We are live now today for the third annual International Conference on Comparative Law. Thank you so much for that wonderful teaser. Ladies and gentlemen, the Constitution gives wide-ranging powers and jurisdiction to do complete justice between the parties to bring to life the motto of the Indian Supreme Court, which says, Yato dharmas tato jaya, which means wherever there is dharma or the righteousness, there is victory. Good morning, ladies and gentlemen. Welcome to Amity University, a world-class university with 11 universities, 28 preschools and schools, and 16 global campuses. We are a research and innovation driven university committed to the cause of education, following the ideals, principles, and values laid down by none other than our Honorable Founder President, Dr. Ashok K. Chauhan sir, and led by the dynamic and visionary leadership of our Honorable Chancellor, Dr. Atul Chauhan sir. I remember Mahatma Gandhi, who said, I shall conquer untruth by truth, and in resisting untruth, I shall put up with all the sufferings. So, keeping the great words of the great Mahatma Gandhi, welcome everybody to the third annual International Conference on Comparative Law. Let us begin this wonderful day wherein a 2 days international conference of comparative law hosted by Amity Law School Noida, Amity University Uttar Pradesh in collaboration with School of Business and Law, Edith Cowan University Western Australia, we foster to nurture the entire globe for the cause of global justice. Let us begin this beautiful day with the invocation and lighting of the lamp. The lighting of the lamp signifies the acknowledgement and the blessings. We begin this ceremony with the lighting of the lamp accompanied by an invocation dedicated to this light in our lives. May I now request all the guests and all the attendees to join us in the virtual lighting the ceremonial lamp before starting today's proceedings. I would request my colleague Mr. Rupendra Singh, the co-convener of this conference, to play the lighting of the lamp video.
ॐ भूर्भुवस्सुवः तत्सवितुर्वरेण्यं भर्गो देवस्य धीमहि धियो यो नः प्रचोदयात् धियो यो नः प्रचोदयात् हे शारदे मा हे
great Lord, take us to the path of righteousness, enlighten us, and guide us towards immortality. Ladies and gentlemen, at Amity University, modernity blends with tradition. And to keep this tradition alive, we would now warmly welcome our guests for today, the Tulsi Saplings virtually. I would request the co-convener, Mr. Rupendra Singh, to share the presentation of the Tulsi Saplings video. This also showcases
From our
at Amity University.
As a token of warmth and gratitude from the Amity family, the Tulsi sapling is being presented to Honorable Mrs. Justice Gyan Sudha Mishra from our founder president Dr. Ashok K. Chauhan sir. As a token of warmth and gratitude from the Amity family, the Tulsi sapling is being presented to Honorable Miss Nazat Abu Chakra from Dr. Joshua N. Aston and Professor Dr. Shifali Raizada. As a token of warmth and gratitude from the Amity family, the Tulsi sapling is being presented to Dr. Abdullah Rashid Ahmad from our Honorable Chancellor Dr. Atul Chauhan and our Vice Chancellor Professor Dr. Balvinder Shukla. As a token of warmth and gratitude from the Amity family, the Tulsi sapling is being presented to Honorable Mr. Justice P.K. Srivastava from our Vice Chancellor Professor Dr. Balvinder Shukla and our Chairman Sir Professor Dr. D.K. Bandhopadhyay. As a token of warmth and gratitude from the Amity family, the Tulsi sapling is being presented to our Honorable Chancellor Dr. Atul Chauhan from our Vice Chancellor Professor Dr. Balvinder Shukla and our Chairman Sir Professor Dr. D.K. Bandhopadhyay. As a token of warmth and gratitude from the Amity family, the Tulsi sapling is being presented to our founder president Sir Dr. Ashok K. Chauhan by our Vice Chancellor Professor Dr. Balvinder Shukla ma'am, our Chairman Professor Dr. D.K. Bandhopadhyay sir, and our Additional Director and Joint Head Professor Dr. Aditya Tomar sir. As a token of warmth and gratitude from the Amity family, the Tulsi sapling is being presented to Professor Dr. S. Shantha Kumar by Dr. Joshua N. Aston and Professor Dr. Aditya Tomar. As a token of warmth and gratitude from the Amity family, the Tulsi sapling is being presented to Professor Dr. G.S. Bajpayee by our Chairman Sir, Professor Dr. D.K. Bandhopadhyay and Additional Director and Joint Head, Professor Dr. Shifali Raizada ma'am. As a token of warmth and gratitude from the Amity family, the Tulsi sapling is being presented to Dr. N.K. Sinha by our Chairman Sir, Professor Dr. D.K. Bandhopadhyay and Dr. Joshua N. Aston sir.
Thank you, ladies and gentlemen, for gracing the occasion. And the host of Amity Law School Noida, Additional Director Dr. Aditya Tomar sir, Chairman sir, for doing the honors. Thank you so much. Ladies and gentlemen, Mahatma Gandhi once said that truth will never damage a cause that is just. And today we have amongst us none other than Professor Dr. Aditya Tomar sir, who is the conference chairperson and additional director, joint head of the institution of Amity Law School Noida, one person who's been the torchbearer of this international conference, one person who has touched our hearts very tenderly by his hard work and determination, one person who we look up to for everything that we do in our academic endeavors at Amity Law School, Noida. I would now request your respected Professor Dr. Aditya Tomar sir to present the welcome address. Over to you, sir.
Thank you, Dr. Sumitra Singh, for being so generous to introduce. Good morning, everyone. I welcome one and all to the third International Conference on Comparative Law, hosted by Amity Law School, Noida, in collaboration with the School of Business and Law, Edith Cowan University, Western Australia. On behalf of the brimming spirit and zeal of organizing committee, I warmly welcome to our distinguished guests for the day. First of all, I would like to take the privilege and honor to welcome our eminent guests for today, Honorable Madam Justice Gyan Sudha Mishra, Madam, former Judge, Supreme Court of India, who is an epitome of great legal acumen, and metal that envisages effective delivery of justice and source of inspiration for all of us. I welcome you, ma'am. Honorable, now I extend my warm welcome to Honorable Miss Nazat Abu Chakra, Investigative Judge, Military Court, Beirut, Lebanon, who heartily agreed to present her address today. Thank you very much, ma'am, and most welcome.
Thank you.
I extend my hearty welcome to Dr. Abdullah Rashid Ahmad, Minister of State for Education, Republic of Maldives, who took out time despite his busy schedule to address all the delegates to the conference. Many thank you, sir. I welcome to you. I extend my warm welcome to Honorable Mr. Justice P.K. Srivastava Ji, Chairperson, Law Commission of Uttar Pradesh, who has been our guiding light and source of inspiration always. Thank you, Honorable Sir, for your gracious presence. My most humble welcome to our dear friend, Dr. Joshua Aniston, Associate Professor and Associate Dean of Law, Adit Kovin University, Western Australia, and Conference Chairperson, who has been by our side in every academic endeavor that we do. Thank you, Dr. Joshua, and most welcome to you. In the spirit of my most humble gratitude, I warmly welcome to Professor Dr. N.K. Sinha, Vice Chancellor, Himalayan Garhwal University. Thank you, sir, for sparing your valuable time.
Yes, sir. Yes, sir.
I extend my warm welcome to Professor Dr. G.S. Vajpayee, Vice Chancellor, Rajiv Gandhi National University of Law, Patiala, just to be our academic partner in this academic endeavor and be esteemed guest. I extend my warm welcome to S. Santa Kumar, Director, Gujarat NLU, Professor Dr. Nishtha Jaswal, Vice Chancellor, NLU, Himachal Pradesh, Professor Dr. S. K. Bhatnagar, Vice Chancellor, RML, NLU. We welcome all of you, sir, just to be the academic partner and gracing the occasion. My hearty thanks to our Honorable Chairman, Professor Dr. D.K. Bandyopadhyay, who has been a great leader of higher education and with whose motivation MIT Law School Noida is growing each day on a global canvas. I'm deeply honored and humbled by the trust endowed upon us by the great leader of higher education of our times, our Honorable Vice Chancellor, Madam Professor Dr. Balwinder Shukla, who has always motivated us to do something bigger in an innovative way every time. Thank you, ma'am. Thank you very much. We are greatly thankful to our Honorable Chancellor, Dr. Atul Chauhan, sir, who believes that together we can change the world. And at MIT Law School Noida, the cause of changing world is based on dispensing justice by making all the stakeholders in legal fraternity work in tandem with the spirit. Thank you, sir. Thank you very much. My most heartfelt thanks to our Honorable Founder President, sir, Dr. Ashok K. Chauhan, with whose blessings, love, and support we continue to make all the difference in the world while instilling in us the value of hard work, inspiration, social outreach, so we can create a just society for the present and future generations. Laws are always evolved and developed in many ways, comparing the law of different nations and even cultures provided to unique way of develop law in a better manner. Comparative law is one such method which describe the comparisons between the different legal systems. There are two types of comparisons. It may be a micro comparison and the macro comparisons. Comparative law has managed to create its own importance spaces within 2 decades. There are jurisdictional approaches which recognize the comparative law methods. Comparative law plays a significant role for not only international relation, but to understand a deeper meaning of legal systems as well. Comparative law helps in evaluating a better law. The comparison of different countries help in analyzing the pros and cons of the legal mechanism and reaching a middle ground for the smooth and functioning of the better law. There are issues of liberty and discrimination which are not limited to one space or region, and the application of such principles in other legal systems provide for a new way of thinking and applying such laws in one's own country. These principles may not be binding in the court of law, but they are used to compare and provide for a legal picture of the policies to be adopted. By this vision, Edith Cowan University and we, the MIT University, organized this conference. There are different themes in which more than 160 participants are presenting their papers in different technical sessions. So further, more deliberations would be done during 2 days grand conference. Once again, on behalf of the entire organizing committee, I wish all the attending and presenting in the conference a huge success. All the delegates to the conference, faculty members and students, and thanks to all in attendance at the inaugural ceremony. Thank you very much. Thank you all. Thank you.
Thank you so much, Professor Dr. Aditya Tomar, sir. Your words always inspires us. Thank you so much. Ladies and gentlemen, I remember Donatus who once said that justice is the constant and perpetual will to allot to every man his due. Having said that, we are joined by our very dear guest of honor, Dr. Abdullah Rashid Ahmed, sir, Minister of State for Education, Republic of Maldives. Good morning, sir. Can you see me, sir?
Yes, I can see you.
Yeah. Thank you so much, sir, for gracing the occasion. And keeping in the flow of this inaugural session, I would now request the convener of this conference, Dr. Jane Iyer Matthew, who's assistant professor and the conference convener, to present her address and to introduce to all of us this international conference and tell us about the different dimensions on which this conference is based at. Over to you, respected Dr. Jane Iyer Matthew, ma'am.
Thank you, Dr. Sumitra. I would like to welcome you all to the third International Conference on Comparative Law. This journey started off into 2019, where we first hosted the International Conference, and today we stand at its third edition. Amity Law School, Noida, Amity University, Uttar Pradesh, in collaboration with School of Business and Law, Edith Cowan University, Western Australia, is hosting this two-day conference. The main theme of our conference is comparative law. Comparative law caters to the study of legal systems of different countries in comparison to each other. With the emergence of globalization, the area of comparative law is garnering more and more significance in matters of business, crimes, family, media, IPR, and technology laws, and many more. A systematic application of the various branches of law helps in understanding the nuances and the emerging issues in the different countries and in adopting the best practices after processing and analyzing these laws. The comparative law jurisdiction is immensely being influenced by the courts across the globe, with new practices emerging in the field. TROIC Compare focuses on interconnectedness of people, businesses, and governments with greater usage of international and comparative law study. Comparative law, therefore, though as old as law itself, has greater significance for the growth of contemporary legal societies. The present conference has incorporated the sub-themes like comparative constitutional law, comparative criminal law, comparative media, IPR, and technological laws, comparative business law, and comparative family law. This goes on to show that comparative law has ventured beyond the traditional notions of comparative constitutional law. We are pleased to have academic collaborations with us for this conference with Council of Australian Law Deans and ILSA. Along with that, we do have academic partnerships with Rajiv Gandhi National University of Law, Patiala, Himachal Pradesh National Law University, Shimla, Ram Manohar Lohia National Law University, Lucknow, Gujarat National Law University, Gandhinagar, and Himalayan Gharwal University, Pauri. We are also honored to have the presence of eminent jurists and legal luminaries from across the globe who will be sharing their insightful thoughts on comparative law. The conference will have 4 keynote sessions, which is slated with 2 to happen today and the rest 2 for tomorrow. Some of the eminent speakers are Professor Dr. S. Shantakumar from GNLU, Professor Dr. G.S. Bajpai from RGNUL, Professor Dr. N.K. Sinha from Himalayan Garhwal University, Professor Dr. Irene Kalboli from Texas A&M University School of Law, USA. We've got industry partners also, Mr. Vikrant Rana from SS Rana and Company, Professor Dr. Mark Graber from University of Maryland, Carey School of Law, USA, Professor Dr. Richard Albert from the University of Nexus, Professor Dr. Manoj Kumar Sinha, Director, Indian Law Institute, Professor Risham Garg from NLU Delhi, Dr. Shamala from NLU Ranchi. We also have Mr. Ranveer Kumar Singh from Singapore, Professor Rosalind Dixon from Australia too. Along with these keynote sessions, we also have received more than 160 abstracts, and after reviewing them, around 80 were accepted, which will be presented in the technical session to be held tomorrow in 6 parallel sessions. Taking forward the mandate of National Education Policy 2020 for strengthening and having better placement and internship, we are also having academic collaborations which will take place with a signing of MOUs with 3 industry partners, namely Trans India Law Associates, SS Rana and Company, and Indian National Bar Association. We hope to have a fruitful session, which will be insightful and thought-provoking, which will help in building the budding young legal minds. Thank you.
Thank you so much, Dr. Jain, that you've given us a wonderful insight into the conference. And in the times of COVID-19 pandemic, all of us have realized that there is but one law for all, and that is the law which governs all the laws, and that is the law of our own creator. The law of humanity, justice, equity, the law of nature and of the nations. I'm sure this International Conference on Comparative Law will shed so many reflections on different aspects of the topic. Having said so, ladies and gentlemen, it's a proud privilege to have with us none other than our chairman of Amity Law School, Noida, Professor Dr. D.K. Bandyopadhyay, sir. Okay, sorry for that glitch. We have with us our chairman, Professor Dr. D.K. Bandyopadhyay, sir. Sir is the chairman of Amity Law School and also the chief advisor to our founder president, Dr. Ashok K. Chauhan, sir. A seasoned professor, that chairman, sir, is being an eminent scholar and educational leader, a prolific writer, and an impressive and an impactful speaker, having awarded with so many national awards. I would now request our very dear and respected chairman, Professor Dr. D.K. Bandyopadhyay, sir, to present your address. Over to you, sir.
Thank you, Sumitra. Thank you for the introductions. Now, I feel very privileged and honored to be present in this conference. This conference actually is the 3rd time that we are conducting at our Amity Law School, Noida. And this is all due to the fact that Dr. Tomar, our joint HY, took the initiative in conducting this type of academic discourses and academic deliberations. And then it is consecutively we have been running it. This is the 3rd time we have been running it. We like to make a dent in this field of comparative law. And as mentioned already, we are happy to mention that we have about 160 papers are going to be presented in this conference. Now they say that any conferences are not known by the people who will be coming over here, who will be presenting their thought processes in the theme of these papers. So I could see that who in legal fraternity from India and from abroad, they are really consented to be present during this inauguration or also during the course of these deliberations. Now, I welcome all of you with a very, very happy good morning in India, but I do not know Lebanon. It may be a little bit different. Maldives it may be a little bit different, but certainly, good morning to all of you. And I welcome, as a chairman of the Amity Law School, on behalf of the entire Amity universe. Amity universe has been created by none other than a single man, that is our founder president, Dr. Ashok K. Chauhan. And he says that when there is a problem, then there is a challenge. And when there is a challenge, there is innovations. Now we could see that his words has resulted to many of our achievements in the field of research and innovations in different arena of subjects, whether it is science and technology, engineering, social sciences, and law. And we are progressively, going up and up and up. And he does not believe that we should be incrementally just going up, but we should be spirally going up. And this is the thing that has also given a message that do the different things, but do it differently. And this seminar also, we are trying to do it in a different way. And the topic itself is a different topic and different way. And although there are a couple of papers are being taught in the law schools, some of the law schools, but not a full paper. But this demand of today about this has come up like anything. Now, having said so, once again, I must mention the names, those who will be present over here. And if I do not mention their name, I will be failing in my duties. So at the outset, Your Lordship, Gyan Sudhaji, welcome to this conference. Mr. Jasalji, I think he's the director of Himachal Pradesh National Law University or Vice Chancellor National Law University. I think she got engaged too, but some of the time we shall catch up with her and she'll be present over here. Now, Honorable Ms. Najat Abu, who is joining us from Lebanon, thank you very much and welcome you once again on behalf of the, as I have told you, on behalf of the Amity Universe. And this Amity Universe, I must mention over here that, is also getting now spearheaded with lots of dynamism and lots of, blessings, I would say, by the Honorable Chancellor, Dr. Atul Chauhan, and who takes everything in such a way that he says, whatever we do it must reach to the students. So the Amity University or Amity Universe as such is a student-centric universe. And the student centricity comes through different ways, through classroom, through activities, through deliberation, through moot courting, through ADRs competitions, through debate competition. There is one of the way of learning we like to create among the mindset of the student, how you want to be creative, how you want to actually make the, develop your analytic power, dissecting power, and then develop the, new knowledge and new things. So this conference is essentially aiming at that with the blessings of our Honorable Founder President and with the blessings of our Chancellor. Now, this is again further spearheaded by our Honorable Vice Chancellor, and who feels that we must do something which others are not doing. And I'm very happy to say that, and we are the first law school in the country where NEP 2020 is talking about major minor. We already introduced this major minor log back in 2019. And we are giving in our integrated program all the major minor courses. So that means the first degree they are getting honors, and also second degree they are getting honors with specializations in particular area. Now, this is something new that we have incorporated, and we have also incorporated the new concept known as professional skill development activities. The PSDA, every students, depending upon the course, they need to see that the applicability in the society or applicability in the court of law or applicability in different NGOs, so that they come up with a report that the course which has been taught to them, how it's being applied over there, so that they know that It is not the theoretical only, it has an immense amount of applications and or new way of thinking of the applications. We also give them some sort of a research project, and we ask them that look at the literature, look at the things on a particular course, international law. When we teach international law, we give a PhD project like that, what has been happening in a particular area, and then come up with this concept of the international law, the things that has been implemented or things that has been happening. Or say, for example, when we teach the alternative dispute resolutions and the different types of PhD activity that we conduct them. So this is some of the new thing that we have been doing it. And this conference itself is one of the newness that we have brought that in comparative law, we have brought 5 themes over here, as I already mentioned over here. The 5 themes are very, very important themes. And these themes has been well thought over themes. And we can say that the first theme starts with the first session starts with the one of the theme is the family law that we could see over here. And the second thing that we can see that it is being handled effectively. The second thing is the international law, and the third thing, of course, constitutional law. So like that, the new way, new themes have been created while inviting the papers in the conference. Now, this way, I feel that it will enrich the field in the field of comparative law by deliberating and discoursing on the different facets. I must, once again request, once again welcome Honorable Justice P.K. Srivastava, Mr. Abdullah Rashid Ahmadi, Minister of State for Education, Republic of Maldives. I also welcome our dear friend and who is also our honorary associate professor, Joshua N. Aston, and he also took the initiative as an honorary professor that how to actually collaborate between Amity Law School, Noida, and also Edith Cohen University, Australia. And he also convinced his authority that this type of collaborations will bring 2 greatest law schools together. And this is again another initiative has been taken by our PSPR headed by him. So I must thank him and also welcome him virtually in this in this conference. Now I also thank to the keynote speakers of today's inauguration program, N.K. Sinha ji, Professor N.K. Sinha, Professor Bajpai ji, Professor Sant Kumar ji, and actually they will be giving us the keynote address, and certainly they will enrich this inauguration program because they say that well begin is half done. So if these people are going to speak over there and in the presence of such illuminaries, it is going to create a different types of vibration in this conference. Although it is doing it virtually, but I believe that in the next time we'll be able to do it physically in the campus, because our Amity campus of Uttar Pradesh, AUP we call it, is a very inviting campus. Greenery is around, ambience is around. You feel that there is everywhere you go there is the positivity and the atmosphere of learning and atmosphere of contribution for the benefit of the society. Because our honorable founder president all the time says, whatever we do it has to reach to the mankind. And he says that our generation or the generation which will be produced by Amity Group, these generations are going to change the world, and we will be collectively and we will be togetherly, we will be changing the world. And every student of Amity carries this message that they are to do something, they are to contribute something, so that they makes a difference in the society, they makes a difference in the country. And this in the concept of superpower things also in our mind, that we must make every nation, or particularly India, first, how to make a superpower nation with a balancing power. So in this region, Asia region, so this can only be possible with the help of our future citizen, that means our student. And we give this message to the student, contribute, and then you see that the difference that you can make to the society. Now this conference also one of the steps towards that direction. So with these words, once again, I must thank Dr. Aditya Tomar, who spearheaded it under the assistance of our another HY, Dr. Shefali Raizada, and then, of course, our organizing committee led by Rupinder, led by Dr. Jain, Dr. Jain, led by Sakshi Parasar. They have done a great job with the students volunteer. Dear students, we are really, really, feel proud of you because you are able to create such an platform where people from all walk of life, they are coming over here. Because lastly, I will say that in the words of the Vivekananda, that education is a matter of perfection. How do we bring the perfection in the mind of every student? And then I will also say, that you are going to make the difference in the world. And please listen these deliberations very carefully. Try to see how these speakers are going to deliberate it, or how the presenters are going to present their papers, and it will be great learning for all of you. So thank you very much. Thank you all.
Thank you so much, Chairman, sir, Professor Dr. D.K. Bandyopadhyay, sir. Sir, it is said that there is no genius where there is no simplicity. And in very beautiful and simple words, you have shown us how geniuses can be more creative. Thank you so much, sir, for your beautiful address. Having said so, ladies and gentlemen, I also remember Lydia Maria Child, who once said that law is not the law if it violates the principles of eternal justice. Ladies and gentlemen, it's a proud privilege to have with us Honorable Ms. Najat Abu Shakra, who's investigative judge at Military Court Beirut, Lebanon. Madam is a distinguished guest of honor. Let me tell you a brief about Madam Judge. Ma'am is an investigative judge at the Military Court in Beirut since October 2010. She has been in charge of several critical case files, and some are related to terrorism, and some are related to the finance of terrorism, and some are related to the contact with the enemy, war crimes, and crimes against humanity, like the Amer Al-Fakri case file, in addition to the murder cases, drug trafficking, human trafficking, and minors involved in terrorism acts. In line with this, ma'am has been occupied the post of penal unit judge at LA Court from June 2014 to October 2017, and the post of civil unit judge at LA Court, competent of rental and real estate cases from March 2009 to June 2014. She has been the member in the first instant chamber in the south of Lebanon with full jurisdiction from October 2004 to March 2009. Madam joined the Judicial Authority as an apprentice judge and as a permanent member of the courthouse in August 2001 and became an accredited judge in September 2004. Ladies and gentlemen, please join me in welcoming our guest of honor, Honorable Ms. Najat Abu Shakra, Investigative Judge, Military Court, Beirut, Lebanon, with a round of applause. Welcome to Amityville. Yes, ma'am, you're on mute, ma'am.
Yeah, that's true. I was muted. So I can see that someone has raised his hand. I don't know if you can see this.
Yeah, it must be by mistake.
Okay. So would you like me to present my presentation now?
Yes, ma'am.
Would I share my screen?
Yes, ma'am.
Okay. So I will follow the steps that I have been learned.
Yes, ma'am, we can see the screen now.
You can see my screen? Okay, thank you so much. So good morning to you all. I'm really very honored to be with you today. It's a privilege and an honor. My topic will be about introducing the Lebanese judiciary system, which is divided into many branches, one of which is the military judiciary, where I do my work since 12 years now. And I will be giving you a general idea about each branch and a specific and briefly explanation about the military judiciary. The branches of the Lebanese judiciary are the judicial judiciary, the administrative judiciary, the financial judiciary, the religious judiciary, and the military judiciary. The judicial judiciary includes the civil judiciary and the criminal judiciary, while the administrative judiciary has jurisdiction over the disputes between the state and the individuals. The financial judiciary, its mission requires guarding the public funds and controlling their use. The religious judiciary has jurisdiction over personal status cases such as marriage, divorce, adoption, nursery, and other family issues. And here worth mentioning that in Lebanon, we have 18 different sects divided basically amongst Christian and Muslims, where each sect has its own religious court. And now it's the turn to talk about the military judiciary, and I will be exposing it according to the following sequence: the structure, the location of each partition, the composition of each partition, the spatial authority, the qualitative authority, the personal authority, the procedure rules, and the methods of prosecution. First, the structure of the military judiciary. You can find in the military judiciary the single military judges, the permanent military court, the military court of cassation, the military public prosecution bureau, and the military investigation bureau. About the location of each partition, the single military judges are located in each governorate, and she or he considers criminal cases related to infractions or misdemeanors, the penalty of which is less than 1 year of imprisonment. And this judge could be a judicial judge or an officer with the rank of first lieutenant and above with a BA degree in law. While the other partitions of the military judiciary are located in Beirut, the capital of Lebanon. And here it is worth mentioning that the permanent military court has two bodies. The first one looks into misdemeanors cases whose punishments exceeds 1 year of imprisonment, and the second looks into felony cases. The composition of each partition in the military judiciary. First, the military court of cassation. In felony cases, this court is composed of a judicial judge as president of the court and the membership of 4 officers of the rank of lieutenant colonel and above. In misdemeanor cases, the court is composed of a judicial judge as president of court and 2 officers of the rank of lieutenant colonel and above. The permanent military court, in felony cases, it is headed by an officer of the rank of lieutenant colonel and above, and actually or currently, the head of the court is a general, and 4 members, one of whom is a judicial judge and 3 officers. In misdemeanor cases, it is composed of a president who is an officer with the rank of lieutenant colonel and above, and currently he is a general, and 2 members, one of whom is a judicial judge. The Military Public Prosecution Bureau. This bureau consists of the general prosecutor of the military court, who is called the government commissioner, and who should always be a judicial judge, and his assistants, who could be officers or judicial judges. The government commissioner and his assistants are subject to the authority of the public prosecutor of cassation, called the general prosecutor of the republic, who is the highest authority in criminal cases in Lebanon. The Military Investigation Bureau, where I work, this bureau consists of the first military investigative judge and the military investigative judges. The first military investigative judge is the administrative head of this department, meaning that he distributes the work to the military investigative judges, so each investigative judge exercises his work independently. And the first military investigative judge keeps to himself critical cases, yet he has the authority to distribute them among the other military investigative judges. These judges could be officers or judicial judges, but it is worth mentioning here that all the judges in the military public prosecution and the military investigative bureau have always been judicial judges since we have the military court in Lebanon, since 1943. The spatial authority of the military judiciary. The military single judge has authority within the lands of the governorate in which he is appointed, while the permanent military court has authority over all the Lebanese territories and the territories occupied by the Lebanese army, if there are any lands occupied. We don't occupy any country, any land. The qualitative authority of the military judiciary. First, the military crimes, treason and espionage committed by a civilian or a military person, terrorism and finance of terrorism, crimes of recruiting Lebanese to fight for a foreign country, and the crime of incitement of foreign soldiers to disobey or flee if committed by a Lebanese inside or outside Lebanon, as well as the act of incitement that takes place in Lebanon if committed by a foreigner, crimes listed in the firearms law, crimes committed in military barracks and military institutions, crimes committed in prisons, crimes committed against the army members, but as for the crimes that fall upon conscripts, the military judiciary does not have the authority to consider these crimes unless the crime is related to their job. Crimes committed against a member of the internal security forces, general security, or state security, such as harsh treatment or resistance to security forces men. Crimes committed against civilian employees of the army, internal security forces, general security, state security, under the condition that they are related to their job. Every crime that affects the interest of the army and the security forces, such as attacks on military barracks or on state equipment. Crimes affecting foreign armies working in Lebanon, unless there is a contrary agreement between Lebanon and the foreign country to which this army is affiliated. The personal authority of military judiciary. First, the army personnel, but as for conscript, the military judiciary does not have jurisdiction over the crimes they commit unless they are related to their job. The members of the general security, internal security forces, and state security are prosecuted in the military court under the condition that the crime is related to their job. The prisoners, the men of foreign armies, and the civil servants affiliated with them, unless there is a conflicting agreement between Lebanon and the foreign country to which this army is related. Civil servants of the army, general security, internal security forces, and state security are prosecuted in the military court under the condition that the crime is related to their job. Every contributor, partner, instigator, or meddler in a crime that the military judiciary has jurisdiction to consider and prosecute. Every civilian who commits a crime that falls within the qualitative jurisdiction of the military judiciary. Now, the procedural rules applied before the military judiciary. These rules are the same applied before the judicial judiciary that is those listed in the penal procedures law. The defendant before the military judiciary enjoys all the rights listed in this law, such as the right of defense, the right to be represented by a lawyer, and the right to file formal pleas. However, there are some exceptions listed in the military judiciary law, but I will just mention the most important one. That is, the jurisdiction of the military judiciary is limited to the public right claim without the personal right. This means that there is no claim for a personal right before the military judiciary. But this does not prevent any victim of the crime from submitting a complaint to the government commissioner, who has the right to start the prosecution on its basis. This victim is heard as a witness without taking an oath. Anyhow, the victim can file a personal right lawsuit before the judicial judiciary, which has to stop considering the case until the military court issues the sentence. The methods of prosecution before the military court, the same methods are applied that is before the judicial judiciary. So the prosecution begins at the level of the Public Prosecution Bureau, then it moves to the Investigative Judges Bureau if it is a serious misdemeanor or a felony, or it is referred directly to the court, that is either to the single military judge or to the permanent military court according to the type of the alleged crime. Honorable attendants, I have tried to just talk in the 10 minutes that was written in the schedule of this conference. Many things more are to talk about the military judiciary, but I just limited myself into these 10 minutes. I hope that I was clear. I hope that I have reached or met your expectations. I'm really so honored to be with you. Thank you so much for listening to me, and thanks a million.
Thank you so much, Honorable Judge Ms. Najat Abu. Thank you so much, ma'am. Let's have a round of applause for Madam Judge. Thank you so much, ma'am.
Thank you so much.
Ma'am, I think we will organize a separate webinar exclusively for our students for such a beautiful address that you have presented. Beautiful, ma'am. Many congratulations for the presentation.
Thank you so much, Deep. Thank you.
Okay, ma'am, we are so humbled, ma'am. Students, definitely we are going to invite ma'am once again for another scintillating webinar. So going ahead with the flow now. Ladies and gentlemen, it's a proud privilege to have with us our guest of honor, Dr. Abdullah Rashid Ahmed, who is Minister of State for Education in the Republic of Maldives. Let me give you a brief glimpse about Honorable Dr. Abdullah Rashid. Sir is presently the Minister of State for Education at Maldives. As an overall in charge of the National Institute of Education, there is so much of educational work to be done, and that too with a mandate of global justice and imparting education that would make every citizen of the country responsible for his duties towards the world. Sir is also responsible to enhance the effectiveness of the curriculum implementation. He ensures that the teachers receive all the required training and other teaching and learning materials at the National Institute of Education. Before holding this position, Sir was also the vice rector at Avid College, and before that, Sir was also the director of international affairs at MI College of Halmale campus. And before that, Sir was also the principal in Atoll Education Center and also principal in various other educational institutions. Ladies and gentlemen, please join me in welcoming our guest of honor, Dr. Abdullah Rashid Ahmed, Minister of State for Education in the Republic of Maldives, with a round of applause. Welcome to Amity, sir.
Thank you, Dr. Sumitra. Excellencies, speakers, judges, and all the participants of this wonderful conference. Assalamu alaikum and very good morning or good afternoon or good evening, whichever suits to you. It's really a great pleasure to be in part of this conference. Thank you, MIT University, for inviting me and give this opportunity. I'm sure this is a very good opportunity, especially those who are in the industry law profession. They will get an opportunity. What are the difference and similarities compared to the law in different countries? We are living in a globalized world, and world is like a small village. So things are happening and interacting with other countries. In years ago, we lived in our own city or own town or own country. So it is enough to know the things in our local area. But now it is totally different. People do business from one country to another, even multiple countries. Multinational companies, they have operation in different countries, and people travel and movement is very high. Therefore, or those who are working in the law profession, it is really good to know what are the difference and similarities in terms of law in different countries, so they can be better helpful to their clients. And another thing is creating knowledge is very important, because we are living in a knowledge economy. In years back, it was a production-based economy, but now the world has, especially the developed countries, they have transformed their economy from production-based to knowledge-based. In a knowledge-based economy, the prime resource is the knowledge. Therefore, creating knowledge in any field is very important, whether it is law or medicine or education, engineering, and science. I am sure through this conference, all the people working in this field, their knowledge will be enriched, or their knowledge will be refreshed. Therefore, this is a wonderful opportunity for those who are working in the field of law, and also those who are studying law as a profession. A research has shown that what developed countries mainly do and developing countries mainly do. It has been found that developed countries, they invest their time on creativity and innovation in terms of doing research and coming up with new ideas and always improving the change. So that's the status of developed countries and what they are engaged. However, in developing countries, it has been found that people are doing routine things, same thing repeatedly over decades. So that's one reason there is a restriction. And also it has been found that in developing countries, routine things are done by the machine. So either by machine or by using the labor, routine things are going on. Therefore, creating knowledge is very important. So before concluding, once again, I would like to take this opportunity to thank Amity University for inviting me and organizing this important conference and bringing speakers, judges, and highly professional and specialist people from across the globe. I'm sure the product of this conference will be very fruitful. I wish this conference will be a great success. I'm really pleased to hear when the professor explained how MET University looked like, the green ambience and everything. Unfortunately, now we are virtually connected, and I also hope one day I will be able to see the beauty of the MET University. I wish you all a very good day. Thank you.
Thank you so much, our respected Dr. Abdullah Rashid Ahmed, sir, our guest of honor. Thank you so much, sir, for gracing us.
Thank you very much, Abdullah ji. I forgot to tell one thing, that our founder president has created in India about 11 universities of similar type, similar standard, and similar type of philosophy and similar type of vision. Only thing that regional variability has been taken into consideration while shaping up their educational endeavors. And same way, we have also gone to different countries. We have a university in North Island, US. We have a university in Dubai. We have a university in Tashkent. Now we have got 15 campuses all across the globe. And these are all created by our honorable founder president and his equally able sons, our chancellor, Dr. Atul Kechwan and Dr. Asim Kechwan. Now you'll be finding that the philosophy, the vision is such a beautiful vision, such a progressive vision. And then, when others could not think anything, that our honorable founder president thinks that. And that is the beauty of the MET Education Group. While India was not able to think NAB 2020, MET University implemented much ahead of it. For example, their outcome-based education, we implemented in 2013. The value-based education, our honorable founder president implemented in 2013-14. The graduate attributes, it was all implemented as a part of our outcome-based education, and this is something very forward-looking. So I invite you, whenever you will be in India, I invite you. Please do visit us. We'll have much more interactions with you. Thank you, sir. Thank you very much.
Okay, thank you, sir. Excellent work, and it is highly appreciated.
Also, Dr. Abdullah Rashid Ahmed, sir, it is said at Amity that once an Amitian is always an Amitian, sir. So welcome to the bigger Amity family today.
Okay, thank you.
Thank you, sir. Ladies and gentlemen, there is this very famous quotation by Gurudev Rabindranath Tagore, who says that the world speaks to me in colors and my soul answers in music. So where is the law? We will discuss more about that in further deliberations in the conference. Having said so, ladies and gentlemen, we have with us our guest of honor, Honorable Mr. Justice P.K. Srivastava, sir. Sir graduated in law in the year 1980 and post-graduated in law in the year 1986. Sir was appointed in Provincial Civil Services Judicial in 1986 and promoted in Higher Judicial Service in 2002. Sir was promoted as District and Sessions Judge in the year 2015 and appointed as Additional Judge in November 22, 2018. And Sir took oath as Permanent Judge on November 20, 2020. Ladies and gentlemen, Honorable Mr. Justice P.K. Srivastava, sir, is presently the chairperson of Law Commission of Uttar Pradesh. Please join me in welcoming our guest of honor, Honorable Mr. Justice P.K. Srivastava, sir. Over to you, Honorable Sir, for your address. Welcome to Amity. Chairman, sir, we also acknowledge the gracious presence of Honorable Ms. Justice Gyan Sudha Mishra, ma'am, former Judge, Supreme Court of India.
Okay.
Welcome to Amity.
Your Lordship, so we are really thankful and grateful in welcoming you. We are eagerly looking forward to hear you. Any issue, Sumitra?
No, sir. We are awaiting to listen to Honorable Lordship, Mr. Justice Srivastava, sir. Sir is unmuted. Yeah. Your Lordship, can you hear me, sir? I think I'll request my colleague Rupendra, sir, to speak to your Lordship. Rupendra, sir, can you speak to sir?
But I did not see him.
Sir, Honorable Lordship is there in the conference, and
but he's muted.
Yes, sir. So he got unmuted, again got muted. So we are just waiting for him. So, ladies and gentlemen, this is the inaugural session of the third International Conference on Comparative Law 2022, hosted by Amity Law School, Noida, in collaboration with School of Business and Law at Coven University, Western Australia. And this is the inaugural session. And we have the privilege.
Sumitra ma'am, Justice Srivastav will be joining. There is some problem with the link.
Right.
I think he's rejoined again. Yes.
Yeah, I think so. Ma'am, sir is there in the conference. Yeah. So awaiting your lordship to listen to your enlightening words. So in the inaugural session today of this international conference on comparative law. Yes, sir. Yes, sir. Yes, lordship, we can hear you. We can see you, sir. So as the world shrinks into the virtual world.
I'm audible?
Yes, sir. Perfectly, sir.
Yes, 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 sir. Please continue.
I'm not that technocrat unless I get assistance from some of the staff. So it is why the disturbance is there. But I am trying. So, क्या हो रहा है? Honorable Mr. Justice Gyan Sudha Mishra, former judge of the Supreme Court of India, respected Dr. Atul Chauhan, Chancellor, Amity University, Professor Dr. Balwinder Sandhu, Vice Chancellor, Amity University, Professor Dr. Bandopadhyay, D.K. Bandopadhyay, Chairman, Amity Law School, Professor Dr. Aditya Tomar, Chairperson and Additional Director, Amity Law School, Honorable luminaries, judges, professors, and delegates participating in the webinar. Firstly, I would like to extend my thanks to the Amity Law School for giving me this opportunity. In fact, I was thinking that there is some deliberation and interaction on the topic of Australian constitutional law and other laws and Indian constitution and other laws. But to my utter surprise, there are so many countries representing in this webinar. So suddenly I will have to shift my address so that to meet the purpose of the workshop. Now, we all know that we have a voluminous written constitution, and because India became independent and enforced the constitution only in the year 1950, therefore it had the opportunity of taking aid and assistance from the experience of various democracies. And considering the fact that so many countries who were having a very brief constitution in which so many things were not defined, they had to face a lot of problems when the constitution started functioning. Many times it created a crisis in the country itself. We can remember the incident of United States, where the Constitution did not provide for the judicial review. And when the Supreme Court of United States interpreted the Constitution to assume the power of judicial review, a constitutional crisis was created in that country. So, being experienced by all these things, the Indian Constitution was framed in such a way that it incorporated everything in the Constitution. And in the process, it was inspired by so many constitutions of the world, United States in particular, and then it was also inspired by the constitutional law of Great Britain and even Australian constitution. Australian constitution existed prior to the Constitution of India and even much before, because the Constitution of Australia came into force in 1900. So it was 50 years elder than the Constitution of India. So naturally, it also inspired our Constitution. Our Constitution is a unique Constitution. It is a rigid federation with flexible federation. It provided for the amendment of the Constitution, but provided a very flexible procedure for amending the Constitution, unlike what was provided in the Australian Constitution. It is why we find that in a short period of 70 years, we have more than 100 constitutional amendments, whereas in more than 120 years of the constitutional experience, Australia has amended the constitution probably 10 times only. So this is the difference between the two countries. But coming to the laws prevailing in our country, I find myself inspired by the address of Madam Dr. Abdullah, Madam Mrs. Najat Abu Chasra, if I'm correctly pronouncing, happens to be the judge of military court. So being inspired by her address, I would also like to explain how our judicial system works in our country at the various levels. We all know that the country has various districts, and at district level, there is district judiciary, and it is further divided into 3 layers. The civil judge at junior division level, the civil judge at senior division level, and the additional district judge, so far as the civil disputes are concerned. We all know that civil disputes relate with the right and status of an individual. And when such a dispute is created, the matter comes to the court of law at the district level. The difference between the civil judge junior division and civil judge senior division has been with regards to the valuation of the suits. If the valuation is higher, then the jurisdiction lies with the civil judge senior division. And if the jurisdiction is in the lower side, and that has been specified by the various laws, then the jurisdiction lies with the civil judge junior division. The district judge has the appellate jurisdiction against the initial judgment passed by civil judge junior division and civil judge senior division. Similar is the situation in the criminal side. In the criminal side, the jurisdiction is divided between judicial magistrate, chief judicial magistrate, and additional session judge and session judge. Here again, when the offenses are a smaller one and the punishment provided for the same is less than 7 years, the matter goes to the judicial magistrate or chief judicial magistrate. The session judge has the appellate jurisdiction, and the session judge is further assisted by so many additional session judges. And they have appellate jurisdiction, they have revisional jurisdiction, and so on and so forth. The session judge has all authority to inflict any kind of punishment, including the death sentence to an offender. But the Criminal Procedure Code provides a restriction that in case death sentence has been inflicted by the session judge, the same should be rectified by the High Court. When it is rectified by the High Court, same can be executed. That one can prefer an appeal before the Supreme Court, and there the judgment may be reversed or affirmed. Only on the judgment being affirmed, the death sentence is executed. The High Court has the jurisdiction in the civil side, and it has also the jurisdiction of the writ. In civil side, the High Court has appellate jurisdiction, and under the Constitution of India, it has writ jurisdiction, and it can issue various kinds of writs, which has been provided under 2 to 6, Article 2 to 6 of the Constitution. The Supreme Court has, of course, different kind of jurisdiction, because any person who is aggrieved can go to the Supreme Court directly for the enforcement of the fundamental rights. We all know that our Constitution expressly provides for fundamental rights and a mechanism for remedying any wrong committed against the fundamental rights. Where there is some deprivation or something is done against the fundamental right, the person can go directly to the Supreme Court, and the Supreme Court can pass a suitable order in order to enforce the fundamental rights. So all these courts exercise their jurisdiction in their specific field, with an exception that the Supreme Court has a residuary jurisdiction in respect of all the matters. There are several tribunals at the district level. There is Motor Vehicle Claim Tribunal. Then there is, of course, family courts who are functioning in all the districts of the state of Uttar Pradesh. They have the jurisdiction on the family matters and family disputes. And all these functionaries, these courts, they work together in order to impart justice to the people of the country and the aggrieved persons. Now, coming to the fact of the Australian side, because this webinar has been organized with the collaboration of the Australian university or some Australian counterpart. So Australia initially, because the Constitution is enforced 50 years prior, the courts in India took aid and assistance of the Australian judgments in order to interpret various laws and the Constitution of the country. Later on, after some times, particularly in certain matters, when the case of Menka Gandhi was decided in 1978, and with that judgment, the Article 21, which provides for personal liberty and life of the person, it was widely interpreted by the courts. And that experience was also taken by the Australian courts in order to bring there the free legal aid and speedy trial, etc. So that way, both the Constitution and both the experiences influence the working of the other country. And it is how the law grows in the real terms. Law is a growing phenomena, and with the experience of other countries also, it develops in a better way. There is nothing static so far as law is concerned. It is always changing in order to meet the changed situation and change circumstances in a particular society. So therefore, at many times, we have to take assistance of the experience in other countries in order to interpret the law in correct direction. That way, this kind of venture is very important, because when the participants interact and discuss in respect of the law in their country, it helps the other also to understand the situation, and it, in fact, it gives a richness so far as the experience of other country is concerned. I really feel that the Amity Law School has done a wonderful work by organizing this kind of workshop in a pandemic period. And I should say that they have very potentially used this period by organizing this kind of workshop where the luminaries and professors are participating, and their views are going to generate certain ideas for the benefit of the legal world. I congratulate the Amity University for organizing this workshop, and I believe that the interactions and discussions in the workshop will further enrich our understanding of constitutional and legal developments in the various countries. It will also strengthen the mutual relationship of the countries which are participating in the workshop. I feel obliged and express my thanks to the Amity University for giving me this opportunity to become part of this great event. I wish for the great success of this virtual workshop. I'm further inclined to learn from whatever discussion which is going to take place in the workshop. I will request to the organizing committee, particularly Professor Aditya Tomarji, that whatever resolution is passed during the workshop, he may apprise us
Yes,
by
sir.
providing those resolutions to us, because it can certainly help the working of this state law commission, and we will explore some benefit in our working also. Thank you, everybody. Wish you all the best. Thank you very much.
Thank you so much, Your Lordship. Let's have a huge round of applause for Honorable Lordship. Thank you so much, sir. So
Thank
we
you
are
very
very
much.
humbled with your presence, and it's a beautiful address, sir.
Thank you very much, sir, for your kind guidance, and we will surely follow, and outcome reports and detailed report would be submitted to your office, sir.
Thank you, sir. Thank you.
Thank you, Honorable Lordship, once again. Thank you so much, sir. Ladies and gentlemen, after Honorable Lordship's address, I remember the very beautiful quote by none other than B.R. Ambedkar, who said that justice is yet another name of liberty, equality, and fraternity. Having said so, ladies and gentlemen, it's our proud privilege to have with us Honorable Ms. Justice Gyan Sudha Mishra, ma'am, former Judge, Supreme Court of India, amongst us today. Honorable Ladyship was elevated as a Judge of the Supreme Court of India on 30th of April 2010. Madam Ladyship passed several landmarks and notable judgments in the Supreme Court of India, including judgments on conflict of interest in the Srinivasan BCCI matter, landmark euthanasia judgment, Aruna Schonborg matter, and the Delhi Upahar fire tragedy dissenting judgment holding the management liable for colossal loss of human lives and directing them to pay heavy compensation to be used for social causes like building the trauma center. Madam Ladyship was enrolled as an advocate in the Bihar State Bar Council in 1972 at a time when the legal profession for women in India was rather uncommon, and the profession was primarily considered to be a male bastion. Prior to her appointment as a judge, Madam Ladyship was actively associated with the activities of the lawyers and the legal profession, and hence was also elected as treasurer, joint secretary, and member executive committee at the Supreme Court Bar Association several times, which is a premier association of the lawyers in the country. Madam Ladyship had in prior also held the position of Judge Patna High Court, Judge Rajasthan High Court, and also as Chief Justice of Jharkhand High Court. Ladies and gentlemen, it's a matter of proud privilege to host ma'am as our chief guest for the session. Please join me in welcoming Honorable Ladyship, Madam Ms. Justice Gyan Sudha Mishra. Over to you, respected madam.
A big hello to everyone and a very good morning to all the distinguished guests from the judiciary, from the academics, the devoted students, the avid listeners, and all other participants. It is indeed a matter of great pleasure and I feel delighted to International Conference on Comparative Law, which has great relevance and value in the modern times. First of all, I would express my compliments to the organizer and all those who thought about a discussion through this workshop on comparative law, because I think it would be a matter of curiosity among the students that they must have heard about substantive law, they must have heard about procedural law. Now, what is this comparative law? Because comparative law traditionally doesn't have that expression coined in any statute, but comparative law, as the name stands, basically emerges from the idea that we can learn from each other. If you go through the history, if you dig the history of the development of law, you would already know that in the Western world, it was Roman law, common law. In the other part of the country, like the eastern side, basically it was the ancient scriptures, it was the customary, it was the usage, which crystallized into the legal precepts which guided us. But in this age of globalization, in this age when we interact, when, as we say that, the world has become a global village, I think the value of having a separate discipline for the study of comparative law is indeed of great importance. And that is how perhaps somewhere in the 19th century, the study of comparative law emerged. An institute was opened in Paris specifically for the study of comparative law. And all countries, besides their substantive, and substantive, of course, are the principles. So basically they overlap with each other, but procedural laws are different. I compliment you for choosing this subject, and I wish this comparative law course should be should really, whenever a legislation is enacted, there should be a dialogue in between the legislators and the law experts regarding the comparative study of the law on which the legislation is coming up. And in that sense, I treat the subject of comparative law rather offbeat. And offbeat, but of dual importance, because we learn from experience. These, of course, what I'm expressing my thoughts are basically, these are, I would say these are abstract thoughts which I'm expressing on comparative law. But I tell you from experience that the study of comparative law really hit me when I had attended a conference on the criminal justice administration system. Then we came across the Malimat Committee report on reforms on the criminal law. Now, all of us know that under the Indian law, there are two theories which the student community may be informed, that here in India, we follow the adversarial system. In the European countries, it is mostly inquisitorial system. The difference between the two is, I'm saying it in the context of criminal law, that adversarial law, it's the accused, it's the prosecution which has to prove that the person is guilty. Whereas in the inquisitorial system, it is the accused also, rather it's the accused which has to prove that that he is innocent. Now, when in the case of rape cases, this found introduction in some way, not truly adopting the inquisitorial system, when the Evidence Act also was amended in India, and if the victim if the victim expresses that she has undergone some kind of atrocity, then her version also would be treated as evidence, not merely as confessional statement, but somewhat taking the thoughts that inquisitorial system also might be introduced. Now, it was really a hitting moment that I'm expressing myself on comparative law, that here is a case rather in criminal matters that we have to make a very serious study of the comparative charts of all the the countries who have a very crisp legal system, where there is a balance between liberty and justice. And in that sense, it was, it's many a time it comes up that why it is in very heinous offenses, the prosecution has to prove and the accused goes scot-free without getting the punishment. It's a very complex subject in that sense, that you have to strike a balance between the two, the adversarial and inquisitorial. But that is in the context of, as I said, that is in the context of criminal law. And in the field of criminal law, this comparative study, the law of comparative, the study of the law from different countries, has a great value, and it should be treated with a lot of devotion and very minute and in-depth study of the systems prevailing all over the world. In that sense, I'm very happy that the subject of, it's a very offbeat subject, because when there are workshops, we generally get, already, which we have already discussed a lot, we keep on repeating the discussion. So comparative law subject needs to be understood with a lot of seriousness, because, and there the research, the students who want to go in for research will have a great, they would be adding great value for the improvement of law. Now in this global world, as I said, one part is criminal law, other is commercial law, and in the form of arbitrations, which is coming up to the assistance of the commercial courts and the corporates. There again, the study of this comparative law is of great value and assistance for the development of law. And I am jumping over just the nucleus of the issue, that as for example, I would say that even when there are awards are passed, why is it that the execution of the awards are taking long time to become effective? And there, I guess, the study of different countries, experience of different countries, because we keep hearing that our justice system, is slow and it takes a lot of time in getting the final verdict. So we have to study that what are the areas where the justice is condensed into a capsule form many a times, and it is delivered for a speedy justice. So for the value of speedy justice, I think the value and assistance and study of comparative law would be of great value for the speedy justice. Because, why I'm saying this criminal law and the commercial law field would require these comparative studies, because when we go to the family law, or when we go, when we study the laws which is based on our ancient scriptures and our customs and usage, we cannot do much in in adopting the ways which other countries or each other's, we cannot come to each other for much assistance. For that matter, constitution also, because those are all the codified, they are statutory in nature. If it is statutory, then we cannot, by amendments, of course, we can do it. We can take the hints from other studies, but where at least the comparison and the speedy justice norms maybe can be adopted if we make a comparative study where all stakeholders are involved. As I said, in commercial disputes, because I'm slightly, obsessed with commercial matters, because I'm into arbitrations these days. Therefore, it is, provoking more to speak on this subject, because those are the areas where the comparison would be of great help, and making, giving justice or speedy justice to the stakeholders would be of, we can, we can bank upon the international experience in getting a speedy justice, at least in those areas. As I said, I've taken only focusing more on the criminal law and the commercial aspect, because those are the experience which we can straight away, learn from each other, inform each other, and also adopt each other. I'm very happy that this conference is a cohesive effort in between the Australian University at Perth. I had a very happy experience when I had gone to Australia and Sydney for an international delegation with the Chief Justice of India. And I had a wonderful opportunity to interact with the federal court judges, high court judges in Australia. And we were discussing the concept of locus standi. Because you see, this locus standi is a very important, there is very important area where public interest litigations get force, because locus standi, I don't know if the young students would be very well informed about this. Locus standi is the competence of the person who goes to a court of law and files a litigation, like in euthanasia, because my mind is so full with my past experiences, one after the other, some thought is jumping. Locus standi in euthanasia, you would, in euthanasia, we had dealt with ichha mrityu, that you have to die if a person's sick, because sometimes I have to explain also for the youngsters in the group. There the question came up that, all right, I mean, we had a very concerned debate mutually between the two judges, the two of us, that all right, if we hold, or the statute holds, that some euthanasia should be given effect to, then, and the person is not in a position, the affected person is not in a position to take a decision on this, whether he wants to have a euthanasia should be practiced on him, then who would take that decision? Who would? Then the concept of locus standi. Your neighbor cannot file a petition and say, oh, that person is not in a position to survive, so let euthanasia be implemented. So We had a very locus standi concept in that Australian delegation. We had a very happy discussion, and I think we also informed them about the locus standi, because one of the judges of the Supreme Court, I think it was Justice Ravindran, who said that for the weaker sections in India, we also at times bend the law when it is required in the interest of justice. And this concept, I remember one of the federal judges in Sydney, a lady judge. So she said, we don't have this concept of PIL in Australia. This public interest litigation concept is not in Australia. I don't know. I mean, that was 10 years ago. Maybe after 10 years, this some development might have taken place. So what I'm trying to say that one part is through amendments where you introduce the comparative law study and experience. The other part is it's a natural instinct that we learn from each other. So these exchange program, student exchange program is all right, but otherwise also an exchange program with the legislators and the judges and the legal experts. Generally, what we do is if the judges meet there, only judges are there. If the academicians and eminent professors meet, it is only in between the academicians. When the legislators meet, only the legislators are there. Let there be a cohesive group where all of us, at least when there is a legislation to be introduced, that we have an in-depth information through study of comparative assistance, and the universities also can give their input. So because I have so many speakers we have to see, it's a very, very broad subject. And I'm also feeling acutely conscious of the time limit. So I would like to, I'm rushing into one subject. So in a condensed way, I'm very happy that this subject has been chosen for discussion. But as I always perhaps in all workshops and conferences, I always say that let these workshops become truly useful for the development of law, and just not be a discussion and keep it. Let the resolutions and let the feedback be given to the Honorable Supreme Court, to the High Courts, to the parliamentarians, where the value of these study and workshops may put to complete use, and the efforts that we make in these discussions come to light. I'm very happy for this conference to have been organized with such a broad-based, all over the global international conference, and with such eminent judges. I'm happy that I'm sharing the group with another distinguished lady judge. Today I'm slightly, technically slightly, I'm in a soup, I would say, that because of my system, I'm addressing you all through iPhone, listening, so I can't even see all the speakers, I can't see the name. So please excuse me, as I have not been able to address all of you by name. And in a very small system, I can see only 3 more faces other than me. So I could not, it would have been a wonderful occasion if we had interacted personally, and looking forward to that sometime. But I compliment all of you to have organized a workshop and a seminar for a discussion, which really needs to be understood, because I don't think comparative law concept is very much, in fact, to make an honest confession, I also had to, refresh my memory. And I said, oh, here, when first of all, this comparative law struck me, when I was confronted with the this Nirbhaya, case, in some way, that also was a PIL. And finally, I could come across some of the European experience in European countries, where they also use, where the accused has to prove its innocence. The prosecution will late and accused will have to. But of course, these are, these ideas, it's just in a capsule form. We need to deliberate, we need to expand. I'm sure in the deliberations, all of you would give a thought to it. Amity University, earlier occasions, I had the good fortune of visiting the university, and it is so devoted to the cause, and it always, does the whatever it does it does with a lot of quality and devotion, and with such eminent academicians who are so very, in such a wonderful campus. Also, I must compliment. And in that, if you apply the comparative study, it lacks in none. It has such wonderful infrastructure with such good, academic group. It's a wonderful experience, and I compliment the students that they should take this opportunity to explore, compare the law, and be at the top and make the world at the top. Let there be competition only for the good, for the better, for the universe at large. I would say no more, but I would take this opportunity to thank the organizer, the convener. I came to know of this only yesterday about this program. So I was teasing, am I a late addition to this? Then, but of course I was also traveling. But it's always a treat. It's always a treat that when you involve in a discussion, in a workshop with the young fraternity especially, you feel that what you have done is being put to use. I'm happy that I have been invited to this August gathering. Very many thanks to the chairman and the vice chairman of Amity University, Dr. Chauhan, both the senior and the junior Chauhans, the respected, the honored principal, the eminent professors, and of course, it is the customary to first of all address the judges, but I'm including my brother Justice Srivastava at the end because we have sailed in the same boat. I'm happy that he informed so much in such a condensed way about the entire Indian legal system. Thank you very much. Looking forward. Wish you all a great future. Wish you all the best. Thank you.
So thank you, Your Lordship. Whatever you have told, actually it resonates what our founder president Dr. Ashok K. Chauhan says, that whatever we do it has to be put in use. Whatever action we take has to be put in use. And in the same way, you are also spoke in the same language, and we are to work for the benefit of the society, for the benefit of the mankind. That's really great. Get to hear you, madam.
Thank you so much, Honorable Ladyship, Madam Justice Gyansudha Mishra, ma'am. Ma'am, listening to you is always a treat, ma'am. Every time we listen to you, every time we learn something new, ma'am. Thank you so much, ma'am. And as our founder president,
today I have to really concentrate in listening, but my sister, the sound quality is too low. I really have to, poke in my face in my iPhone, because it's in a lighter vein, I left my laptop and iPad bag at the place where I had gone to visit. So ultimately I said, how will I join? Then I was suggested, no, you can join through your phone. But the voice quality is very low. It's very difficult to decipher what one is saying.
But ma'am,
fortunately, I haven't lost my hearing capacity.
Okay, but
yeah,
ma'am, now what you will see on screen is something that you can really make out. And now we are going to present the citations for your honorable presence, ma'am. Thank you so much for gracing the occasion. And I would request my colleague and co-convener, Mr. Rupendra Singh, sir, to present the citations. And the citation of honor is presented to Honorable Mrs. Justice Gyansudha Mishra, Madam, in the inaugural ceremony of the International Conference on Comparative Law on Friday today, the 18th day of February 2022. Her ladyship is the fourth woman judge of the Supreme Court of India, with an acumen in dispensing justice for the cause of humanity, an illustrious personality With profuse knowledge and number of landmark judgments to her credit, her ladyship is a person to reckon. We are extremely thankful to Honorable Mrs. Justice Gyan Sudha Mishra ma'am for sparing her precious time and sharing her valuable thoughts. We hereby recognize the contribution made by her ladyship and extend our heartfelt gratitude to her, presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. I would request Madam to present a one-liner acceptance speech. Thank you so much, ma'am, for your gracious presence. I would now request my colleague to present another citation of honor, and I would request Honorable Chairman, sir, Joint HOI, sir, and all the dignitaries of the days to join us in this felicitation of presentation of citation of honor. Ladies and gentlemen, the citation of honor is presented to Honorable Mr. Justice P.K. Srivastava, sir, in the inaugural ceremony of the International Conference on Comparative Law on Friday, the 18th day of February 2022. Justice Srivastava, a former judge of the Allahabad High Court, has experience in myriad facets of law. Justice Srivastava has contributed immensely to this conference by his thought-provoking words, so we are extremely thankful to Justice Srivastava for sparing his precious time and adding value to this conference. We hereby recognize the contribution made by Honorable Justice Srivastava and extend our sincere thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. We would now present the citation of honor to Dr. Abdullah Rashid Ahmed, and the citation reads, the citation of honor is presented to Dr. Abdullah Rashid Ahmed in the inaugural ceremony of the International Conference on Comparative Law on Friday, the 18th day of February 2022. Dr. Ahmed is a distinguished educationist who has painstakingly taken steps to transform education in Maldives. An illustrious personality with profuse knowledge in the field of education, he has contributed immensely to this conference by his thought-provoking words. We are extremely thankful to Dr. Ahmed for gracing the occasion and adding value to this conference. We hereby recognize the contribution made by Dr. Ahmed and extend our sincere gratitude to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. This citation of honor is presented to Honorable Ms. Najat Abu Chakra in the inaugural ceremony of the International Conference on Comparative Law on Friday, the 18th day of February 2022. Ms. Chakra is a renowned jurist and the first woman appointed as a military investigating judge in Lebanon. Her in-depth knowledge in international criminal law has contributed immensely to this conference. We are extremely thankful to Ms. Chakra for sparing her precious time and adding value to this conference. We hereby recognize the contribution made by Ms. Chakra and extend our sincere thanks to her. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. Thank you so much, Honorable Lordship, Leadership, and Honorable Minister of Education, Maldives, for gracing the occasion, and Chairman, sir, Additional Director, sir, Dr. Joshua, for doing the honors. Thank you so much, ladies and gentlemen. We now move ahead in the flow of the schedule, and this International Conference on Comparative Law is going to see now the release of the conference proceedings. The conference proceedings of the Third International Conference 2022. We have received around 160 papers from across the globe, and this proceedings of the conference showcases and highlights the different topics on which different authors have presented, ranging from the comparative study of the social security framework of India and Australia, talking about the impact of the hostility in different countries relating to the criminal law, and analysis of relationship in the nature of marriage and the legal wedlock in different countries. As you can see, so many chapters being presented, ranging from comparative media, IPR, technology law in the digital area, to sedition laws. It talks about recognition and importance of arbitration between the South Asian countries and many more. As you know, there are 6 themes in the conference, and relating to the 6 themes, we've got so many chapters. Many congratulations, everybody, for the release of the conference. Thank you, dignitaries gracing the dais, for being a part of this conference. Now, we would also request all the dignitaries of the virtual days to be a part of the release of the Amity International Journal of Juridical Sciences. This journal is an international journal, and I invite all the delegates and attendees to this conference to send their papers to this international journal that we are releasing today, Amity International Journal of Juridical Sciences, a journal of Amity Law School, Noida. And as you can see, the chief patron is none other than our founder president, Dr. Ashok K. Chauhan sir, patron, Dr. Atul Chauhan sir, who's our chancellor, co-patron, Professor Dr. Balwinder Shukla ma'am, who's the vice chancellor of Amity University, and together with Professor Dr. D.K. Bandyopadhyay sir, who's chairman at Amity Law School, Noida, with editor-in-chief, none other than our joint head of the institution, Professor Dr. Aditya Tomar, editor, my senior colleague, Professor Dr. Devendra Singh. You can see that the board of editors and the editorial team comprises of the people from across the globe. And this is the release of the Amity International Journal of Juridical Sciences. Now, you can see so many chapters ranging from different facets of law being written in this particular journal. Let's have a huge round of applause for the release of the 2 books. Congratulations, Chairman sir, all the dignitaries of the days, especially Professor Dr. Aditya Tomar sir, because of whose motivation we are holding this conference. Over to Dr. Aditya Tomar sir for a one-liner, please.
Thank you very much, sir. Thank you very much, sir and honorable madam. Now I request to Professor Joshua to continue with the technical session, keynote address session. Thank you, Dr. Sumitra, and most welcome, Joshua sir.
Thank you, sir. Thank you. Just before I begin, I have to say that it has been an intellectual feast listening to all the speakers so far, and it's really been so good, so interesting, and so much of it's a wealth of knowledge. So thank you. Prime Minister Scott Morrison recently stated in a virtual summit with Prime Minister Narendra Modi that India and Australia are natural partners. And to this he replied, "It is not the Indian Ocean that separates these 2 countries. It is the Indian Ocean that connects us." And so this mutual relationship between Amity Law School, Noida, and the School of Business and Law, Edith Cowan University, Western Australia. And I thank Professor D.K. Bandyopadhyay and Professor Aditya Tomar and his team, or shall I say his army, for ensuring that these bonds grow from strength to strength. On behalf of the Council of Australian Law Deans and on my own behalf, I extend my best wishes to the organizing committee, participants, and other distinguished speakers. We at Edith Cowan University are once again delighted to be collaborating with Amity Law School, Noida, for this international conference on comparative law. Now, this is one platform where academics, lawyers, jurists, and people from industry and profession and students come together to discuss and debate. And this conference has brought thousands of participants from almost all the continents in the world. Now, I have the honor of introducing our distinguished keynote speaker in this segment. So without any delay, let me introduce our next keynote speaker, Professor Dr. Nand Kishore Sinha, Vice Chancellor, Himalayan Garhwal University, Uttarakhand. Before embarking upon this role, Professor Sinha has served as the Pro-Vice Chancellor of Sri Venkateshwara University in Uttar Pradesh. He has also served as the Group Director, BDS Group of Institutions, Meerut. He specializes in the area of managerial economics and business environment. He has also served as the President of the Center for Education Growth and Research, New Delhi. And in 2019, he received the Academic Leader of the Year award by the Integrated Chamber of Commerce and Industry, New Delhi. He has worked on several research-sponsored projects. To name a few would be the modernization of handicraft metal industry, especially the art and the idol making, sponsored by the Ministry of Textiles, Government of India, investment climate in northern states, sponsored by the PhD Chamber of Commerce, New Delhi, and the social and education status of the backward classes in National Capital Region, sponsored by NCERT, New Delhi. This is just to name a few of them. He's a prolific writer and has published several articles in journals of repute. He is a life member of All India Management Teachers Association, All India Economic Association, the Econometric Society of India, Center for Education and Research, New Delhi, and the Integrated Chamber of Commerce and Industry, New Delhi, to name a few. Sir, we warmly welcome you to this conference and look forward to your address with great delight. Over to you, sir.
Sir, you have to unmute yourself. Please unmute yourself.
Honorable Sinha, sir, please unmute yourself.
Okay. Good afternoon. Thank you, Dr. Joshua, giving me opportunity. And good afternoon to all the luminaries present in the international conference today. My special thanks to Chairman Dr. D.K. Bandyopadhyay, sir, that he has organized such a wonderful international conference with the help of Associate Director Dr. Aditya Tomar, and I would like to extend my thanks to Vice Chancellor Professor Balvinder Shukla, and I never forget to thank the person who has given this platform, Amity Group of Institution, Dr. Ashok Chauhan, founder of this Amity University. He is the real leader in the educational world, particularly. He established this Amity University, and now it has having global repute. So thank you, Ashok Chauhan, sir. And also I would like to thank chancellors of the Amity University, Atul Chauhan, sir, and Asim Chauhan, sir, for providing this great platform today. I would like to extend my thanks to Dr. Abdullah Rashid ji, Minister of Education of Maldives, and our eminent judges, Madam Gyan Sudha Misra ji and Justice P.K. Srivastav ji, who has enriched us in the area of legal knowledge, particularly. I would like to say a few things in this regard, that all of we are relying most on the legal system. None of the world is not relying on the legal system. All of we are working for the people, for the planet, prosperity, peace, and partnership. And we know that this legal system governs the world and the people. And this legal system is the ultimate instrument of the change. It has potential to reform the society and guarantee of justice to the people, and principally it has a basic elements of facilitator of justice. It serves as an important instrument of achieving socio-economic development in the society. The primary function of law is to maintain peace, order in the society while protecting individuals' right, freedom, and is therefore a basic element in the society. Today we are here to discuss the importance of comparative law and which has increased enormously in the present age when the globalization, internationalization, and the strengthening of democracy taken place. The nature of law, always we know that changing as well as it has dynamic element, since the characteristics of law is depend on the governance in the country. More especially, it involves the study of different legal system, as most of the speakers has pointed out that Indian legal system has gained from different advanced countries like USA, France, Australia, Germany, and we have developed a very enriched constitution in our country. Why we are talking about the comparative legal system? Because all of we are not working in isolation. We are working with the global partners, and especially when liberalization and globalization taken place and emergence of multinational came in forefront. So we can say that we must be thankful to the multinational corporations and global production chains, and national economies are being globalized. Modern digital technology made the integration of production at global level possible. The European Union, the North American Free Trade Area, and the World Trade Organization represent the institutional manifestation of this new trend. Along with the trade liberalization, these institutions have been pursuing the objectives of developing global standards and thereby global governance for intellectual property rights, investments, labor rights, etc. There have been formidable obstacles on the way, but still the efforts towards a global regime in trade, investment, and related aspects such as technology is going on. And thanks to the contribution of the people like Adam Smith, since he is known as the father of economics, and the governments realized the value of free trade and made conscious efforts to promote the free trade. And one can identify three distinct stages in evolution of international free trade regime. To begin with, the state started concluding bilateral treaties which are due to mutually reducing tariffs with regard to certain specific goods which were in the interest of them. As I mentioned earlier, that welfare of the citizen depend on the law, and the law gives the structure to the nation. And we know that India, there is a law commission working for us. And if we talk about the legal education today, since I'm looking after the university, so I would like to draw attention towards the legal education system. And this actual comparison of legal system, the discovery, explanation, evaluation, and comparison of legal system is only one of the several themes of the contemporary discipline of comparative law. A theme concerns influence between the legal system, especially the reception of law, whether the individual legal institution or the entire legal system. With regard to Europe, this encompasses on one hand the influence of European private law of different legal systems, and the other hand, it includes the transmission of European law to non-European legal systems. And the theme of comparative law is the development of general theory of law. Hence, comparative law functions as the discipline which attempt to understand the various legal systems in their totality and their relationship in each other, without necessarily trying to avoid the minimize the existing differences between them. This theme was prominent, and even today, since UNDP always deciding some factors on which this world is developing. Earlier, it is Millennium Development Goal. Now it's a development goal for the sustainable development. So all these areas we have to inculcate in our educational system and comparative educational system. If we talk about today's first area where this legal system must concentrate is the health, nutrition, and sanitation. Recently, we have seen that the COVID had played a devastating role in the economy, and this legal system has helped to overcome this COVID situation. And another first area is the child right, juvenile justice, child labor, bonded labor, trafficking of women and children, women's empowerment and security, disability and barrier-free movement, elderly care, basic amenities and infrastructure, inclusive and alternative education, skill development, vocational training, promotion of entrepreneurship, economic empowerment through microfinance, disaster relief, environment issue, and all these trust area has taken care if we go through the national new new education policy devised by the Ministry of HRD, Government of India. I'll not take much time. Another expert members are there in the legal area. They will focus on the comparative legal system on the issues where I pointed out. So thank you, Madam Sumitra. Thank you, Aditya, that you have given opportunity to present my views in this international conference. Thank you.
Thank you, sir. Thank you very much.
Thank you. Thank you very much, sir, for your insightful perspective. You've certainly left us with a lot of food for thought. In fact, the unique blend of your expertise of managerial economics and business environment adds to the interdisciplinary flavor of this conference. And I was really very much looking forward to listening to your the economic angle that you brought in, and that was really good. So thank you. Our next speaker is Professor G.S. Vajpayee, Vice Chancellor, Rajiv Gandhi National University of Law, Punjab. He's also the convener for the Committee for Reforms in Criminal Laws set up by the Ministry of Home Affairs, Government of India, which is tasked with the spearheading of historic reforms in criminal laws in India. He is a member of the Advisory Board for the Development of Legal Education and Legal Profession and member of the Standing Committee of the Legal Education Committee of the Bar Council of India. He's also a member of the General Council, Damodaran Sanjeevaya National Law University, Visakhapatnam, and a member of the Punjab State Legal Services Authority. He has been nominated by the Association of Indian Universities as a member of the Board of Indian Association of Social Science Institutions. He's also the president of the Indian Society of Victimology, Executive Committee of the World Society of Victimology, and the vice president, Victim Support Asia. At the instance of the Honorable High Court of Delhi, he was appointed as amicus curiae in 3 cases. He has authored several books and published numerous articles in journals of repute. He is a recipient of the G.B. Pant Award for his book on human rights and police. In recognition of his contribution to the growth of criminology in India, Dr. Bajpai was conferred the title of Fellow of the Indian Society of Criminology. In 2005, he was also awarded the coveted Professor S. Srivastav Memorial Award for Excellence in Research Teaching in Criminology, and in 2014, the Best Social Scientist Award from the Indian Society of Criminology. And the list can go on and on and on. We are extremely honored to have you with us, sir, and we really look forward to your address. Over to you, sir.
Many thanks. This is such a pleasure to be with you this afternoon for this wonderful gathering, and I acknowledge the presence of Dr. Dilip Kumar Bandyopadhyay, Professor Adit Tomar, and all the colleagues and friends at MIT Law School. This is such a wonderful theme that you have chosen for discussion today. I've been listening some of the presentations which were made this morning in this conference. And whatever time I have, I am going to discuss very briefly the comparative law, since this theme is focused on comparative law, and a lot of ideas have already been expressed. I thought that I can briefly discuss the method part of comparative law. Comparative law as a method has perhaps not been adequately focused in our discourses. However, even generally speaking, the comparative law is not a subject which figures very often in conference themes. I don't know what is the reason. So therefore, a special acknowledgement and a special appreciation is accorded to the thought process that you had for organizing this particular event. So friends, I thought that since this in this limited time, I can probably explore some of the ideas relating to comparative law as method, because we understand that comparative law is discussed in various contexts. Most of the time, the lawyers and judges would look at comparative law as a sort of knowledge gaining exercise for the purpose of application, and to be able to gain from the experiences from different jurisdictions. That is the one very common sort of way to look at comparative law. The other very useful and very important dimension of comparative law is comparative law as a discipline. Comparative law as a discipline, which is emerging now very, remarkably. So comparative law as a discipline would mean that what are the conceptual boundaries of this subject, what are the important theories, what are the discourses involved, and what are the educational aspects relating to comparative law. So this is mainly the academic side of comparative law. Third is when you decide to make use of the comparative law for the purpose of gaining knowledge or for the purpose of gaining insights from other jurisdictions to be able to benefit from different experiences, then the method of comparative law would come. So comparative law as a method is not something which is very often seen. So my focus in this couple of minutes, I'll highlight this particular thing, and we'll look at how the comparative law as a method being used to generate knowledge, to gain experiences, and to be able to benefit from the experiences in the jurisdiction. So we know that the laws are developed and evolved in many ways. And comparing the law of different nations or even culture, that provides a unique way to develop laws in a better manner. So comparative law to me looks as a method which describes the comparison between different legal systems. So there are two types of comparison, which I feel that, so one is where we have macro comparisons, and other where we have micro comparison. So essentially micro comparisons is something that is a comparison between, say, for instance, specific institutions of law, which are dealing with specific problems. Whereas macro comparison or macro comparison is about the entire legal system. So this is the nuanced method. So if you are explaining the idea of comparative law to the students, then you have to be essentially clear whether you are talking about macro comparison or you are looking at micro. And both are very important. So sometimes my interest is limited to see as to how the prosecution system, say in Australia or England, functions, or for instance, in other than common law countries like France and China functions. So this is the comparison of institution. But if I want to understand how the entire legal order functions for the purpose of protection of women, what are the protective laws, then probably we can look at. So comparative law as a method involves the emphasis on legal mechanisms being adopted by countries and compare them. So it is not a legal text or a body of rule. That is very important for a law student. Let us understand that we do not find comparative law, unlike other subjects, as text or body of rules. It is merely seen as a method. So probably a good takeaway from this conference is to highlight and to develop comparative law as method. And we know that the Montesquieu was someone who spoke pioneeringly about, and he is considered to be the father of comparative law. And he looked at the penal laws in France and England by analyzing especially the punishment given in both the countries. And in doing so, he was able to sort of come out with a comparative methodology to look at the comparative punitive systems. But as we reassess the methodology of comparative law, we need to reassess the purpose and mission served by a comparative law. So generally, the comparative law has been employed as a discipline to understand foreign law and culture. So it is also found to understand our own culture better through the process of comparison to another culture. So culture is very important. Now, the reference to culture along with law. So sometimes the cultural and social context in which law function becomes very crucial. I'll speak a bit on it a little later. However, in charting to this path, comparative law can learn a lot from other disciplines. Now, it's not that the comparative law functions in a solo. The other disciplines are very, very important. And when we are looking at, for instance, critical legal studies, or for instance, law and economics, law and sociology, or for that matter, feminism. So to name just a few, so like these disciplines, comparative law must also stand on its own as an independent scientific discipline. But with a keen focus on comparative law, we can reassess the underlying principles that make up the legal order, determine what if anything needs to be done nationally, regionally, or internationally. So if I can very sharply point out the key objectives, why we should indulge in comparative law as a method. So the first goal which emerges very clearly to perfect the legal system in effect. So we want to achieve a perfection in our legal system. And to attain a deeper knowledge of the legal system is the second very important. And possibly to contribute to the unification of legal systems. So sometimes the unification of legal system is very important on a smaller or a larger goal. And similarly, the improvement of national legislations. As has been said that I'm also the part of the National Criminal Law Reform Committee. So while I was working on the prosecution system and police system for the purpose of recommending the changes in India, I had to go to other jurisdiction to find out. Like for instance, I wanted to recommend the introduction of community sentence as a punishment. At the moment, India does not have community service or a community sentence. So I have gone through the criminal procedure in the UK and the US, where they have certain community orders. Now, how those orders are constituted, executed, or applied, that knowledge is to be essentially gained in a comparative perspective. So that was very helpful. Similarly, I wanted to recommend the changes in the prosecution system. Now, prosecution in India, for instance, is a very deficient institution. But if you go to the civil system, common law system, I would not compare with England. I would compare with the civil law systems like Germany, like France. In France or Germany, the prosecution system is very strong. And we all know that, like, when judges are appointed with the same test or same recruitment process, prosecutors are also, appointed. You'd surprise that the choice for becoming a prosecutor is much more higher than becoming a judge, because prosecutor is the head of the police department also. He is supervising the function of the police. So it has a lot of edge and contribution and involvement. So these are the comparative insights. So like if I have to improve the prosecution system in India, essentially I have to look at the functioning of the institution of prosecution in other context. Similarly, let us look at the different methods which are generally prevalent under the broad methodology of comparative method. So the first method is the functional method. So, we know the Hen codes. Hen codes is a very, I think I have to essentially name the person like Ren Herschel or Hen codes or Testnet, who have actually contributed significantly to the evolving of comparative methodology. So functional method essentially deals with comparing the functions of the law that are in place. So sometimes more than a structure, we are looking at the function of the law. So this method states, even if the structure of law is different, but they have the same function and so can be compared. So sometimes the structures are different, but functions are essentially same. Like for instance, the police is organized very differently in the US, but essentially they are functioning for the maintenance of law order, prevention of crime, investigation, like we do. So to that context, the functional comparison is possible. And we also know that this method is used to solve issues and compare the nation on the basis of basic function of law. So like for instance, theft, rape, murder, they are the practical problems prevalent in all society, irrespective of what kind of legal order they are following. So we can probably be benefited from their functional outcomes rather than essentially going to the structure. But in other case, the second method is the structure method. When you are comparing with the similar zones or similar jurisdiction. So this method is used to determine the similarity and differences between the structure of law. And this structure of legal system is analyzed and compared to determine the difference between the implementation of law. And hence, this is very important. And one of the most popular method, which probably all the law scholars would appreciate, is the analytical method. Now, in comparative methodology, the analytical method is the most used method. This method basically focuses on analyzing the meaning of different aspects of law. It actually analyzes how the same concept can be understood in numerous ways. And this includes the use of various terms of legal references such as right, liberty, defamation, or any kind of legal concept. So this method is used to compare and understanding the use and interpretation of terms, which might be similar in core, but are used very differently. Because sometimes the jurisprudentially, the concepts are same, but their connotation because of the context are very different. So sometimes we need to infer as to what is. And very recently, another method is being evolved, which is called law in context method. This method is used elsewhere also, but in comparative methodology, law in context method is, so third method, very important, fourth method is law in context. Because black letter law is very different. In India also, we are moving probably away from the black letter law to the more and more to the contextual understanding of law. And fifth method is cultural legal comparison, which I have mentioned in the beginning. It is the most interesting. I think this conference can recommend, a lot of research is possible to the cultural specific understanding of the creation and implementation of law. So method uses the cultural aspects of the nation for comparison. For instance, adultery was decriminalized in India. Because why it was criminalized initially? Because we had a cultural context where adultery was strongly looked down upon. The same Macaulay did not criminalize adultery when he made the law in England. So two cultural contexts, same act, two different laws. And I can refer to all kind of laws. So there is a tolerance, there is a social tolerance, like for instance, Holland, Netherlands. Netherlands, there is an admissible use of drug is regulated. Gambling is not crime. Prostitution is not a crime because their cultural context does allow, so therefore laws are also created. But in India, all these things are criminalized. There are people now talking about why are you regulating the OTT platform, pornography? Let people have their own choices. So you need to look at the cultural specific methodology. So for instance, so these are some methods probably we can refer to the students and scholars to probably make use of and to test them, their efficacy, their contribution, their measurability, and all other aspects. But the fact remains that if you want to evaluate the law, to evaluate a better law or to create a better legal order, probably the comparison remains a key important. Comparison remains the key facets. And therefore, I haven't referred the business law, trade law. No, business, trade law, international trade law, even the all digital laws, cyber laws, they have huge comparative application. One very quick example I can quote, that is the artificial intelligence. Now, artificial intelligence in India is in a big debate, but we do not have at the moment any legal framework to regulate it. However, in European Union has already brought a lot of regulatory guidelines and law. Even the Germany has brought it. So we are gaining and understanding a lot from this jurisdiction because today or tomorrow we are going to probably regulate artificial intelligence. So like data protection and privacy bill yesterday, again, we are gaining all these things from, because privacy law, the way we perceive in India, the way it happens in Europe and other jurisdictions is very, very remarkable. But I think the key debates remain same even for India, because we are caring, because we have recognized privacy as a fundamental right, though much later. In other jurisdictions, it was already there. So now law and its institutions both are required to be at place. So I feel that very quickly, in 2 minutes, I think I'll wind up. If we have to follow our methodology, we have to follow 4 steps, basically. The first step is acquiring the skills of comparativist, skills of a comparativist. I'm using this comparativist word. So if I'm making a comparison, I'm a researcher, therefore I'm a comparativist. So skills of a comparativist in order to evaluate clearly, objectively, and neutrally. The second part is evaluation of law as it is expressed concretely in words, action, or orality. We can refer to this as an external law. And third part is of methodology is evaluating how the law actually operates within a culture. We might refer to this as law in action or internal law. And fourth essentially is, and conclude with the comparative observation that can shed light on a foreign law, culture, and our own. So let us now turn to outlining the comparative law methodology. That is the methodology which we can probably look at, because we are busy what is called legal transplant. This is a new expression I am making. So if you are into the business of legal transplant, and there is no harm in gaining from the experiences of other, but But when you do this legal transplant, you need to be careful about how you are going to do it. So I think in the connotation in comparative law is not simply comparing. Please remember, simply comparing, it is methodologically efficient comparison. Methodologically efficient comparison would entail the steps and design of research, which would be objective, neutral, quantifiable, and therefore would be much more refined. So these are some of my ideas on, I have limited myself on comparative method essentially, because probably then we can focus. So this is all from my side. I once again thank you for giving me this opportunity, and I'm inclined to know more and more about your activities. And thank you for having me here. Thank you one and all.
Thank you, sir.
Thank you. Thank you very much. That was really a very well articulated address. And we are grateful to you, sir, for sharing your thoughts with us. I've either had the opportunity of interacting with you virtually or at our Asian Law Institute conferences at the National University of Singapore. But I really hope things get better, uncertainty moves on, and we can meet up. And I've always been inspired by your work. Thank you.
Thank you so
much. It has
much.
indeed been an intellectual feast. I would say a treat listening to all our speakers today, particularly in this segment. And I'm now handing over the baton to Dr. Singh, who will lead us to the next segment of the proceedings. Over to you, ma'am. Ma'am, you're on mute.
Okay. Thank you so much. Sir. Okay. Yeah, thank you so much, Dr. Joshua Aston. I would request Rupendra sir, can you mute your mic? Thank you. Very beautiful deliberations and very nicely moderated by Dr. Joshua Aston. So we are now coming towards the end of the keynote session. However, many things are remaining. So we are just taking a minute to open the citations. These are the citations that we will be presenting to our honorable keynote speakers for the day, Professor Dr. N.K. Sinha sir and Professor Dr. G.S. Bajpai sir, who've made a meaningful contribution as keynote speakers. Ladies and gentlemen, boys and girls, this is the inaugural session come keynote address session at the 3rd Annual International Conference on Comparative Law. We had the privilege of listening to Honorable Ms. Najat Abu, who is investigative judge at Military Court, Beirut, Lebanon. We had the privilege to listen to Dr. Abdullah Rashid Ahmad sir, who is Minister of State for Education at the Republic of Maldives. We had the pleasure of listening to Honorable Mr. Justice P.K. Srivastava sir, who is chairperson of Law Commission at Uttar Pradesh. And we also had the privilege of listening to Honorable Mrs. Justice Gyan Sudha Mishra ma'am, former judge, Honorable Supreme Court of India. And we had released 2 books. One is the conference proceedings of the 3rd International Conference 2022 on Comparative Law. And we also released Amity International Journal of Juridical Sciences. And then we had 2 keynote addresses. And towards the end of this keynote address, much of the deliberations that we find are the various areas in which we understand the inner structure of the legal systems of various countries in a comparative way. So I will now request my colleague and co-convener, Mr. Rupendra Singh sir, to share with us the citations of honor. And I'll just take 2 minutes. Aditya sir, is there any input that you would like to give here?
I just want to join the hands with my friend Dr. Joshua to thank to Dr. G.S. Bajpai, sir, just to enrich with his vast knowledge. And we are also thankful, sir, just to join us in the conference as the academic partner. We are thankful to you, sir. And I also want to thank to Professor Dr. N.K. Sinha sir, that with his blend of management knowledge with the law, he enriched the house. Thank you very much to both the learned professors. Thank you very much.
Chairman, sir, before we present the citations, Chairman, sir, before we present the citations to our honorable keynote addressees today, sir, is there any input that you would like to give?
Yes.
Sir, is there anything that you would like to say before we present the citations?
Yeah, let me, there's some issue. Yeah.
Yes, sir, actually some network problem, sir.
Yeah.
Somebody's mic is... sir, actually, we are trying to open the site, the video of the citations.
Yeah,
yes,
please.
sir,
Please. Please.
No, sir. Before we present the citations, now we finally got the citations. Thank you, Rupendra, sir. Ladies and gentlemen, we would now present the citation of honor to the eminent guests for today who presented the keynote addresses. The citation of honor is presented to Professor Dr. S. Shantakumar, sir, in absentia, in the inaugural ceremony and the keynote speaker session of the International Conference on Comparative Law on Friday, the 18th of February, 2022. Professor Shantakumar Sir is an internationally renowned legal scholar and has been instrumental in promoting the cause of environment and climate change, a dynamic personality with profuse knowledge and zeal for bringing change in the society. Professor Shantakumar has contributed immensely to this conference by his thought-provoking words. We express our gratitude towards Professor Shantakumar for wholeheartedly supporting us in our academic endeavors. We are thankful to Professor Shantakumar for investing his valuable time and enlightening us with his valuable words of wisdom presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. The citation of honor is presented to Professor Dr. G.S. Bajpai in the inaugural ceremony and keynote speaker session of the International Conference on Comparative Law on Friday, the 18th day of February 2022. Professor Bajpai is a renowned legal scholar with extensive research experience, unparalleled, and an academician par excellence, a dynamic personality with profuse knowledge and enthusiasm to bring about a change in society. Professor Bajpai has elevated the legal education to the next level. We are grateful to Professor Bajpai for supporting us in our academic endeavors. We are thankful to Professor Bajpai for investing his valuable time and enlightening us with his words of wisdom presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. The citation of honor is proudly presented to Professor Dr. N.K. Sinha Sir in the inaugural ceremony and the keynote speaker session of the International Conference on Comparative Law on Friday, the 18th day of February 2022. Professor Sinha is a renowned scholar who is involved in enhancing the quality of education, an illustrious personality with huge experience in management and economics. Professor Sinha has contributed immensely to this conference by sharing his valuable thoughts with all of us. We're extremely thankful to Professor Sinha for sparing his precious time and adding value to this conference. We hereby recognize the contribution made by Professor Sinha and extend our sincere thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. Thank you so much, sirs, for gracing the occasion. And the citations are being presented in the august presence of Chairman, Amity Law School, Noida, Professor Dr. D.K. Bandyopadhyay, sir, and Additional Director and Head of the institution, Dr. Aditya Tomar, sir, together with Honorable Ms. Najat Abu and all other dignitaries gracing up the days. It's time to present the closing remarks by our moderator, Dr. Joshua Aston. Dr. Joshua, I would request you to present some brief remarks in 2 to 3 minutes about the keynote sessions.
Thank you, Dr. Singh. Indeed, it has been so great listening to everyone, and presenting my closing remarks in two minutes is like regulating a nuclear fission reaction, because I've heard so much from everybody, and to put everything in a nutshell is difficult, but I am conscious of time and I'll limit myself to 2 minutes. Now, I've really enjoyed listening to each of our speakers in the session. Each of them came with rich, diverse backgrounds and specialized in various areas of humanities. Can I begin by thanking each one of them for their time that they've taken to come and talk to us today and enlighten us with their address. I think having distinguished speakers such as these at conferences, really it's like the cherry on top of the cake. So thank you very much. Now, the importance of comparative law cannot be undermined. The main aspect of comparative law is the unification of laws on the international level, and the comparative methods that provide similarities and differences in the legal systems. And thus, this is what helps in creating uniform platforms that causes the common consensus that we talk about. From what I have gathered from our keynote speakers in this session is that we should not take comparative law just as a text, but as a method. And we need to reassess the purpose and the mission of comparative law. Now, different purposes are ascribed to comparative law, and it should inform national lawmaking, assist judges, or even in resolution of difficult questions, or provide basis for the legal unification or harmonization, or even simply increase the knowledge and extend awareness. All these purposes that we've discussed about are all that the legal science should fulfill in general. From this perspective, comparative law is just a special form of general legal science, or phrased inversely, comparative study of law must contain comparative component. Now, having said this, comparative law continues to remain a very important discipline in communication between legal systems. It also helps mutual understanding and the dispelling of prejudice and misinterpretation that can very often happen. And once again, I would like to thank all our keynote speakers in this segment for taking their time talking to us. It has been a wonderful intellectual journey, and I'm sure this will steer a lot of discussion and debate long after we have concluded this segment amongst students. Thank you. Over to you, Dr. Singh.
Dr. Joshua, very beautifully in 2 to 3 minutes, you have told us the gist of both the keynote speeches. Thank you so much for wonderfully moderating it and telling us the gist. Thank you so much for that. Well, they say every good thing has to come to an end, and now we have reached towards the end of the inaugural session and the keynote speaking session of the 3rd Annual International Conference on Comparative Law, and that too, ladies and gentlemen, well on time. I remember Theodore Parker, who once said that the arc of the moral universe might be long, but it always bends towards justice. What we need to do is to simply understand the law. Having said so, I would now request Dr. Sakshi Parashar, who is the conference co-convener and assistant professor at Amity Law School, Noida, to present the vote of thanks.
Thank you so much, Dr. Sumitra. I feel honored and privileged to get an opportunity to propose a vote of thanks and express my gratitude on this very important occasion. Gratitude is not only the greatest of virtues, but the parent of all others. I, on behalf of Amity Law School, Noida, Amity University, convey deep regards and hearty thanks to our chief guest of honors, and keynote speakers for the inaugural and keynote session. I would like to express my gratitude and sincere thanks to the distinguished guest of honor, Honorable Ms. Justice Gyan Sudha Mishra, former Judge, Supreme Court of India, for her gracious presence and inspiring address. I would also like to thank our guest of honor, Honorable Mr. Justice P.K. Srivastava, Chairperson, Law Commission of Uttar Pradesh, for supporting us in this endeavor and for his encouraging address. Dr. Abdullah Rashid Ahmed, Minister of State of Education, Republic of Maldives, for his wonderful thought-provoking words. Our guest of honor, Honorable Ms. Najat Abu, Investigating Judge, Military Court, Beirut, Lebanon, for her excellent address and paving way for a wonderful start to the event. I would also like to express my heartfelt appreciation towards the keynote speakers for the first session. I would express my gratitude towards Dr. G.S. Bajpai, Vice Chancellor, Rajiv Gandhi National University of Law, Patiala, for investing his valuable time and sharing intellectually stimulating address on various nuances of study of comparative law. I thank Professor Dr. N.K. Sinha, Vice Chancellor, Himalayan Garhwal University, for his inspiring address and valuable contribution to the session of the conference. Lastly, I also thank Professor Dr. S. Shantakumar, Director, Gujarat National Law University, Gandhinagar, in absentia, for always supporting Amity Law School in its academic endeavors. I would like to express my gratitude towards the distinguished other keynote speakers, Dr. Shyamala, Dr. Rishamgar, who were courteous enough to attend the inaugural and keynote session 1. I take this opportunity to thank our Honorable Founder President, Sir Dr. Ashok K. Chauhan, and Honorable Chancellor, Sir Dr. Atul Chauhan, for their blessing and constant encouragement to take on such events with full enthusiasm. I must mention a deep sense of appreciation for Professor Dr. Balvinder Shukla, Honorable Vice Chancellor, Amity University, for continuously supporting and advising us, and which has helped us greatly towards the successful organization of the event. I would also express our heartfelt gratitude to Professor Dr. D.K. Bandyopadhyay, Chairman, Amity Law School. This event would not have been possible without your relentless guidance and support, sir. I would like to extend our heartfelt appreciation toward our joint head of institutions and additional directors, Professor Dr. Aditya Tomar and Professor Dr. Shefali Raizada, for giving us constant direction and supporting us throughout the event from inception to execution. I would also like to take this opportunity to thank Dr. Joshua Aston, Associate Professor, Associate Dean of Law, School of Business and Law, Edith Cowan University, Western Australia, and Conference Chairperson from Australia, for his constant support and guidance throughout the conference. Lastly, this vote of thanks would not be complete without expressing my deepest appreciation for the organizing team, Dr. Jain, convener of the conference, Mr. Rupendra, co-convener, Dr. Sumitra, Ms. Priyanka Ghai, Dr. Lekha, for their constant support. This event could not have been executed without your support. I'm thankful to all the paper presenters, participants for registering for this event. I hope that the event will be hugely beneficial to them and will add value to the conference. Thank you so much.
Thank you so much, Dr. Sakshi Parashar. Well, ladies and gentlemen, one of my biggest takeaway from this session was to understand the law and having a sense of connection to it. While we do that, there comes a conscious evolution in all of us. So with this, we end the first inaugural and the keynote session. And the second keynote session would begin from 2 to 4 p.m. Indian Standard Time. 2 to 4, we have the second keynote session. There will be 6 keynote addresses, and that will be followed by the MOU signing ceremony. So with the permission of your leadership, Honorable Ms. Justice Gyansudha Mishra ma'am, Honorable Ms. Judge Najat Abu ma'am, Chairman sir, Dr. Joshua, Professor Dr. Aditya Tomar sir. So with your permission, can we now take a break from this session and begin with the next session?
Sumitra, before you conclude, I like to mention that my heartiest regards and respect for Joshua, who took the initiative of having some MU sign between us and the Edith Cowan University, and that's a great thing. Joshua, thank you very much, and let us go on, having such type of deliberation and discourses in the future days to come. And at the end, we are really thankful on behalf of the entire Amity Law School Noida, on behalf of both the HOI, especially Dr. Aditya Tomar, that all the speakers, those who actually spared the time to come over here. It's a really, really great honor for us and great privilege for us, and including all the lordships that who came over here, all the lordship, all the vice chancellor, and all the speakers. So thank you very much on my behalf. Now, Sumitra.
Thank you, Chairman, sir. Well, ladies and gentlemen, as I said, we would begin with the second keynote session at 2 p.m. Indian Standard Time. So 2 to 4 p.m., we have keynote addresses of 6 eminent legal luminaries. And then 4 to 5, we have the MOU signing ceremony. So the joining link will remain the same. And as we take a break from the first session, I will end up with what our Honorable Founder President, Dr. Ashok K. Chauhan sir says. He always says that you should be the best version of yourself. And there I relate what he says with what Henry Van Dyke once said, that you should use all the talent that you possess, because the woods would be very silent if no birds sang, except those who sang the best. So taking a break from the first session, let's meet at 2 p.m. sharp Indian Standard Time. We can stay long till. Bye-bye, take care. We are live now on YouTube. This is the second keynote session. Before lunch, we had the first keynote session, and before that, we had the inaugural session. So let's wait for a couple of minutes. Our resource persons are joining in. And in this session, we have 5 keynote speakers. And the session would be moderated by the co-convener, Dr. Sakshi Parashar. So all the students kindly join, and I would request all the delegates also to kindly join. Hello, Mr. Vikrant, how are you?
Yeah, hi, good afternoon, everyone. All good, thank you.
Good afternoon, sir.
Yeah, hi, good afternoon.
So, Vikrant, we would have the MOU signing at 4 o'clock, and
Right.
before this keynote session.
Sure. Thank you.
Thank you so much for being here.
We shall now commence with the second keynote session of the international conference. A very good afternoon to all our distinguished guests, esteemed faculty members, and participants of the third international conference on comparative law. It gives me immense pleasure to welcome all our distinguished guests to the second keynote session of the third international conference on comparative law, organized by Amity Law School, Noida, Amity University, and the School of Business and Law, Edith Cowan University, Western Australia. The field of comparative law has grown immensely over the past couple of decades. The use of comparative analysis to express skepticism about judicial power, constitutional design, and the status quo of liberal democracy by opening up a range of possibilities is squarely in the best traditions of comparativism, and it continues to be much needed. The conference is a step towards exploring various domains within a larger framework of comparative law. With this being said, I would like to start the keynote sessions of the second keynote session. Our first keynote speaker is Dr. Risham Garg, Director, Center for Transnational Commercial Law, National Law University, Delhi. Dr. Garg is an Associate Professor of Law and Research Director, Center for Transnational Commercial Law, National Law University, Delhi. He holds a doctoral research degree for his work on international contracts in UN CISG Convention, and his area of interest includes bankruptcy, insolvency and restructuring, entrepreneurship policy, transnational commercial law, private international law, regulation and public policy, contract management and enforcement, and international sale of goods contract. He has previously worked as a lecturer at the Amity Law School and has been invited as a visiting faculty at the Indian Law Institute, Indian Society of International Law, Indian Institute of Corporate Affairs, and various other prominent institutions. He has also acted as a consultant to the Directorate of Legal Education of the Bar Council of India. He has recently been working closely with the Insolvency and Bankruptcy Board of India by providing valuable consultancy support and also towards continuing professional education for insolvency professionals. In 2019, he served as the academic consultant to the British High Commission and CII project on implementation of cross-border insolvency and individual insolvency in India. He has been involved in publishing and presenting research papers on contemporary issues in commercial laws and has actively participated in consultations at various forums. He has been involved in organizing various workshops, seminars, and events of extreme importance. I now request Dr. Garg to deliver his address. Over to you, sir.
Thank you, Dr. Sakshi, for that generous introduction. And I really thank and congratulate Amity University for organizing this very timely and topical conference on comparative laws. I was fortunate enough to join early in the morning, and it was an extremely interesting and enriching session with the stalwarts providing their valuable insights on this, we can call it a complex issue of comparative law. So, what is comparative law? So, we understand comparative law. And so my discussion, I want to make it basis certain case studies, and my area of expertise or specialization is commercial laws. So I will try to focus and curate my discussion upon a reference to certain commercial law cases and principles and also legislations. So as you know, comparative law is the study of differences and also the similarities between the legal systems of different countries. And it also includes the description and analysis of the foreign legal systems, even where no explicit comparison is undertaken. Now we know that there are methodologies how comparative law is being applied, and there are methodologies how the comparative law can be used to shape and draft our legislation. However, in the limited time that I am provided, I will be trying to explain with the help of two leading cases how the certain issues of, let's say, international commercial matters or cross-border matters were taken up, and then how can probably we can design a law which might be able to ease out and iron out certain issues. So there are, let's say, issues of if there are cross-border transactions, and mostly there are applicability of laws. So applicability of law depends upon the issue. So issue can be dependent upon the Contract Act. Issue can be dependent upon any other substantive law. It can be the corporate law as well. And recently we have been seeing several matters in family law, divorce, or even the custody of children. So how can comparative law be applied to prepare a robust legal system? Now, as we understand, how comparative law probably started to be applied in India, or how did we start to utilize the transplant, right? So there is a foreign law, let's say maybe of UK or US or any other foreign country. And if we feel that that foreign law might be able to provide a solution, then that is being applied. So that is an instance of a transplant. Probably the initial instances of applicability of foreign law, and then intermingling and some semblance of comparative law may be considered in the British courts, British legal system, where we had the concept of justice, equity, and good conscience, right? So there were certain principles of common law which were being applied by the British judges. However, they were being curated with reference to the whatever the law was, rudimentary shape or customary practices, it was being applied. So that was probably the initial element of comparative law. The judges were very careful that they are not directly applying some British law principle in its entirety. However, they were very careful to apply relevance to the facts and circumstances of the particular case. Now, coming to recent times, I can think of two very recent and very interesting cases, both decided by the Supreme Court. And although we can say that these cases are on the conflict of laws, however, I'm sure we can understand the relevance decision of these cases and the role of comparative law jurisprudence and the scholarship. So one is the famous case of British Steam India versus Shanmugh Vilas Cashew Industries. This is a 1990 Supreme Court case. And interestingly, this case was started somewhere in 1965, and the decision was given in 1990. The issue was that there is a contract between a trader from India and the seller was from South Africa, and the shipping company was from Greece. The applicable law was expected to be the English contract law, the British contract law. So as you see, there are cross-border transactions, multiple contracts. There is applicability of people from or traders or merchants from different jurisdictions and also different legal systems. It can be common law legal system, it can be civil law legal system. but they will have to choose. So if you choose beforehand, things get easier in the courts. But still, courts will still have to apply certain principles, and those principles we may call as the principles of private international law. But still, there are principles till the time there is a legislation. So if there is no legislation, the judiciary will apply certain principles, and those principles will be applied to resolve those issues. And as we have seen, those principles, the basis of those principles may also change over time. But if there is a law, there will be a consistency, and there will be more of certainty and predictability for the business class. So contracts, commercial matters are basically for the business class. So in this case, which started in 1965, initially the court applied the law in India and said that, because the buyer was in India, there was short quantity which was supplied or delivered in India. So there was a ground by the buyer to file the case, regardless of the law the contract had provided English law to be applicable. When the case reached the Supreme Court said that, the parties had agreed it should be the English contract law, and you should decide the case basis the English contract law. So it took approximately 25 years for this case to be decided. And the decision was, well, it wasn't, even after 25 years, there was no decision or respite for the parties, because they still had to argue this case, the damages on the basis of the English law, and then resolve their issues. Another interesting case is the Technip versus SMS Holdings case of the 2005 of Supreme Court. And this is regarding the corporate law. So in this case, this Technip was a French company, and it acquires another French company, which was Coflexip. And Coflexip, which had acquired control of an Indian company, which was CMAC. And there was a complex multi-layer route. And this transaction basically in 2001-2000. So at various stages, this was discussed, and the issue was, which was the date on which this Technip company acquired control of CMAC. And this was relevant because this would determine the price of the shares of CMAC, which were in relation to the public offer. So this Technip company approached the Supreme Court for a decision, and this decision was whether this transaction can be adjudicated according to the French on the Indian law. So previously, when these points were argued before the Securities Appellate Tribunal, and certain opinions were cited, and ultimately the French company was saying that, the company, both the parent company are the French company, so it should be the French law. However, the Indian regulator was arguing that, we will apply the India's company law. And then, that provided some remedy or some intervention to certain investors. And again, there was also an argument that Indian public policy, the public policy will apply. And hence, if the public policy rule applies, then to decide this case, the French law should not be applicable. But ultimately, Supreme Court applied the French law. Now, the interesting part is, what was the reasoning provided? The ground was that there is a ground of domicile. Both the companies were domiciled in France. So it is best that the French law should be applied. Now, what this means is that foreign law, French law, has been applied by the Supreme Court. Why? Because there is a general principle that to ensure the justice, the court should apply the appropriate law to decide that particular issue. So that particular issue is being decided by the court and applying a particular law. So the court has to choose which law has to be applied. And this is basis certain principles which they have evolved. So they had argued, ultimately the Supreme Court gave a decision that, there is a domicile and we recognize the domicile of these companies. Hence we'll apply the French law. what are the alternatives and what is the role of comparative law? So the role of comparative law is domestic courts and domestic lawyers, they do not look very kindly to the foreign law. They will say that, we should apply our own law, and they recognize and they understand. Apart from that, it is easy for the judges as well. Judges also are able to understand. It is easy for arguments to be forwarded, and those arguments can be interestingly articulated and presented. So that makes it coherent for every party to understand that, yes, and makes it more predictable as well. However, when a foreign law is being argued, it makes things complicated. So when we had to, like continuing with an example, when we had to draft our new Arbitration Act, we referred to the Arbitration and Conciliation Model Law, International Commercial Arbitration Model Law. So model law is drafted, we can say, like a comparative law. It has role of civil law traditions, comparative law traditions. Similarly, there are other substantive law as well, Sale of Goods Act. So International Sale of Goods, CISG, is a convention, which is like a comparative law between the common law and the civil law legal traditions. So the court will not have to decide and choose which country's domestic law is applicable. So the court is not required to apply foreign law. However, court applies the law, assuming it is international law, then it is international law. But if we adopt it, then we are applying our domestic law. So arbitration model law might have been considered as international law, but when it is adopted in India, it is a domestic law, right? So these are some ways in which the international law or comparative law have been able to resolve certain issues, and they have established a coherent and a predictable system and a legal regime for traders and also the legal scholars. So I think, I mean, what was the time that I had? Do I have some time or?
So you had 50, you can take 5 more minutes. You had 15 minutes.
Right. Thank you, Dr. Sakshi. That's very kind of you. Right. So now, I have tried to illustrate with the help of 2 examples, cases, and then 2 legislations, how pragmatically and practically the comparative law can be applied in an applied manner, right? So it's right, we can have in legal research, we understand a doctrinal approach, or a fundamental research approach, or an applied approach. So comparative law, certainly people have interest, people have interest, we want to improve our law. In the morning, I heard Professor Bajpayee was also speaking about the role of comparative law in criminal law reforms. So similarly for commercial law reforms, comparative law is much needed. Criminal law is still public law. Commercial law is private law. And private law is agitated between 2 individuals in the courts. So there is a direct involvement of individuals in the courts in case of commercial law. Hence, for private law, comparative law is must, because these days there are cross-border transactions, cross-border movement of people. There are n number of issues, n number of legislations, tort law, corporate law, contract law, any type of commercial law, even non-commercial obligations like family law. That is also civil law. So on one hand, you keep public law, on one hand, you keep the private law. So family law is the most important type of private law. That is non-commercial private law, but that has a lot of involvement in, I mean, we have a lot of huge body of jurisprudence in the international sphere. There are a lot of conventions, Hague Convention and Hague Principles on Child Rights, and then recognition and enforcement of judgments. So another important aspect is the recognition and enforcement of judgments. So for arbitration, we had the New York Convention, which provided this facility that, all right, one country's orders, arbitration judgments will be recognized in the other country. But what about the court judgments? Do we have any such solution? What is the legal regime to enable the recognition and enforcement of the court orders and judgments? So there are international conventions, and nowadays when there is a very close cooperation between the professionals, and in certain countries between the judges, the members of the judiciary also. Especially in case of insolvency, there is the judges network. So when there are insolvency cases between US and Canada, the judge just picks up the phone. They just directly talks to, this matter is going on in my court, what's going on in your court, right? Think about across the channel, UK court and US court. They can also have a cooperation and coordination. So the role of comparative law is immense. And for domestic jurisprudence, especially in private law, as I have tried to present certain simple illustrations and examples, I'm sure this would be a much needed step to be incorporated into India for developing a robust and predictable commercial law legal regime in India. And with this, I thank the organizers for this wonderful conference and inviting me here. And I hope my views might have been informative for the participants. Thank you all.
Thank you so much, sir, for your truly informative talk and highlighting the important concerns regarding and the comparative aspect regarding cross-border transaction, that too with the help of pertinent cases. Thank you so much, sir. Moving on to our next speaker. Our next keynote speaker is Dr. Manvendra Kumar Tiwari, Associate Professor of Law, Dharam Shastra, National Law University, Jabalpur. Dr. Tiwari has been teaching in the National Law University since 2008. He has served the Hidayatullah National Law University, Raipur for 2 years, and Dr. Ram Manohar Lohia National Law University, Lucknow for 9 years as an Assistant Professor of Law, before joining Dharam Shastra National Law University as an Associate Professor of Law in October 2019. He completed his LLB from Faculty of Law, Banaras Hindu University, Varanasi, and LLM from Indian Law Institute, New Delhi. He was awarded the degree of PhD in law by Dr. Ram Manohar Lohia, National Law University, Lucknow, for his dissertation titled Adjudication and Enforcement of Socio-Economic Rights under the Indian Constitution, a Critical Study. Dr. Manvendra has several published research articles and chapters in the reputed national journals and edited books. He has authored modules in PG Pathshala portal of UGC in subjects of law and criminology. He is a regular opinion piece contributor in Live Law, The Wire, and other web portals. His area of interests are jurisprudence, constitutional law, human rights, international law, and research methodology. I would now request Dr. Tiwari to deliver his address. Over to you, sir.
Thank you, Dr. Sakshi. And thank you to Amity University and Amity Law School for inviting me and giving me this opportunity and privilege to speak in this international conference on comparative law. When I was asked to choose a sub-theme on which I would like to speak, I had chosen judiciary and the constitution as the topic on which I would like to speak. Now, I have been teaching comparative constitutional law recently, so I'm not somebody who is very conversant with everything that is happening in comparative constitutional law, but based on what I've learned for my classes, I guess I'll be sharing something with the audience here. And if I can share a small slide that I had prepared. Is it visible?
Yes, sir, the slide is visible.
Okay, thank you. So, yeah. So when it comes to judiciary and the constitution, there is so much that can be talked about, and therefore I would preface my talk by telling you that I'll mainly be focusing my today's talk on constitutional review and the mechanisms that we have in comparative law and then try and understand as to how, and in particularly what circumstances perhaps our framers might have chosen a particular form of constitutional review that we find in our constitution, and also some reflection about its present state of affairs. Okay, so okay. Please excuse me, some repair work is going on in my university, right in front of my office. So that's why. Can you? Okay. Now, when it comes to constitutional review, we all know that our constitution has provided a mechanism where judicial review of legislations is also possible, and the courts have got the right and authority, the constitutional courts have got the right and authority to rule on the questions of constitutionality of legislations enacted by the legislature. Now, when you look at this mechanism, especially if you are only dipped in Indian constitutional law, then probably you tend to take it for granted that constitutional review of legislation by the constitutional courts is given, and probably there cannot be any other alternative to this. Okay, but if you glance through comparative constitutional landscape, you would realize that it is out of the available options of constitutional review, one option, though one can definitely say that it is one of the most popular mechanisms of constitutional review. But judicial oversight over legislation and the judiciary having the right to declare even legislative actions unconstitutional, and that declaration having a binding effect, this is not something that is the rule when it comes to the comparative constitutional law landscape. As you can see in this slide as well, I pointed out three different mechanisms that you find when it comes to constitutional review. And start with the legal and judicial constitutionalism, the one which we as students of constitutional law in India are familiar with. That is where the courts have got the right to declare on the constitutionality of legislations. So that's legal and judicial constitutionalism, where there is, when it comes to legislation and the finality on the constitutional questions of the legislation, the parliament is not supreme. Okay, it is the constitutional courts whose last word prevails so far as the constitutionality question is concerned. Okay, it is also interesting to note in this in the same respect that courts in India and elsewhere have taken this analogy of judicial constitutionalism not only to rule over the constitutionality of ordinary legislations, but they have even taken this this by analogy to even rule on the constitutionality of constitutional amendments, and therefore where is it? Okay, and therefore there can be unconstitutional constitutional amendments as well. Just give me a second.
Sure, sir.
Yeah. Okay. So this is one. Okay, legal and judicial constitutionalism, and then we have political constitutionalism. That's interesting. It is in fact another name for parliamentary supremacy, but obviously the sophisticated constitutional theorists have put it so as to reflect the modern day acceptance of the idea of constitutionalism, where the word supremacy of one organ of the state perhaps does not go along with the very idea of constitutionalism. And that's why they have replaced the word supremacy of parliament with the term political constitutionalism. Okay, and obviously they've also tried to bring in some of the measures which can be put in place in a setup where there is parliamentary supremacy, but at the same time we can say that the parliamentary supremacy does not mean a kind of autocratic legalism. Okay, so there is an effort to ensure that there is some mechanism to ensure that the parliamentary supremacy is actually replaced by political constitutionalism, and that's why, to guard against, the theorists have therefore pointed out towards a more acceptable notion of political constitutionalism. But what is important to underscore here is the fact that in such systems of constitutional governance, you do not have the constitutional courts having the last word when it comes to declaring on the constitutionality questions of legislations enacted by the parliament. That means if the parliament enacts a law, after all the necessary safeguards which may be put in place to ensure that the parliament having the authority to enact legislations does not actually reduce the system to a kind of autocratic legalism, but once enacted, that only the parliament can actually undo it. So that is the mechanism, that is also a kind of setup that is there. And in fact, you'll be surprised, some of you, I'm not obviously undermining the knowledge of the audience here, but some of you may be surprised, those who are not aware about the English legal system. You'll be surprised to know that till 1998, United Kingdom was having this absolute parliamentary supremacy when it comes to the constitutionality question over the legislations enacted by the UK Parliament. However, in 1998, UK Parliament itself enacted a Human Rights Act 1998, whereby the UK courts have been given this authority to declare not on the constitutionality of UK legislations, but to declare as to whether a UK legislation is actually consistent with UK's obligations under the European Convention on Human Rights or not. So that's a kind of judicial review mechanism. However, again, what an interesting thing to note here is that the declaration of the UK court on the inconsistency of a UK law with UK's obligations under the European Convention of Human Rights are not binding declarations. So these are simply a declaration, a judicial declaration, but it is not binding in the sense that it will not automatically invalidate the law as it happens in India. A declaration on unconstitutionality of a legislation automatically invalidates the legislation. That's still not the case in UK. So that is a kind of mechanism that has now been put in place there. Okay. So that is what we mean by political constitutionalism. But what you can understand from this is that perhaps when the framers of India were deliberating about the means of constitutional review that they would go with when it comes to the Indian Constitution, and they had this model of parliamentary supremacy and political constitutionalism coming from the United Kingdom itself, but instead they chose to go with judicial constitutionalism, and that to that extent perhaps it also shows that they were not very confident, and there was lack of trust when it comes to reposing that kind of faith upon the politicians who are going to be the lawmakers in our country. Okay. Whether it's a good thing or a bad thing, probably in the hindsight, we can say that this definitely was a good thing to be done, rather than bestowing that kind of faith upon the framers, upon the legislators, that they would always be enacting legislations which are consistent with the constitutional ideals. Okay, it's better to have probably in an Indian setup an independent judiciary taking final call on constitutionality questions, where obviously the unconstitutionality argument has passed the threshold where the judiciary needs to step in. Now, apart from that, there are also these days some hybrid models, which Professor Mark Tushnet, who is a comparative constitutional law scholar from Harvard Law School, he calls it dialogic constitutionalism. Now, by dialogic, it is a kind of midway where, and even what, if you look at what the Human Rights Act of UK has actually tried to do, it has actually turned the political constitutionalism into a kind of dialogic constitutionalism, where there is a declaration of inconsistency of UK law with ECHR is a real possibility, but at the same time, that declaration is not binding upon the legislature, and that declaration will not have the effect of invalidating the legislation. So therefore, the ball again goes back to the legislature in the light of the declaration of the judiciary to take a call as to whether they would still like to hold on to their argument of the law enacted by them being consistent with ECHR obligations or not. So that kind of dialogue situation which is happening between the legislature and the judiciary is what is called this dialogic constitutionalism. Canadian Charter of Rights is a very good example of this dialogic. The Charter of Rights, even if the legislation is inconsistent with the Charter of Rights, the legislation shall not be declared unconstitutional, and that power is especially there with the Parliament. And the fact that every 5 years there will be elections, this decision, if unpopular, the next government in power can actually obviously undo this. So these are the mechanisms, different kinds of constitutional review that were put in place to ensure that the actions of the legislature remain well within its bound. However, in political constitutionalism, it is for the legislature itself to take a call whether the legislative actions are well within the parameters of legislative action prescribed by the Constitution itself. Now, if you look at it, this particular thing, courts in nation, this is an important thing to note in the contemporary discourse that we are having, especially in India. Courts in nation where a single party dominates the system for an extended period rarely find national legislations unconstitutional. Okay, so what this particular statement from Mark Tushnet is actually telling us is that it's not simply the system that is put in place that works automatically to cater to the interest of the Constitution. Rather, we also need to keep in mind that court and the judiciary and our Constitution is very much intertwined with the politics that happens in any country. Okay, and as you can see, courts in nations where a single party dominates the system for an extended period rarely find national legislations unconstitutional. That does not mean that single party domination will result in formal amendments of the Constitution, taking away the very power of judicial review from the courts. But it is actually hinting towards the fact that the political domination can have such pervasive effect that even an independent judiciary, independent judges may actually not feel very comfortable declaring legislations enacted by that popular legislature unconstitutional. Okay, and that's something in the recent past, if some of you have been following the discourse that is there in comparative constitutional law, the most important thing that is being discussed at present is about democratic backsliding. Okay, everywhere you would find Indian scholars, European scholars, American scholars of comparative constitutional law talking about democratic backsliding. I was happy to see Professor Rosalind Dixon's name among the list of speakers who will be speaking in this conference. And very recently, she has come out with a book on abusive borrowings from comparative constitutional law in the context of comparative constitutional law, and how that has actually helped in this democratic backslide that we are seeing today as a global phenomenon. That's that's extraordinary, because what is important to note that unlike what you may have seen in some countries, for example, Hungary. Okay. Hungary is a country where recently the elected prime minister has, in a way, changed the judicial constitutionalism to political constitutionalism, or if I may again take the sophistry away, from political constitutionalism to judicial constitutionalism to autocratic legalism. That is what has happened in Hungary. But that's one of those rare instances where you would find that that single party domination, or one political party becoming so powerful that they have actually resorted to the route of constitutional amendment to actually alter the nature of constitutionalism in a country. What in fact has happened is the other way around. And what is that other way around that has happened? The other way around that has happened is the fact that that without there being a formal amendment, somehow courts, obviously because of the populism and the popularity of the government in power, have not been able to emphasize and enforce a constitutional authority which they otherwise possess. Okay, and you would know that even in Indian context, there is very strong criticism of the Supreme Court of India not undertaking the Article 370 abrogation till date. Not a single hearing has happened on the challenge to the abrogation of Article 370. Okay, when it comes to political funding, that petition is pending for more than 3-4 years now, and the court is yet to start hearing the political funding matter. You must be knowing that the former chief ministers of Jammu and Kashmir, they had filed habeas corpus petition, and they after more than a year, their petitions, habeas corpus petitions, became infructuous because they were freed by the very executive which had actually put them in custody, in preventive detention. And their petitions of habeas corpus after more than a year became infructuous. So why is it something where the courts, Indian courts and Indian Supreme Court also probably is not able to take up those high political stake matters? Are they actually going for deliberate abstention so as to avoid confrontation? And obviously the Supreme Court of India has an argument of pendency, that there are pending cases, and recently Vedi Center for Legal Policy has come up with a very, very important report telling us the pendency of constitution bench matters before the Supreme Court, and it's alarming. Yesterday only I was reading that there is a constitution bench referral pending in the Supreme Court of India, where the referral happened in 1986. Probably the Supreme Court judges have forgotten that in 1986 they had referred a matter to the constitution bench. Okay, so that also tells us that there is very, very poor management also when it comes to even constitution bench matters. Obviously that kind of delay is not expected. But what it also simultaneously reinforces is the fact that obviously pendency argument is real. Okay, and therefore the courts, if it is saying that there are matters pending prior to a particular matter that has come to the court, that argument is not without substance. But at the same time, we also know that there is this daily mentioning thing that happens before the Supreme Court, and the Supreme Court, based on its own judgment of the urgency of the matter, takes up those matters as urgent and decides on it. Okay, like I keep giving this example because I teach in a national law school, that an NCLAT matter was decided as urgent by the Supreme Court, and they decided it in 1 month. The order came that National Law School Bangalore, having decided to go for their own entrance test, going out of CLAT is wrong. Okay, so that NCLAT is is something which requires that kind of attention of the Supreme Court, that the decision has to come within 1 month. So how do you do that? Can we not say, based on that logic, that probably the abrogation of Article 370 is a matter which requires that urgent hearing? Or is it something where still the pendency argument will still hold the ground? I believe if at all mentioning and if at all urgency of the matter is a reason to actually fast track recent cases for hearing, then there is definitely a case for abrogation of Article 370 matter to be heard by the court. If that is the case, then probably there is argument, there is substance in what Mark Tushnet is saying, that if single party dominates the political landscape of India, you would find that when it comes to declaring actions of that government unconstitutional, especially the ones where the political stakes are very high, you would find a deliberate judicial abstention, a deliberate judicial avoidance. Okay. And that if that is the case, we don't know. We should trust the Chief Justice being the master of roster. That's not the case, and I would hope that that's not the case. But then, if you examine what has happened in India, in the hindsight, from the point of view of how it has actually played out in other places where the single party dominates the political landscape, probably there is a cause of concern. Okay, and obviously what is also important is that there is no formal amendment here. We are still judicial/legal constitutionalism, and yet we find that that a kind of judicial avoidance has perhaps crept in, where important constitutional matters have gone on the back burner. Okay, whether it is because of pendency argument. There's a very good article recently written by Professor Tarunab Khetan, published in the Indian Law Review, where he has tried to critique this pendency argument of the Supreme Court by saying that even this pendency argument does not hold ground, because the court has been rather casual in admitting special leave petitions, and therefore, if at all pendency is an argument, it is the Supreme Court itself to be blamed for adding to the docket, already existing docket, by actually being swayed by the presence of senior advocates who come at admission stage hearing before the Supreme Court. So that's also is food for thought. So that is it. I guess I have taken the time that was allocated to me. I'll be happy. I don't know whether there are questions or answer sessions or not, but I'll be happy to answer questions, if not here, in any other mode possible. Thank you very much, and thank you to the organizers for giving me this opportunity. Thank you.
Thank you so much, sir, for your captivating thoughts and uniquely articulating the different nuances of comparative constitutionalism. I'm sure scholars of constitutional law like me will be hugely benefiting from your talk. Thank you so much. Moving on, we'll move on to the next keynote session, keynote address. It gives me immense pleasure to introduce the next speaker, Dr. K. Shyamala, Associate Professor of Law, National University of Study and Research in Law, Ranchi. Dr. Shyamala was appointed as Assistant Professor in 2011 and Associate Professor in 2018. Prior to joining NUSRL, she was teaching at UPS Dehradun, NLU Jodhpur, and Sri P. Basi Reddy College of Law, Kadapa, Andhra Pradesh. She is appointed as Director, Research and Training since January 2018. She's a member of the research work conducted on the topic, a study on major bottlenecks in procedural laws affecting expeditious conclusion of criminal trials and measures needed to remove such bottlenecks, under the guidance of Judicial Academy Jharkhand, sponsored by Ministry of Law and Justice. She has held various positions at the university level during her service period. She has published 6 books and 19 research papers. She has presented research papers, delivered lectures in various international, national, and regional seminars, conferences, and workshops. She underwent various training courses organized by UGC, TERI for her professional development. She has also organized various programs at national, regional, and university level. With this, I request Dr. Shyamala to deliver her address. Over to you, ma'am.
Thank you, Sakshi. Whether screen is audible? Are you able to see the screen?
Yes, ma'am, we can see the PPT.
Good afternoon to one and all. First of all, thank you very much, Amity Law School, Noida, for giving me this opportunity. I was listening to Dr. Risham Garg, Dr. Manvender Kumar Tiwari, and my topic is also a sort of extension to Dr. Manvender Kumar Tiwari. When Sakshi mailed me that, you have to deliver lecture on comparative law, teaching constitution from almost like 12 years, though I am still a student, I always felt this topic is, is always a live topic, and always debate goes on. Even as on today, we have in January 2022, we had a judgment that how to interpret the term merit. So when you look at the context of affirmative action from the Indian perspective, comparing it with the United States of America, and thinking that where are we moving forward, which direction are we going? It's really, somewhere we feel like we are stuck somewhere, or we are entering into a vicious circle, right? So this is one of the area of interest of mine, and I think every other constitutional law professor or constitutional law scholar will feel like this is a area where dialogue needs to be opened. We need to educate the people that, what is actual and understanding of the equality, merit, and affirmative action, how we have to interpret it, how we have to contextualize it. So this is the judgment I was talking about. This is about, Neil Arroyo, Nuance, and others versus Union of India. This is the judgment which has been delivered on January 20, 2022. Here, Supreme Court said equating marks with merit is wrong. When this judgment came, or when this debate was going on, I was asking everyone, almost all, like, whoever I met, I asked them that, how do you look at the merit? Merit, marks. Even to our children also, we tell them that, if you want to be in the merit list, get marks, right? So this is a very common understanding, and this particular judgment, which is defining merit in a different perspective from different direction, has actually became a debate across the country, right? So what this judgment says that merit should be interpreted from the context of the constitutional morality, from the context of the constitutional values, especially when you are referring merit, when you are connecting merit with the reservation or the affirmative action or quota system. It has to have the feature of inclusive development, right? Merit is a property of humankind. Anyone should be permitted to walk into that particular, level, quota, and right? So what stereotypic understanding we had till date to the definition of merit had a blow, or this judgment really, broke that entire stereotypic approach. So here we can say that, competitive exams are, whatever the marks you are gaining is not considered to be, the concept of merit. So this particular blow led us to lot of debate, lot of discussion. People said that, order of merit, entrance test is nothing but a farce. The people who scored 99% are not able to get into the system. When in terms of the reservation, whoever is scoring 80%, say 80%, or 60% or 50%, they are able to get into the system. So people said, merit is being killed, there is a blow up on the merit and people are discouraged and so on and forth. So this is called the life of contradictions, which has been brought, which has been presented to us by this judgment, by the Supreme Court, that merit cannot be reduced to a narrow performance in the open competition, or competitive marks. High scores are not at all the parameters to decide who is meritorious, who should be brought into the meritorious quota, meritorious category, right? Now, where did it all go wrong? Where actually people started thinking that, merit is only related to only a few section of the society, where, there some section of the society can never ever have a merit, or can never cross that, bridge of, merit. Where this entire understanding went wrong. If you really look into, we are all, when I used to listen about, reservation when I was in my childhood, people used to say that, there is forward caste, there is reserved caste. So this forward caste is 50, will avail 50% quota, and that reserved caste will have 50% quota, right? Now, this 50% quota is sacrosanct. Nobody can touch it. That is whatever is having for the general category or forward category. And the remaining 50% quota is again sacrosanct, or reserved only for the backward classes. So this is the understanding which is there in general among the people. Now, further, okay, fine, people were going on in this direction. Even Indira Sahani was also like, was understood in the same way, that this 50 is for them, this 50 is for the others. So there's no way that, that this 50 can enter into that 50, or that 50 can enter into this 50. Now, this understanding was okay going on, but when EWS was introduced, then there was a debate that whether EWS is horizontal or vertical. Fine, ultimately there was a solution. Okay, fine, it is a vertical reservation. Now that 50% has been, which is being considered to be reserved or believed to be reserved for the general classes, is being reduced to 40%. Some sort of contradictions or debates, and then resentments at that time when 103rd Amendment Act has been brought in. Now, from where actually this 50-50 story started, we had M.R. Balaji, Devdasan, then N.M. Thomas, then Sabse Thomas judgment, and then Indira Sahani. M.R. Balaji, I just took only those points which are like very relevant to this 50-50 rule. The reservation should not exceed more than 50%. More than 50% reservation of course in a single year to be considered as unconstitutional. So here, this is one of the basic understanding from where we derived this concept of 50-50 strict compartmentalization. Then Devadasan again directed our belief to that level only. Even we taught to the younger generations that, this 50 is for them, this 50 is for others. Then when Thomas came, when first time the affirmative action has been introduced, there we started looking at, fine, this is an, whatever the exceptions which are considered, whatever the reservation policies which are being introduced are not the exceptions to the general principle of equality. They are actually facets of the equality, and then they're part of the affirmative action. So we can say that Thomas is one of the case in part. We actually introduced the affirmative action. Now coming to the comparative study, that Becke is another case in United States of America, which is exactly, people normally compare Becke with Thomas because both have come in more or less in the same period, where there also a debate about, in United States of America, the debate about the affirmative action was going on. We'll go to that particular part later. Now, when you look into the Indian scenario, this understanding of 50-50 continued even, after Thomas. But yes, when it came to Indira Sahane, again, though Indira Sahane clarified that, 50-50 is not an absolute rule, there are even some unavoidable circumstances comes into picture. This 50-50 can be overruled, or you can deviate from the 50-50 rule and move on to extend the reservation quota to the rest of the, even increase the reservation percentage. But what has happened? The people or they were focusing upon 50-50 in Indira. That is why, in 2020, the Supreme Court had to come forward to clarify that, Indira Sahane never laid down the absolute restriction or absolute 50-50 rule, right? So this many years, from 1970s to 2020s, we crossed so many years. This debate was never raised. Now, in Jayashree Lakshman Rao Patil, that is the case where actually they said that, never ever Indira Sahane laid down this 50-50 strict rule. Now, what has happened? Subsequently, this myth, that there was this breaking of the myth with the Jayashree Lakshman Rao Patil. Then you can say that Saurav Yadav and Giri and so on and so forth further added on by saying that this 50-50, no doubt, this 50-50 is not a strict rule. It can, the reservation percentage can be increased further. Then subsequently, when you are talking about the vertical reservation, the people who are meritorious reserved candidates can jump into the general category. Can be considered as a meritorious category, right? So this general category, what we prominently used to use for the for the 50%, which is for the general category or open category, we started using it as a meritorious category. And then this OBC, SC, ST, whoever are there as the reserved community, if they are able to show the merit and get into the cutoff of the meritorious category, then they were considered over there. And the court said that OBCs, SC, ST, the remaining people, whoever in the line in the OBC and SC, ST will get the opportunity. So this is to acquire the egalitarianism. The more and more you uplift them, the more and more they stop availing the reservation. Then what happens? The people who are below to them will be uplifted, and then they will be given the opportunity once they are exposed to the good living conditions. Then they will also be uplifted. At the end of the day, there will be a day where there will be no one from SC, ST, OBC who have to be uplifted. Then we can reach out to a stage where we can end the reservation. That is the idea of this entire egalitarianism or affirmative action, which is being reflected in the recent judgments of Saurav Yadav and so on forth. But what has happened that, despite of all this balanced approach, which the Supreme Court took from the day one about, visualizing how the reservation has to be taken forward, how the affirmative action has been taken forward from Thomas to till date nil judgment. Still, this debate of, these contradictions, what I was showing that, this murder of merit and so on forth, why these things are coming up? Because people are not able to understand actually or contextualize from which angle the Supreme Court is looking at or interpreting the reservation policy or the affirmative action. Now, one of the important points which we need to understand here is merit should be socially contextualized and reconceptualized as an instrument that advances social goods like equality that we as a society value. So they're saying that, you have to look at it from the perspective of constitutional values like, liberty, dignity, justice, equality, right? But still, why these things are not becoming, are not being to the taste of the people who are protesting against this kind of understanding? Because what I could understand with this is the structure. There is this central force, there is a central point. From merit side, they are the people who are from the forward communities. They started pulling because they're scared of the government policies. The more and more you are giving, more preferences to the reservation, more preferences to the that are interested in increasing the percentage of the reservation, then they're scared, they're feeling insecure. And the other way, we know very well historical background or something, already some vulnerable sections are there, they are already in need of some upliftment. So they are pulling on, either they are pulling or on their behalf the politicians are pulling. In both the ways, what is happening that constitution which is at the center, the constitutional values which are at the center are stuck somewhere, are being misinterpreted at the popular level or at the common man level, right? Everybody is questioning that why in NEET also you are providing reservation for the OBC, why there is no creamy layer introduced in SC and ST, right? So where actually this entire story happened, how to solve the vicious circle? So first thing is that, this entire story is about the Hindu caste system, social hierarchy, everybody knows about it. Untouchables, lowest caste, Manusmriti is one of the classic example where, that's where they started actually birth-based quota system. Further, interestingly, there is an expression which you can see in United States of America, that is Boston Brahmins. This expression reflects that Brahmins means the intellectuals are the Brahmins are the intellectuals, right? So this kind of understanding, this kind of, what you can say that visualizing that, about the intellectuality or merit is another problem which is prevalent in our society. Then, as we already discussed about 50-50 as an strict compartment. Now, when so there is an extended advantage to the reserved category. This is what is the demand or the debate which is going on. Now, lessened opportunities obviously will create a sort of insecurity in you, and Jat and Maratha story is going on. So at the end of the day, what is your vision about the equality? How you are going to look at this, merit, equality, and affirmative action? What is the best approach? If you look into this particular picture, equality, equity, liberation. So United States of America is moving towards liberation. We are, moving towards the equity. So what happens that even in the equity, this is the way how, we are providing the reservation, but still there is barrier but still there is a limitation. You can see here the hedge which is there creating the barrier, right? So unless and until we do not remove that barrier, we do not remove that sort of, limitation which is there, or which is asking us, demanding us for, affirmative action, or granting privileges, or continuing the quota system, what happens that we cannot reach out to this liberation, and we cannot end these contradictions. How to move about it, right? Is it possible to have absolute equality? No, not at all possible. Every man cannot be counted once and, not to be counted again, not to be counted more than once. So there is no universal law. All laws has to be discriminatory in nature. And obviously, all the discriminations which are unreasonable will have to face the constitutional invalidity. But the issue is that the way how you are interpreting the equality, how you have to carry out from equality to equity to liberation, is being perceived by Dr. B.R. Ambedkar from the day when the debate about the introduction of the reservation started. He said only for 10 years, but we are continuing for 70 years. That's also one of the, what you can say that, frustration which is in the minds of the general classes. But yes, the kind of social historical background we have in terms of the social taboos or social structure we had, but that has 500 years of historical background, and eradicating all those backdrops, or bringing, uplifting all the vulnerable sections within 50 years or 70 years is not technically possible. That's where, we have the stories like in midday meals, when Dalits are cooking in the schools, their hands were chopped, their hands were, burnt. So these kind of things are Varna, the existence of Varna system, or you can say that, Hathras case, all these things are examples that there is still a debate about, atrocities upon the vulnerable sections is still there. They needed a lot of protection and upliftment. So, but what Dr. Ambedkar said, with this constitution, we are entering into an era of, contradictions. So we have to, unless and until we do not, fight to reclaim the human personality, to reclaim the human dignity and the values, the entire story will be taken over by the political mottos. And then, everybody starts defining the reservation, merit, affirmative action in their own direction. Now, as a sort of, solution, what we can say are a sort of formula has been derived by the Honorable Supreme Court of India in terms of the doctrine of constitutional morality, which was actually visualized by Dr. B.R. Ambedkar, where, he said that, dignity, respect of the individual is the most important thing. So here, meritorious candidate, if a meritorious reserved candidate is considered in the merit quota or merit category, what's the harm in this? It's okay. We have already jurisprudence that it is only limited to public employment. There's a private employment. There is other situations also where we can survive, right? Immediate attention which is to be given is uplifting all the vulnerable sections, and at one day ending the reservation. So that is where we need to focus, so that we can have an inclusive development, which is again part of the constitutional morality, right? Now, with Dr. B.R. Ambedkar's dream of social democracy has to be realized, it is now time for us to realize it by respecting the individual dignity, right? So if you compare it with the United States of America, because it's, one of the comparative law context, we all know very well there is no need of explaining further that, their affirmative action is in a different direction. They said that, no, we are not, state is not going to provide any reservations or quotas. Rather, state will discourage the people to have the quota or the privileges in the public employment, or in the admissions, right? But still, Becky is one of the classic case. Before that, we can say that, this board of, one second, Brown versus Board of Education was the first, and then we have the Becky case. But Becky case left a door for, benign preferences to continue, because they permitted race-sensitive admissions, which again became, debating point in United States of America, that, equality, equal protection of equal protection clause has to be interpreted in a right direction, or in its constitutional spirit. So providing race-sensitive admissions is obviously creating a sort of blow upon the equal protection clause. So that story continued, and people started, comparing Becky with Thomas, and saying that, United States of America started giving quota system, right? Which was subsequently discussed in Grutter versus Bollinger. The most important thing in this particular case, Grutter case, is the dissenting opinion of Justice Clarence Thomas, which you can connect it with the 2022 judgment of the Indian Supreme Court. It says that the Constitution abhors classifications based on race, not only because those classifications can harm favored races or are based on illegitimate motives, but also because every time the government places citizens on racial registers and makes race relevant to the provision of burdens or benefits, it demeans us all, right? So, though a bit of connection, what we can see here is that they are also talking about promoting the individual dignity, right? The context of United States, the background of United States of America in terms of the India vis-a-vis the reservation is totally different. They have the racial discrimination, right? Okay, fine. There also the suppression was there. There also the discrimination was there. But still, what has happened that, in United States of America, from the day when they whatever the step they are taking, they discouraged government to provide any privileges. They were actually trying to create a sort of, equal platform for all of the people to compete and then to get into, right? Whereas here, when you look at the United States of in India, we went through the equity. So liberation versus equity approach in terms of implementing the equality is the difference which we can see in terms of United States of America and India. Now, to conclude, I think I crossed the time, or I don't know. I'll just move to the last slide. That is, we are with this judgment of defining the merit in a different context, or from the constitutional context. We again had to remind ourselves that we were in life of contradictions, we are in life of contradictions, and we are going to enter into a life of contradictions. And future in terms of equality, merit, and affirmative action in India is going to have another era, or you can see another height, right? So this is what I wanted to convey here. Any questions or anything, or if there are no questions, I request Sakshi.
Thank you, ma'am, for tapping into such an important area of affirmative action, and especially from a comparative lens, and sharing your unique perspectives on this particular topic. Thank you so much, ma'am. And I request all the participants to post their question in the chat box if they have any. We can take those questions at the end of the session. Moving on, our next keynote address speaker is Dr. Syed Hadi Mahmoodi, who's Assistant Professor of International Law, Faculty of Law, Shahid Beheshti University, National University of Iran. Dr. Mahmoodi is an Assistant Professor of Department of International Law, Faculty of Law, Shahid Beheshti University, Tehran, Iran. His focus is on international law and has published some works in this field. He teaches public international law, law of international organizations, state responsibility, and air. Excuse me. So Since 2018, he has been the Vice Dean for the Education at the Faculty of Law, Shahid Beheshti University. He is also a member of International Institute of Space Law, as well as representative of Ministry of Science, Research and Technology in the Subcommittee on Space Law and Policy of Supreme Space Council, Iran. I would now request Dr. Mehmoodi to deliver his address. Over to you, sir.
Thank you very much. Good evening, all distinguished participants and dear colleagues. I want, first of all, thanks Amity University and the other stakeholders for inviting me, especially dear Dr. Takashi, for being in this great conference. It's an honor for me to be here for the second time, I think. Of course, a couple of years ago, I have been in Amity University. I had good experiences. On those days, I was in Amity University, so I'm very, very grateful for being in this conference. So my presentation is about anti-pandemic measures under the constitutions of India and Iran. Let me start with some introductory remarks. Globally, some catastrophic moments in the world, all around the world, and also very, very tragic events in India, in Iran, and all other countries. There are some, death because of pandemic, and also parallelly there are some vaccination, and the more vaccination, the less the threat to the life of persons. I would like just to show, I don't like to mention just the rate of death globally in India or in Iran. Just I want to first of all show the situation, the current situation, which hasn't finished, and we don't know what the time is finishing. The main question is that what approaches have India and Iran taken to counter the COVID, and are these approaches constitutional or not? First of all, as you know, we have this knowledge that public health emergencies in India as a federal state are dealt with jointly by the central and state governments, while these actions in Iran are decided by just central government, and the other provinces have very little role in this moment. They are some commonalities with, they have some commonalities with the situation, and that's the different interpretation of constitution. Let's say the marginalization of parliaments. Also, we should remember the legal maxim salus populi est suprema lex, or the welfare of the people is the supreme law. That's why the state should somehow balance between the rights, human rights of persons, citizens, with those powers and discretions that can suspend and limit those rights. The question is that, are these two countries successful in balancing these two dimensions? First of all, we should say that national governments around the world have suspended or restricted some human rights, like suspension of people's freedom of movement, restrictions on freedom of information, closing schools, businesses, and places for worship, all in the name of public safety. Before getting into the constitutions, I would like to share some remarks on the international human rights law perspective, because both states are members of International Covenant on Civil and Political Rights 1966. and they are obliged to respect those provisions, and particularly human rights. I would like to say that international human rights law has not defined crisis situations or emergency measures, and only limited some restrictions. We should look at the Article 4 of the International Covenant on Civil and Political Rights, ICCPR, which states that in time of public emergency, which threatens the life of the nation and the existence of which is officially proclaimed, the state parties to present covenant may take measures derogating from their obligations on the measures are not inconsistent with their other obligations under international law and do not involve discrimination solely on the ground of race, color, sex, language, religion, or social origin. Also, some rights are not derogable, which I think I have some, I have said in this slide. State parties cannot derogate from the right to life, prohibition of slavery and torture, and freedom from retroactive legislation. Also, some other rights about the inability to fulfill contractual obligations. It means that all other rights, except those I have mentioned, may be derogated during emergencies. Besides derogation, even when a state doesn't declare a state of emergency, ICCPR let that state to restrict some rights. That's the right to manifest or practice one's religion, freedom of movement, freedom of assembly, freedom of association, freedom of expression. Adding that, obligations of state parties on the other covenant means International Covenant on Social and Cultural Rights, that states are obliged to, protect the public from epidemic diseases. So let's check the Indian Constitution and the approach which have been taken by the state. Article 21 in the Indian Constitution states explicitly the citizen fundamental right to life and personal liberty. Also, there are some other related, health-related rights in the Constitution, which due to time shortage, I will not mention about it. But in particular, right to health have not been mentioned specifically and independently in the Constitution. But if you see the judgments of the court, the Supreme Court, they somehow relate the right to health to the other human rights, like the right to life and personal liberty. What has been stated in the Constitution of India about the emergencies? There are three emergency. There are three kinds of emergency: national emergency, state emergency, financial emergency. What about the health emergency? I should say that Constitution, the government has not applied the state of emergency because the Constitution specifically authorizes the president acting upon and because of the overlapping this box with the slide. somehow I paused. Yes, to declare an emergency. So an emergency must ordinarily be ratified by the parliament within a month. I should say that this article has not been applied in a pandemic situation in India. Rather, the government, has taken another way and has relied on some national laws and some executive orders. So during the pandemic, central government has taken the decision to control COVID-19 as largely dependent on existing legal tools like the EDA and DMA, which is Epidemic Disease Act 1897 and Disaster Management Act 2005, and some other related laws like Indian aircraft public health rules, also criminal law. The problem is that these acts do not contain detailed provisions on the procedures or steps to be followed by the central or the state when fighting a disease. This is some detailed stuff about the specific invocation of Indian government to the Disaster Management Act, while creation of executive order, Ministry of Home, and a series of other executive. The Constitution, in spite of the fact that has potential burden for government, but Indian somehow marginalized, I think, the Constitution and rather relied on the national ordinary laws. What about Iran? So Iran has taken different view, I think, in comparison with Indian practice. First of all, we should say that Article 3, according to the Article 3, one of the goals of the government of Iran is the planning of a correct and just economic system in accordance with Islamic criteria in order to create welfare, eliminate poverty, and abolish all forms of deprivation with respect to food, housing, work, etc. We also have an article in Constitution of Iran about the state of emergency. Article 29, which states that the proclamation of martial law is forbidden in case of war or emergency conditions akin to war. The government has the right to impose temporarily certain necessary restrictions with the agreement of the Islamic Consultative Assembly. In no case can such restriction last for more than 30 days if the need for them, etc. Not important, this part. But another, the message for this article is that a prohibition of martial law and imposition of necessary restriction by the government with the permission of the parliament. Here we can see in the Constitution the role of parliament, but again in practice, there is very, very few role for Iranian parliament in dealing with pandemic. Instead, what has been taken, the road has been taken by Iran is the establishment of national headquarters for coronavirus control under the supervision of Supreme Council for National Security. So in Iran's perspective, pandemic and COVID-19 has a more security dimension than the other dimensions. So they are questionable whether these steps have been constitutional or not. Apparently, there are some provisions. They try to make it constitutional, but according to the rule of law, it is questionable. Briefly, if I want to fit this presentation, the national approach to pandemic in India and Iran could be pandemic as a security threat, which is taken by Iran, pandemic as a crisis, disaster, which I could say India has taken such things, pandemic as a state of emergency, which none of these states had taken this approach. And the last slide is the perspective. The problem is that both states and also some other states, I think, should rethink about legislative measures to deal with pandemic, because we don't know what time is finishing. The situation may be altered. I hope it doesn't, but maybe show in another way. Maybe the world has another peaks. So they should think about the marginalization of the role of parliament, less India and, I mean, more Iran and less India, because they have a different view about the national ordinary laws. The other point is that the public health emergency does not give license to government to cast aside their obligations to uphold fundamental rights and liberties. And there are some threats. Democratic or semi-democratic states are in danger of authoritarian political behavior in pandemic. So pandemic can threaten democracy. So they think they should think about these matters, which I mean, think about the rule of law and acting under the provisions of their constitutions. And apart from medical preparedness, legal provisions play a significant role in managing and controlling the disease. And the last is the rethinking of global legal norms pertaining to public health pandemics. I mean, they should strengthen their health law systems, both in process and in substantial matters. Thank you very much. I'm very, very honorable to be here. And thank you, Dr. Sakash.
Thank you, Dr. Mahmoodi, for this very stimulating talk and highlighting important legal nuances and approaches taken by two different nations regarding the COVID-19 pandemic. Thank you so much, sir. Moving on to the next speaker, our next keynote address speaker is Mr. Vikrant Rana, Managing Partner, SS Rana and Company, Delhi. Mr. Rana is the managing partner of SS Rana and Company, a premier intellectual property law firm in India. Mr. Rana read law at the University of Delhi in 1996 and is enrolled as an advocate with the Delhi Bar Council in 1996. He's an advocate on record with the Supreme Court of India and registered as a patent agent in 1998. He has been litigating in courts all over India, primarily at the Supreme Court of India, various high courts across the country, trademark registry, patent office, intellectual property appellate boards, and the Copyright Board of India. As an experienced IP attorney, he superheads the team at the firm, which includes specialists in law, chemical, biotech, and electronic sector. Mr. Rana has been providing legal advice to many Fortune 500 companies and has some of the world's most esteemed corporations on securing, protecting, enforcing, and exploiting their intellectual property assets in India and world over. He's actively involved in sensitizing awareness on intellectual property rights in India and associated with several governmental organizations, including TFAC, Department of Science and Technology, Patent Facilitating Centers, Patent Information Centers, FICCI, Ministry of Small Scale Industries, CII, WIPO, TERI, IIM Ahmedabad, BHU, etc. And is a frequent speaker and panelist in seminars and conferences conducted by these organizations. He has been nominated by esteemed clients for the ILO Client Choice Award 2012 for providing exceptional legal services pertaining to intellectual property law. He was nominated in the category of Managing Partner of the Year by Legal Era and ALB SE Awards. With this, I request Mr. Rana to deliver his address. Over to you, sir.
Well, thank you so much for that kind introduction, Dr. Prashar and Dr. Singh. Thank you so much once again for inviting me to be part of this esteemed international conference and share such distinguished academicians. It's a privilege that probably I'm the only on the practicing side and rest all were academicians on this particular panel. So my topic today, I wanted to pick up a different topic in the sense, what business and law, the culmination where they would kind of meet in the current scenario. And the topic I've taken for today is the future lies in the virtual world. We are all living in this connected world where things are online, most of the things are online. And we are hearing a lot of, these words like metaverse, crypto, digital assets. So I just wanted to share, what India and other countries and jurisdictions are dealing with these kind of online digital assets. And this is an attempt to give a basic introduction to those assets and metaverse, and then take it to see what experiences India could learn and lead in this particular field of digital assets. Let me start with the famous song by Freddie Mercury, Queen, the Bohemian Rhapsody, where he mentioned, "Is this the real life? Is this just fantasy? Caught in a landslide, no escape from reality." That is what it is now. It's what is real and what is not is going to be very difficult in the times to come. As we get into the augmented reality, the virtual reality, a lot of things will come together and we will not know what is what. So it's quite interesting times and great times to be living in. I think we all remember recently there was an article about a young couple getting married in the metaverse, and this was January last month only. And Dinesh SP and his fiancée Ramaswamy, both 24, were the first ones to celebrate their marriage in the 3D virtual world, which was as they were both Harry Potter fans, they had done it in that particular background. And in fact, they also invited the bride's late father, who joined them as an avatar, and many famous people also joined the wedding. So there we see the how the two worlds, the real world and the virtual world, coming together, and how people can and would be sharing their information and thoughts there. Another example is of JP Morgan, which claims to be the first bank into the metaverse and looks at business opportunities. The Wall Street Bank opened a lounge in the blockchain-based Decentra lab. So we are seeing these examples not only from private individuals, but also companies trying to woo the next generation consumers and customers who are more more acceptable and ready for this new change, which we will be seeing in the days to come. So these are some examples where we see, the companies who are already launching or in the process of launching online stores like Forever 21, Gucci, and other stores who are either selling virtual assets or they're looking at even selling normal assets through this virtual metaverse. And recently, we also saw many brands across the world filing for metaverse related applications. And in fact, in India also, we have seen some of these brands file for these virtual assets, virtual products being filed, being protected under the trademark law. Just a few examples here on the IP side. What we saw that DKNY, they filed an application on 17th November 2020. That was almost 1.5 years ago, regarding downloadable virtual goods, namely computer programs featuring clothing, colors, badges, and tools for use in online virtual environments. And also in class 41, for entertainment services, namely providing online non-downloadable virtual clothing, colors, badges, and tools for use in virtual environments created for entertainment purposes. So we have seen that, since late 2020, companies have been looking at protecting this IP, not only just making alternate virtual system, but also to protect IP in the current scenario, but also in the virtual world which they intend to create. Then we saw that Puma also filed an application on 11th January this year for downloadable virtual goods. So a lot of them there, you can see a lot of goods they have filed in the virtual domain. And they are one of the few early ones who have looked up and are protecting their trademarks in the virtual world also. Then this application filed by Nike on 27th October last year, again for downloadable virtual goods, namely computer programs featuring footwear, clothing, headwear, eyewear, bags, and so and so. So not only the general public, but also the corporates are looking at, making the first move in this changing scenario of the metaverse. I think even during the budget speech this year, we had the finance minister talk about the digital assets, and we have seen these terms which have been trending this year and the last year or two: NFT, metaverse, crypto, blockchain, virtual and augmented reality. And these terms would get more and more common now. We are hearing them on radio, we are hearing them on the TV, and we would expect them to really grow in the coming days too also. So Mark Zuckerberg, he actually had come out with a statement called, I believe the metaverse is the next chapter for the internet. Initially, when the internet was launched, it was more of a communication medium with emails and basic sharing of information. Then the second generation could have been the online shopping, the revolution we had there. And now with this metaverse, that can be really said to be the next chapter for the internet, where we will be living in a virtual reality, where things would be in the physical world and they could also be there in the virtual world. And everybody's trying to go and find their 2 cents in this particular chapter of the new internet. As we crunch into 2022, so terms like meta, metaverse, augmented, Oculus are on the tips of every tongue. And with this likely paradigm shift in the world of internet and AR, VR, we are moving to a new era of human development. However, with every such shift comes a plethora of legal issues and questions which need to be explored. This really reminds me of the Scorpion, the band rock group Scorpion, and their song, a very well-known song called 2 Steps Behind. Law in most of the cases is always 2 steps behind business, technology, and society. And whenever there is a change, and as society or technology or business evolve, law follows, and law is, we try to fill in the gap if there is any, and law comes in to fill in the gap on the legal front for the changes in the society per se. So that is what we would be expecting in the new, the new scenario we are looking at of metaverse, that countries around the world would be looking how to, manage, regulate, or see how this could be done, and the rights are also protected of consumers and right holders. Legal developments regarding NFTs in India. So there's no particular law which regulates NFTs in India as of now, but laws have been in the making to regulate crypto at least. For crypto, we have the Cryptocurrency and Regulation of Official Digital Currency Bill 2021, which is pending with the Lok Sabha. As per the 22-23 budget, the Union Finance Minister did announce that income from virtual assets shall be taxed at 30%, and on percent TDS shall be deducted on these investments. So there's already a move to to identify and to also to tax these virtual assets as per the tax laws. And while defining virtual assets, the government included any instrument which is generated through cryptographic means, providing a specific digital representation. So that is a good wide definition to cover a lot of different products which could come under the virtual assets, the digital assets as contemplated. Talking about the Cryptocurrency and Regulation of Official Digital Currency Bill, it intends to prohibit all private cryptocurrencies in India, but has certain exceptions which qualify promotion of underlying technology of cryptocurrency and uses thereof. However, considering that NFTs are technically not cryptocurrency and unlike cryptocurrency are not fungible, they may prima facie not fall under this proposed law. However, under the FEMA Act, NFTs may qualify as intangible assets which may be recorded within global ledgers, making determination of location essential. So these things also lead us to the question, how would these be looked up? How would the valuation of these NFTs also come into play? I mean, how do you value those NFTs? Would they be one of the sources or the ways for money laundering? I mean, there's so many questions which would really come up in the next months or years regarding the metaverse and those digital assets, the virtual assets, and how it would pan out is anybody's guess as of now. So exploring this particular new world, and the legal issues and questions which may arise due to these developments and plans, we thought we'll just cover a very brief introduction to NFTs and the related terms. So metaverse is not a new term. In fact, it's almost a 30-year-old term, which was coined by the famed author Neil Stephenson in his 92 science fiction novel Snow Crash, where he referred to metaverse that may be construed as to allude to a world or conception that requires the real world in order to move beyond it and acknowledge another realm. Then we've had a number of video games where you are living in that kind of another realm and in the virtual realm. For example, the Second Life video game, Ready Player One, which is a book and a film, The Matrix, the movie, Black Mirror, The Good Place, various MMORPG games, including League of Legends, Final Fantasy, Counter-Strike. So these are just some of the examples you can see where these things have already been talked about or discussed or shown on TV and movies. Oxford has actually defined metaverse as a slang term used to describe a virtual representation of reality implemented by means of virtual reality software. So in this context, it's important to really understand probably from an example which really shows how it works. The example of Second Life by Linden Labs is a great example for understanding what the term metaverse entails, and more importantly, the future possibilities as well as legal issues which may arise in this context. So Second Life is essentially a digital world on its own, a plane of existence which can be accessed by creating your own avatar or digital representation of yourself on the online platform and entering the world. So it comprises of worlds where people lead parallel or concurrent lives, as in from the physical world as well as the virtual world, and do what all they would do in their real lives. For example, have a job, do shopping, socialize, have romantic relationships, get married, attend classes, go to office meetings, and take your pets out for a walk. So it's a kind of a replication of your normal life into the virtual sense, and that is, that gives a real good indication what things are, and probably what things will really get more deeper into this metaverse. As such, the above mentioned digital world, which still exists and has millions of active users, can be thought of as a base about what the metaverse is all about. Except the new conception of the metaverse has a capitalistic aspect to it, and there is far more emphasis on economics and marketplaces. Like I said, internet, I mean, the second wave could have been on the online shopping, where it was again the capitalistic and the economics which really dictated how it panned out. That is what is expected to be in the metaverse space as well. Talking about metaverse again, there is no single metaverse. Rather, as per the definition and conventional notions about the term, many metaverses already exist in the form of various platforms such as the above mentioned Second Life, Microsoft Mesh, Facebook's Horizon Worlds, etc. So therefore, the possibilities of metaverse in a commercial aspect are endless. And once commerce comes into play, legal issues would definitely crop up on the corporate side also. So imagine browsing a 3D rendition of a superstore from the comfort of your home with advanced AR and VR technology. Wearing those glasses, you could feel that you're sitting in a showroom, or probably walking around the aisles in a showroom and picking up your favorite products and buying them from the comfort of your sofa itself, but still having the look and feel of moving around in a showroom and buying products as if you were actually in the physical shop itself. Similarly, replacing office space with virtual workspaces where you are still sitting at your home in this work from home environment, and yet have the feel of working at your desk in your office and interacting with your co-employees in that virtual space. So it would be still a work from home, but yet the feel, the exposure, the feel factor of working at a proper office would still be there. Another example could be of a digital vacation in a faraway land, where you could be, just by wearing those glasses or getting into that virtual reality, you could be, going places, looking at different monuments, different places, and from the comfort of your home and without actually going to those places, which could be good and bad both. I mean, it may be reducing the carbon footprint, but the commerce around that tourist place would go down. So how do you balance those rights? Again, would be one of the many questions which would come up. Like I said, with great strides in humanity, there would also come problems. And how do we tackle those? It's difficult to answer as of now, but I'm sure that a lot of solutions being looked at, a lot of theories coming up, and law would evolve with the system getting evolved. So in such a virtual metaverse, who would be the authority inside the world? Who would really make the rules? Who would regulate? And would it be the persons who make it, or it would be the government, or it would be a global authority? So those questions would slowly start coming up. How would a case of trademark infringement inside a virtual world be tackled? Who will own any IP which will be created inside the metaverse? These are some questions which could be there. They could be, similar to what would be in the physical domain, but there could be some different aspects to it, which would come out in a better way once these virtual realities are further developed. NFTs, again, these are interesting things. A non-fungible token, that is NFT, is a unique form of a digital asset which cannot be replaced by something similar. So it's one of a kind, based around a blockchain technology, most notably the Ethereum blockchain. An NFT is a digital collectible, be it an image, a GIF, an audio video file, an element in an online game. So what exactly does one get by buying an NFT? When I buy the first tweet by Jack Dorsey, what do I get? Do I get the tweet? Do I get a copyright on it? What exactly gets transferred? So that is the question here. So does the transfer of a famous NFT such as that of the Bored Ape entails transfer of copyright? Does the buyer actually own the digital item? That these kind of questions would come up, and we'll see how we can answer using the current legal system and how they would be in the future. And is NFT a cryptocurrency? Well, although NFTs are based on blockchain technology, similar to cryptos like Bitcoin, but they may not be. So to oversimplify, it is one of the strongest certificate of authenticity out there, but yet it may not be a cryptocurrency there. And what can you sell as NFT? Like I said, it could be anything. It is up to the creativity of the creator or seller. If a GIF of Shiba Doge can rake in millions, the sky is certainly the limit. We have seen GIFs, JPEGs, video, music, everything is being traded, being sold in the metaverse. So what is the inherent value of an NFT? Again, that's a very question right now, which probably right now the tax authorities may not be looking at, but they would certainly start looking at the valuations they are being put for NFTs, how the money is transferred for those NFTs, and the tax deduction at source, as well as the taxation of the virtual assets. That would really show that the valuation is more realistic and not a way to really launder money using the NFTs there. The example I mentioned earlier, Jack Dorsey's first tweet. So that was sold for 2.9 billion there, if it's millions there. So that was just the first line, just setting up my Twitter. That was sold for 2.9. And, and what actually did he buy? The buyer was Sina Estavi from Oracle, brand Oracle, I think. And of it, considering that the work is publicly and freely available online. So the work is already there. You don't get a copyright on that. You just get a token, the NFT. He got the stamp of approval that it's a non-fungible token, which no one else can claim to have. So he can claim that I have the token to the first tweet. He doesn't have the tweet. He doesn't have the copyright on the tweet, but only a token to identify that this was the first tweet. So it's something which is coming of age. We will see more of these coming up without getting the right. For example, getting the copyright there. It's more on the copyrighted work. And that to the first copyrighted work, because there are subsequent, and these are still on the internet for anybody to go and see. Conclusion on this part would be that metaverse is the future of the internet. That is, there's no denying to that. We would see a lot of lot of debate, lot of interaction, lot of discussions on this, and how law would adapt to the evolving society and business will be interesting to see. And AR, VR will see great leaps in tech development to accommodate these lofty ideals of metaverse. They have to go hand in hand. The technology would have to be there to be able to use it in more commercial and capitalistic sense. And the challenge will be to make the metaverse accessible to the common man. So right now it's not that common. That would depend on the technology, like I said earlier, on the AR and VR. And once it gets to the common man, then it would really roll out to the big numbers and commerce, which is the intention to really play on. And so one cannot just buy headsets worth thousands of millions to immerse themselves in the meta. The time is ripe to secure one's IP rights in the metaverse. So therefore, it's important that companies and persons are looking at buying their or getting their IP rights in the metaverse domain, so that the rights are protected as per the current regimen of law, but also be abreast with the changes and file accordingly to different set of laws which would evolve gradually. I'll just briefly run through the brief, on the different jurisdictions on the cryptos. Give a comparative angle to the crypto regulations across different countries and jurisdictions. For example, in EU, markets in crypto assets regulation was published on 24th September 2020, which proposes to regulate currently out-of-scope crypto assets and service providers under single licensing scheme. This is anticipated to take effect in 2024 and would be applicable to all member states and non-EU states planning to conduct business in EU. So that's important for to see that, keep a note on that. And obligations would include publishing prospectus like crypto asset white paper. However, although NFTs are considered crypto assets, their issuers would not be required to publish such a white paper. Germany, the crypto assets within the meaning of the act have been considered as those instruments used for investment purposes, and since NFTs can qualify for the same purpose as well, basis their value creation character, all NFTs will not be cryptos, but cryptos would have some angle to that. So in this respect, the trade-related activities of NFT may trigger a license requirement. And under the German Capital Investment Act, NFTs may find coverage as investment products promising an interest payment, repayment of invested capital, or a cash settlement in exchange for an investment of capital. Coming to Italy, the Directive 2018 of 843, AMLD 5, under the definition of virtual currency through issuance of legislative decree 125 of 2019. So Italian Consolidated Financial Act covers the NFTs as investment products, and they may be considered when held for investment purpose and transferred, stored, and traded electronically, but not used as a means of exchange. Under this act, NFTs may qualify as investment products too, which qualify for capital disbursement, expectation of financial gain, the assumption of a risk directly linked and correlated to the capital disbursement. However, these depend on the characteristic of each NFT individually. Finally, coming to China. So in contrast to India, China has been actively regulating activities related to cryptocurrencies and crypto assets, but there is no unified regulation or framework therefore, and the rules are spread out in the forms of various circulars and notices. So essentially, the government there is trying to, due to free trading aspect of cryptocurrency, has expressed its displeasure in indulging therein and has banned the cryptocurrency trading and mining. The ISO 2017 circular, they revealed unprecedented regulatory clampdown on crypto assets, leading to supervisory and enforcement actions taken in respect of crypto-related activities. There exists no specific definition of cryptocurrency or crypto assets under the laws there, which has been highly localized to suit the highly stringent regulatory framework. China has introduced blockchain-based technology for NFTs through a Chinese state-backed company called Blockchain Services Network, which adapts blockchains from Ethereum and 9 other platforms to meet regulatory requirements in China and ensure non-occurrence of illegal activity. The NFTs shall be traded using only yuan and not cryptocurrencies. I believe that was a basic comparison and introduction to metaverse, and I hope it was informative and useful for the audience there. Thank you so much.
Thank you so much, Mr. Rana, for this very vibrant discussion and talking about the new aspect of metaverse and virtual reality. I'm sure it must have been very, very informative for the students of IP rights. Moving on and coming to the last keynote speaker of the session, I welcome Dr. Irene Calbolay, Professor of Law at Texas A&M University School of Law, Texas. Dr. Irene is a Professor of Law at Texas A&M University School of Law, Academic Fellow at the School of Law, University of Geneva, Fellow at Melbourne Law School and Transatlantic Technology Law Fellow at Stanford University. She held visiting positions in several universities in North America, Europe, Asia, and in 2018 was a Fulbright Specialist Scholar in Cambodia. Dr. Irene's research focuses on IP, international trade, and cultural heritage law. Her most recent books include Exhausting Intellectual Property Rights, A Comparative Law and Policy Analysis, The Protection of Non-Traditional Trademarks, Critical Perspectives, and the Cambridge Handbook of Comparative and International Trademark Law. She's a member of the editorial board of the Queen Mary Journal of Intellectual Property, the Journal of Intellectual Property Law and Practice, and the WIPO WTO Colloquium Papers. Dr. Irene is elected member of American Law Institute and serves in leadership positions in a variety of professional organizations. She's also regularly acts as an expert for national governments and international organizations, and she has conducted missions for the World Intellectual Property Organization, the EU Intellectual Property Office and Commission, and several national IP offices. With this, we welcome you, ma'am, and we request you to deliver your address. Over to you, ma'am.
So many thanks. I am very happy to be here with you today, and I apologize because I couldn't listen to the beginning papers of the session because we had a medical emergency, so I had to be at the doctor's office. And so I want, first of all, again, to congratulate the organizers for this very well organized conference. I enjoy the presentation that I have attended. The NFTs are certainly one of the hot topic of today, and discussing the metaverse is something that the new generation of lawyers and scholars should do. I was asked to briefly address the audience about comparative and intellectual property in a comparative and international law setting, which is what I do regularly for, and what is my area of expertise. And so this conference is dedicated at large to various topics in comparative law. And the vast majority, if not the, more or less all the speakers are from India. I have heard some comparative approaches in your methodology, and I commend you for that. I think, I teach comparative intellectual property. I teach US intellectual property. I work with the European Union Intellectual Property Office as well. And I'm based in Asia. I'm based in Singapore, and what I hope you can gather and you can take away from this very short remark I'm going to make today, and I don't have a PowerPoint for once, is that and I think I'm preaching to the choir here in India. Comparative law in every field is important. It's even more important in technology, intellectual property, areas that, as you just mentioned in some of your presentation, really has no boundaries. Think about the metaverse. Well, which law will govern it? We don't have a territoriality, we don't have geography. And even when we talk about brick and mortar worlds, we still need to have harmonization of rules to allow the movement of goods, the movement of people, the movement of services, and so on. Intellectual property is probably the area of law that early on, probably one of the first, if not the first, areas that got very considerable comparative attention and harmonization. The Paris Convention, the first draft, the first approved draft was in 1883. So, almost 150 years ago. The Berne Convention for copyright was 1886. Even though disagreement back at those, during those times were largely negotiated between the European and the North Atlantics in some way blocks. Even for a country like India back then, of course, a colony, a lot of these synergies and interaction were important. When we had India still part of the British Empire, India has all sort of circulation of goods and intellectual property provision coming directly, from England, from the United Kingdom into India as well. And so intellectual property from the very beginning, from still, the Indian, the tea companies and the trade in tea or in raw materials, has always been very devoted to facilitating movement of goods. Goods continue to travel via shipments. We know the issues with disruption of supply chain, as well as they travel, through the metaverse or through digital technology. And no matter how goods travel, to have similar laws in different countries is crucial to conduct trade. And we can go even go much earlier than the Paris or the Berne Convention. I'm sure you are familiar with the Lex Mercatoria. Lex Mercatoria is comes from the medieval time, in which the merchant on the routes of trade, largely European, but still also beyond Europe, because a lot of trade was coming from Asia, China, India, and coming through. The stories of the expedition of Marco Polo are real. They're not just just fairy tales. And because of that, we had agreements between traders in different jurisdictions to apply similar laws. And so what happened, as you all know, with the creation of nation states, initially nation states are different than what they are today because the geography of the world, mostly in terms of colony, was different. But when after World War II, the world started to look more as it is today, hopefully stays at this point as it is today, we have started to see even more push for harmonization of intellectual property laws. And so based on a principle of territoriality, how does, in which nation state make and apply their national law, how does comparative law interact, and what's the role of comparative law? I've written extensively about that. We could even debate whether comparative law is law in general. Some might say comparative law is just methodology, because what we do in comparative law, we compare, two different systems instead of developing new law. There is, of course, an epistemological, a variety of materials that we are using in the comparison, but still, comparative law in itself doesn't have a code, doesn't have rules, only compares two different types of laws, jurisprudence, legislative development, and so on and so forth. But comparative law is absolutely crucial in our field and in every field to understand how the international development are conducted, what new approach, what revision of old treatises should be implemented. Comparative law is more than just law. It's law in society, it's law in economics, it's law in technology, and so on and so forth. And so the value and the absolute relevant role in our field with respect to comparative law can never be understated. I teach in the United States, which is notoriously a country that follows, many good principles, but some also very nationalistic, in which, in my view, there should be, particularly in the academy, much more attention to comparative everything, comparative IP, comparative environmental law, comparative constitutional law, and so on and so forth. I hope the main takeaway for you is India does at this point look outward, very much so. India does focus a lot on comparative because, of course, India has implemented a lot of the national laws of the United Kingdom or national laws of other jurisdictions. India has implemented international treaties that were not negotiated or not only negotiated by India, and so wants to see how to fine-tune these, when they have to be implemented, at the national level. But certainly India is a major continent. It's not just a country, it's a continent. And it's a continent that is roaring and developing fast. And in many ways, it's also becoming a leader in legislation. Think about patent law, Article 3D, and the different standard for obviousness that India has later, by adopting this standard, has later exported to Indonesia or to Brazil. Both these countries have taken the Indian approach, for example, and introducing their own legislation. And so the comparative part in India from Indian scholar remains absolutely crucial in two ways: learning from what are the other systems and how the other system can inform or do inform or add informed the Indian system, and how the Indian system later can inform future developments in intellectual property law in general. And this is really something that I think every Indian scholar should consider. When we look at Indian law, we also look at the international agreement that are at the basis of that specific Indian legislation. Then we look at the national decision that interpret the national law. It's also relevant to make comparison, and comparison not just only always with the United Kingdom or the United States, but also make comparison with civil law jurisdiction, make comparison with other smaller common law jurisdiction, former British colony as much as India, that might have similar or almost similar, but yet a bit different experience. And so we can always learn from what's going on, both from a social, economic, and legislative standpoint in jurisdiction around us. And so, my comment, I really again commend the organizer of this conference, because I think thinking comparatively, it's a very important exercise. It's an exercise that has to go down to the core of legal education. I grew up in Italy. I went to my university, my undergraduate degree, my LLB, I've done it in Italy at the time when the European Union was enlarging. And so, and a lot of laws were being changed. And so the Italian system, the French system, the German system had to implement European directives. And Europe has a very interesting way of creating law through a binary track of directly applicable regulation and needed to be implemented directive. Europe tries to balance the need to create a supranational European right with sovereignty and territoriality of the member states. The process wants to be as democratic as possible, something like, the federal system, that India might have in the various, in the various states. But still, it's a complex process. And living through that phase and seeing a lot of the national law being amended because, or brand new created because of the European push. And then, in our legal education, we had comparative public law, comparative private law. We never studied any topic, whether it was national labor law, national administrative law, national, back then copyright or industrial property, without looking at the international framework and some of the comparison. And that's crucial under multiple perspectives, to understand better one system, to understand better other system, and also to create what I say, long-term stability and peace. To understand others and other mechanisms, it's crucial, also because scholars collaborate and people collaborate to create long-standing relationship and hopefully, in the long-term peace. Our world is a better place than it was probably 70 years ago, but it's certainly a complicated world right now when we are seeing that, as we speak with the Ukrainian crisis, and and a variety of other frictions. Call it Taiwan and China, call it the United States and China, India and China, and so on and so forth. And the North Korean issue. So there's so many issues from a political standpoint that are happening in our world. That understanding the legal system, not we lawyers are technical. We are looking at the law. The law, of course, is the reflection of politics very often, but the law also creates the basis for the most important, democracy brick, which is the rule of law. And so when we look at all these specifics, specific aspects, we can absolutely not overstate the importance of comparative law. I'm a comparativist. I genuinely believe in comparative law. Comparative law can be anything. And sometimes when we look at the global villages, like the internet, of course, well, then we have global law or the law of country X that arrived first, developing technology that then gets used by all other countries, for example, like the UDRP in the domain name dispute resolution and so on. It will be very interesting to see what law develops for the metaverse. The situation of artificial intelligence, for example, and authorship, inventorship, whether invention created by AI or specific works made by AI, can they be copyrighted or not? A variety of offices across the world have said no. Some offices said yes. And so this is also very interesting to compare similar or identical issues and see diverging solution at the national level, based on territoriality. And so, I know we are a bit late, so I don't want to keep the audience too long, but again, I want to thank the organizer. My role was very limited. I just was asked to say a few remarks about the importance of comparative law in our field. And really, the main takeaway is our field is intrinsically comparative. We have to work comparatively on a variety of dimensions. And in addition, the comparative work is fun because we meet good people. It's a very interesting area. And, even in the Zoom time, we can still travel, at least be connected with people from different cultures and countries and legal system. And that in itself is very valuable, I believe. So thank you again to the organizer for the opportunity to address you.
Thank you. Thank you so much, Dr. Irene, for the wonderful address and your encouraging words and highlighting how important it is to study comparative law in this world today. Thank you so much. With this, we come to end of the keynote sessions for the second keynote session. I would now like to take this opportunity to present citations in honor of our distinguished guest. I request Rupendra sir to please present the citations. This citation is presented to Professor Dr. Irene Calpulai in the keynote speaker session of the Third International Conference on Comparative Law, Friday, the 18th day of February 2022. Professor Calpulai, a proficient scholar of intellectual property law and cultural heritage laws. An illustrious personality with profuse knowledge and enthusiasm, Professor Calpulai has contributed immensely to this conference by her thought-provoking words. We are highly obliged to Professor Calpulai for her presence and resonating with us the discourse. We hereby recognize the contribution made by Professor Calpulai and express our deep sense of gratitude to her. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. The citation is presented to Dr. Risham Garg in the keynote speaker session of the International Conference on Comparative Law on Friday, the 18th day of February 2022. Dr. Garg's in-depth knowledge in the field of transnational commercial law has added immense value to this conference. We are extremely thankful to Dr. Garg for his presence and contribution in the conference through your words of wisdom. We hereby recognize the contribution made by Professor Garg and extend our thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. This citation is presented to Dr. Manvendra Kumar Tiwari in the keynote speaker session of the International Conference on Comparative Law on Friday, the 18th day of February 2022. Dr. Tiwari, Dean and Associate Professor, is the legal scholar with expertise in constitutional law, human rights, and jurisprudence. A dynamic personality with profuse knowledge and interest in research, Dr. Tiwari has enriched this conference by his thought-provoking words. We are extremely thankful to Dr. Tiwari for gracing this occasion with his presence. We hereby recognize the contribution made by Dr. Tiwari and extend sincere gratitude to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. This citation is presented to Dr. K. Shamala in the keynote speaker session of the International Conference on Comparative Law on Friday, the 18th day of February 2022. Dr. Shamala is a legal scholar in constitutional law and research with her words, thought process has contributed immensely to this conference. We are extremely thankful to Dr. Shamala for sparing her valuable time and adding value to this conference. We hereby recognize the contribution made by Dr. Shamala and extend our sincere thanks to her. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. This citation is presented to Dr. Syed Hadi Mahmoodi in the keynote speaker session of the inaugural conference on the International Conference on Comparative Law on Friday, the 18th day of February 2022. Dr. Mahmoodi's presence in the area of international law in its various facets. A dynamic professional and a generous knowledge and passion, he has made a significant contribution to this conference. We are extremely grateful to Dr. Mahmoodi for sparing his precious time and adding value to this conference. We hereby recognize the contribution made by Dr. Mahmoodi and extend our sincere thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. This citation is presented to Mr. Vikrant Rana in the keynote speaker session of the International Conference on Comparative Law on Friday, the 18th day of February 2022. Mr. Rana has rich experience in areas of intellectual property rights and is a prolific speaker, which is evident from the thought-provoking words. We are extremely pleased to have Mr. Rana with us, who has always wholeheartedly supported us in all endeavors. We hereby recognize the contribution made by Mr. Rana and extend our heartfelt gratitude to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. With this, we have come to an end of this keynote session. We have had an exceptional session today. Our distinguished guests covered extremely pertinent issues in comparative law, ranging from constitutionalism, affirmative action, IPR, contractual laws, and metaverse. The deliberations have certainly enriched the intellectual content of this particular conference. Before closing this session, I would like to take this opportunity to propose a formal vote of thanks. The wonderful thoughts, ideas, and abundance of knowledge shared by our distinguished guests has hugely benefited the listeners and participants of this conference. I would like to thank Dr. Irene, Professor of Law at Texas A&M University School of Law, Texas, for taking the address despite various constraints. We are much obliged, ma'am. I would like to thank Dr. Risham Garg, Director, Center for Transnational Commercial Law, National Law University, Delhi, for a thought-provoking address. I would also like to express heartfelt appreciation towards Dr. Manvendra Kumar Tiwari, Associate Professor and Dean at Dharamshala National Law University, Jabalpur, for beautifully articulating the session. I would like to express my gratitude towards Dr. K. Shyamala, Associate Professor of Law, National University of Study and Research in Law, Ranchi, for investing her valuable time and sharing such an intellectually stimulating address. I also express deep appreciation towards Dr. Syed Hadi Mehmoodi, Assistant Professor of International Law, Shahid Beheshti University, National University of Iran, for his inspiring address and collaborating with Amity University for its endeavors. I also lastly would like to thank Mr. Vikrant Rana, Managing Partner, SS Rana and Company, for always supporting Amity Law School in its academic endeavors and enlightening us with his very pertinent talk. With this particular keynote session comes to an end. Thank you so much, all of you.
Thank you so much, Dr. Sakshi Parashar, co-convener of this conference, for moderating the keynote session very well. So, ladies and gentlemen, boys and girls, we now come to the highlighting part of today's conference. And now we are going to go through something that's very, very interesting and in the interest of everybody, and that is the MOU signing ceremony. So, ladies and gentlemen, welcome to the MOU signing ceremony. Amity University is a world-class research and innovation-driven university. Today, following the ideals of our Honorable Founder President, Dr. Ashok K. Chauhan, sir, we are 11 universities in India, 16 global campuses, with 28 schools and preschools. Amity Law School, Noida, is a leading law school not only in our country, but also in the entire Asia-Pacific region. So let me tell you about the MOU signing ceremony. So today we are going to sign our Memorandum of Understanding for placements and internship related activities on mutual points of agreement with Trans India Law Associates, which we call as TILA. And we have with us SS Rana and Company, which is an IPR law firm. Then we also have with us Indian National Bar Association, which we term as INBA. So Amity University, where modernity blends with tradition and with research and innovation being at the core of the university, we truly believe in global excellence and we prepare future-ready professionals. What in the field of law? Yes, of course. When it comes to industry-ready professionals, of course, law is also the domain, and Amity Law School, Noida, takes this privilege in providing our students world-class education together with preparing them as industry-ready professionals. So we will talk more about the MOU signing, and as we go with the flow, I would now request Additional Director and Joint Head of the institution, Professor Dr. Aditya Tomar, sir, to present his address for the MOU signing ceremony.
Thank you, Dr. Sumitra. I just want to open the ceremony formally, though we are just hosting you, Dr. Vikrant, Professor Irene, and other dignitaries on the dais, virtual dais. So for the formal sake of opening of the ceremony, I would like to welcome to all the distinguished dignitaries on the virtual dais. I would like to extend my heartiest welcome to Trans India Law Associates, TILA, Professor Raj Singh Niranjan, Mr. S.S. Rana and Company, IPR law firm, Mr. Vikrant Rana ji, and our very dear friend, Ms. Vinakshi from INBA, Indian National Bar Association. I welcome you all, and all the dignitaries on the dais, on the virtual dais, though some are in the list of panelists and some are in the list of attendees. So I welcome you all. Thank you. Thank you very much.
Thank you so much, Professor Dr. Aditya Tomar, sir. Well, today we talk about how do we bridge the skill gap between the academia and the industry. Well, national education policy talks about setting up of interface structures. It talks about academia, industry, R&D lab consortium. It also talks about the formation of a national knowledge network to connect the institutions and to enhance the use of technology. So what goes in for Amity Law School, Noida today in this MOU signing ceremony will be focused more by none other than our chairman, Professor Dr. D.K. Bandyopadhyay, sir. I would now request respected sir to present your address. Chairman, sir.
Yeah.
Yeah.
So, Sumitra, thank you very much. This is really a great day great day for Amity Law School, Noida. We have the honor to have, Minaski Kadam and of INBA. And we have got Mr. Raj Singh Niranjan on behalf of the TILA. And we have got Vikrant Ranaji, our good old friends, and to be present over here in the MU signing ceremony. Has the register been called, Sumitra? Aditya, has the register been called?
Yes, sir. Registrar sir is in the meeting, sir.
That's in the meeting. Okay. Now, it's a really a great day. Again, I'm mentioning it while welcoming our three partners with whom we are going to sign the memorandum of understanding. And it will not be out of the place to mention at this juncture that why we are signing these MOUs. What is the purpose for signing these MOUs? The first purpose is the Amity University was the first university who actually transformed or converted their curriculum in tune with Industry 4.0, and we came out with Education 4.0. And meaning thereby, Education 4.0 demands lots of changes, the way the curriculum is delivered, the way the teaching learning process needs to be taken care of, and the way students centricity are to be brought in. We subsequently, it has been seen that NEP 2020, and we have been doing it in Amity little bit 17, 18, 19, and so on and so forth, with the guidance and the direction of our honorable founder president, and with the vision of our chancellor, and then again spearheaded by our vice chancellor. We have been doing it, but now education, the NEP 2020 has further boosted our activity, that the student, if we really want to bring the student centricity over here, then the learning process should be much more creative oriented, would be industry oriented, and students will be getting the opportunity directly to work with the industry. It is not only in the form of the internship, but also in the form of the apprenticeship, so that while they learn the theory, and they should be in a position to apply them in the practical field. That's the whole purpose. Also, we have been doing it, but now the impetus is much more in those directions. And as a matter of fact, as you mentioning in the morning deliberations in the conference, as we have every courses we have a component known as professional skill development activity. That's one. And what we do there, we also do in a small way, course-wise. Course-wise is a small way to see that the students get the opportunity to work on a practical problem, and they accordingly they get assessed too. Now, in addition to that, what we are talking about, that if we are able to get some MOU signed with the different industries, it will facilitate us in an official form to have them on board in terms of having guest lectures, because every course we want, that should be 2, 3, 4 guest lectures by the eminent persons. So this MOU will provide us that opportunity to have them in a structured form, in addition to interacting and interfacing for the apprenticeship, and also for the purpose of the internship. However, other objectives are also there, but that is again subsequent, that when the students are passing out, if we have got the industry partner, if we have got the MUs with them, then it will also facilitate the students to be placed. And they will also know that these students came to us for apprenticeship, these students came to us for for the purpose of internship. So why not? We have seen them. Why not to absorb them in our role, depending upon the vacancy they have got it. So it has a multifarious, multifarious objective as per the NEP 2020, and also as per the trust given by the Amity University that not only to changing the way the academic delivery is being made, and we have made it to happen that all the courses that are being taught, we have categorized them under 6 categories, and the lower 3 categories in terms of remembering, understanding, all those things are being done through the help of the e-content being developed by the faculty members. So any students who will be attending the class, they will prepare them before coming to the class, so that the class discussions becomes more of a interpretation, analysis, and creation. So the learning becomes a complete one. So they become they are able to develop different analytical ability apart from having information and the knowledge. These are the skills that we want to, our competency, we want to incorporate them. So along with that, coupled with the industry exposure, will make our students to be much more effective, much more communicative, much more understanding, much more creative, and on the other hand, will be in a better position to become a great professional with a great human being. We also give lots of emphasis on value-based education. So this value-based education, communicating ability, industry exposures in a greater way, and that will make them the overall grounded and professionals in the days to come. So in that way, I would say that through this conference, when Dr. Aditya Tomar brought this proposal that we should be signing agreement MOU with three of our partners, and it was immediately was appreciated, and we went ahead, and we are really thankful to you that you came forward with our proposals, and you agreed with our proposals. Now today is that historic day where we'll be signing those MOUs, and it's a great thing, and we have made a beginning, and we like to have at least 20-25 such type of MOUs to be in place, so where students can go and do their internship and also the apprenticeship. So thank you very much once again to our 3 partners today, and the ceremony is going to be a very important ceremony, and it is going to be one step ahead for Amity Law School Noida. So thank you, Aditya, thank you very much. Thank you, Sumitra, for taking the lead, and thank you, Sakshi, for taking the lead, and Jane, Jane and Rupinder, those are involved in this seminar. So in this conference, in between the conference, we are also showing that we care for our students. We made our students to be ahead of time, and so that they will be much needed in the society. So thank you very much. With these few words, now I would request Sumitra to take the take the deliberation, take the deliberation ahead.
Thank you so much, Chairman, sir, for the wonderful insight into what we are going to do today in the MOU signing ceremony. Well, ladies and gentlemen, I was talking about the industry-academia convergence that would bridge the skill gap. Amity University is a leading research and innovation-driven university, and we ensure that our curriculum adapts and moves faster with the pace of the industry changes, which is why we've built up relationships with industry and career advisors in the area of law. There is a tailor-made education for the people that we provide them and make them as industry-ready professionals. This is how we are collaborating to develop the learning models as expounded by our chairman, sir. Developing joint academic and industry degree models is also one of the areas on which national education policy focuses on. And today in the MOU signing ceremony, we will learn more about how mutually enabling can be the processes for capacity building of the faculty and the students, and also the corporates and the law firms. To focus more on this, I would now request our very honorable and respected Registrar of Amity University, Uttar Pradesh, Noida, Dr. B.L. Arya, sir, to present his deliberations and address. Over to you, respected sir.
So thank you, Sumitra ji. This MOU signing with the different stakeholders will definitely mutually benefit for all of us. And I'll simply say that in times to come, a lot of things will happen due to these MOUs. So thank you very much and congratulations to all the people for this purpose.
Thank you so much, respected Registrar, Dr. B.L. Arya, sir. And with your address, the MOU is already endorsed. Thank you so much. So beginning with what we see today in the contemporaneous society is to develop the models of partnerships and to provide value to the changing employment patterns in the area of law. We would now begin with the MOU signing ceremony. The first MOU presentation is from Indian National Bar Association, and we have with us Madam Ms. Vinakshi Kadan, who is the legal head of Indian National Bar Association. Indian National Bar Association is focused on taking the Indian legal industry and its members to the newer heights, and it represents the entire legal ecosystem in India. It is dedicated to expand its members' professional network and industry insight. When the lawyers need to be heard, INBA is also the voice. And we are also privileged to sign this MOU with INBA. I would request Rupendra sir, can you zoom it a bit?
Zoom and flip through.
Yeah, if you can. Yeah. So thank you. So as you know, Amity University is a leading research and innovation-driven university, and Indian National Bar Association has been registered in New Delhi, and the areas of mutual agreement that we talk about and the scope of work that we talk about is about internship training to the selected students to make them industry ready. AUUP and INBA would design the on-the-job training curriculum for the industry embedded degree programs and would also assess the performance of the students during the internship period. And both of us together are jointly going to issue the certificate of the students on the successful completion of the internships. Now, the roles and the responsibilities for both AUUP and INBA are also defined in the MOU. I would request Rupendra sir to scroll it further. Thank you. And Amity University Uttar Pradesh would also upload the marks of the internships on the portal that we already have. And also this joint certificate would also provide ratings to the students. It will also get embedded with the degree, which Aditya sir will later talk about, perhaps in the next webinar. This internship training to the students for one semester may be tailor-made to 15 or 18 weeks. And INBA can nominate a guide also for the duration of the internship training. International Bar Association would continuously assess the skills of the students through skill tests and exams and meet the faculty guide to review the monthly progress of the student. INBA shall also issue the certificate to the students on successful completion of the internships, and that certificate can be presented by the students to the faculty guides and also on the completion of the summer internships. Well, of course, both the parties are jointly going to assess them, and this MOU bears all the confidentiality as is seen on the screen and the general conditions of the
Go to the last page. Rupendra, go to the last page. Yeah.
Thank you, sir. And so this and other things, as you can see in the scroll today, we are going to sign this MOU in the presence of Ms. Vinakshi Kadan, who is Senior Legal Advisor at Indian National Bar Association, in the presence of Honorable Chairman, Professor Dr. D.K. Bandyopadhyay, sir, and in the presence of our Honorable and respected Registrar. And also in the presence of Ms. Babita Sharma, who is editor of INBA. Thank you, Ms. Vinakshi Kadan, for endorsing your signature. And thank you, Dr. B.L. Arya, sir, and Dr. Bandyopadhyay, sir, for endorsing your signature. Let's have a round of applause for this MOU, for this collaboration between INBA and Amity Law School, Noida.
Thank you so much. Sumitra ma'am, if I can take quick 2 minutes, if I'm allowed.
Yeah, sure, please.
A very warm welcome to Amity University, Noida, and to all the members present here. I have been in this inaugural session since morning, and I've been wanting to say certain things for the students. I'm sure all of us know, and for all those who don't know, Indian National Bar Association, it's a voluntary lawyers organization with the Ram Jethmalani as the late Ram Jethmalani as the president of the organization, and Dr. Subhash Kashyap as the president of the organization. And we as an organization work with the litigating councils, GCs, sitting judges, law ministries, and tribal ministry and other ministries along with the university. So when especially focusing on the law students and why we are signing this MOU. One, it was actually it's actually a formal signing ceremony today, but the association has been long with Amity University. And students from MIT have every now and then been picked up by INMA. They already are members. The membership is available to the corporates, to the law firms, not just in India, globally. So we have done our research projects with the law ministries, wherein MIT was the most prioritized university. We had participated, and some of the students picked up have been keenly working diligently, and their names have also gone to the law ministries. Also, the second part of it is it's not just an organization of the Indian lawyers, we connect them globally. So and today, Edith Cowan University, Australia, we've had the Chief Justice of Australia, Honorable Andrew Bell, on Law Day, Constitution Day in 2019. So the association with Australia has been long back with us. And we have international MOUs with various universities. Internship is open not just for Indian students, even the overseas students come and intern with INMA. We had a student called Freya from France in 2018-19. And as far as the internship with MIT is concerned, the students are all the time welcome. This formal ceremony is happened, but it is not required actually, for the reason we are very close to the students in MIT. Somehow the cream that comes to INBA is from MIT. I mean, I'm happy to say that and share with all present here, Dr. Aditya, Dr. Bakopadhyay, Sumitra, and Shifali ma'am is not here though, but I can never forget the association with MIT is so very close. So it's a very warm welcome to all present and the honorable judges in the morning. We even work with the judges, and why this platform of INPA, how does it benefit the students is when we do the law day and when we do the main event of the lawyers, that's a law day, Constitution Day on 26 November every year. We've had an opportunity of inaugurating the 10th one last year. So INBA has completed 10 successful years by doing it even at the times when none of the other organizations were able to meet the targets. And we've been appreciated for this by even the president and PM's house. So all of us can visit the website for the same. And once again, I'm actually honored. We even try and help the students, not to forget to mention here, recommend them. We don't actually recommend, but we take them along, give them a common platform wherein the judges are there on the stage and the students conduct those events. So we train the students on that, how well you can perform on the stage. So that is how we try and help them. So I would, I mean, it'll be wonderful for Vikrant, Rana sir and Raj sir here present. So let's have the students, let's try and promote each other in the best possible manner. Thank you so much. Thanks a lot.
Thank you, Maxi. Thank you very much.
So much, sir. Thank you so much.
Thank you, Vinakshi, and it was wonderful listening to you. We've been friends since so many years, and now formally, after endorsing the MOU, we feel more connected. Thank you so much. And ladies and gentlemen, this MOU is being signed today on 18th of February on the first day of our international conference on comparative law. Congratulations, Amity Law School, Noida, and congratulations, INBA. Now comes the time of the second MOU that is going to be signed, and I proudly present to you this MOU that we signed today between Amity Law School, Noida, and Trans India Law Associates. And with us today, we have with us Mr. Raj Singh Niranjan, who is the managing partner of Trans India Law Associates. So let me tell you what is Trans India Law Associates. More will be told by Mr. Raj Singh Niranjan. This is the world's largest legal entity which has improved client satisfaction in all the areas. Trans India Law Associates, it is a multidiscipline full service law firm which provides a range of legal services both inbound and outbound. And the firm has its main office at New Delhi and associates in major cities of India in order to ensure fully integrated services. Raj Singh sir, there are many offices that you have across the world also. It's a proud privilege that we are signing this MOU today. I would request my colleague, Mr. Rupendra Singh, to present this MOU of friendship and camaraderie. So this memorandum of understanding being signed today between Amity Law School, Noida, which is a leading law school not only in India but also across the Asia Pacific region, and the Trans India Law Associates, which is a leading law firm in India with its office at New Delhi. And we have with us Dr. Rajni Patel and Raj Singh Niranjan sir, who are the managing partners. So if we look at the MOU, let's move on to the mutual points of agreement, and would request you, sir, if you could zoom it a bit. So the scope of work and the services would again be endowed with providing apprenticeship and internship training to the selected students and to make them industry ready, and to provide them by designing on-the-job training curriculum that will be in collaboration both with Amity Law School Noida and Trans India Law Associates. So both of us jointly going to assess the performance of the students during the apprenticeship and the internship period. We would mark them and provide them certificates jointly on the completion of the internships. So moving on to the roles and responsibilities, Amity University Uttar Pradesh Noida, Amity Law School would communicate to TILA, that is Trans India Law Associates, regarding the commencement of the apprenticeship or the internship that we already provide you every time, sir. And the nature of the internship will totally depend upon the interest of the students. If he chooses arbitration or if he chooses real estate law or whatever, and that will be designed on the job training curriculum, which would also help them in their academics. Of course, both the parties are going to assess the students' performance on the basis of how they perform during the internship duration. And yes, the confidentiality is maintained between both the parties as per the mutual terms and conditions. Today, this 18th of February, 2022, together, Amity Law School Noida, Amity University Uttar Pradesh, in the presence of our registrar, Dr. B.L. Arya, Chairman Professor Dr. D.K. Bandyopadhyay sir, and in the presence of Mr. Raj Singh Niranjan, Managing Partner, Trans India Law Associates, Dr. Rajni Patel, Joint Managing Partner, Trans India Law Associates, together endorse with stamp and seal this MOU. Congratulations, Amity Law School Noida and Trans India Law Associates. Let's have a round of applause for both the parties. Congratulations. I will now request Mr. Raj Singh Niranjan, our very dear friend, to present his address. Over to you, sir.
Thank you, Dr. Sumitra. So it's wonderful interacting with you, Professor Aditya Tomar ji, Professor D.K. Bandyopadhyay ji, Dr. B.L. Arya ji. Special, I'm very happy to meet this Vinakshi Kadam ji, and wonderful work you all are doing. And Mr. Vikrant Rana, I had the opportunity to hear your presentation. That's super actually. And obviously Dr. Shefali Raizada and Dr. Sumitra. So I will not talk about Trans India Law Associates. Let's talk about a more important issue actually. So 1984, the firm was established, Trans India Law Associates. 2015, we said that society has given us a lot. What have we given back to the society? That was the question. And we said that let us do, we cannot do so many things. Let us do one big thing, and let us do consistently, persistently for next 10, 2, 3, 4 decades actually. So we said, since we have expertise in energy laws and we are also legal advisor to International Solar Alliance, we have also published the first book on Electricity Act 2003. So we said, let us identify energy as a sector and do something about it in this particular sector. Instead of we identifying the biggest challenge in the energy sector, we called experts from across the world. We invited professors from Europe. We invited professors from Australia and Hong Kong. And obviously, the entire power sector of India was there. Generation, transmission, distribution, trading, and supply of electricity were present there in India Habitat Center. Only one question we asked them: what is the biggest challenge in the world in energy sector? After 1 day of conference, they told us there are not one challenge, there are 3 biggest challenges in the world in energy sector. First one is 1.2 billion people across the world do not have access to electricity. We are all blessed that Vinakshi ji is sitting with us, Dr. Professor Aditya is, we are all happy to talk to each other. But imagine a situation if we don't have electricity, internet to baad mein aayega. So 1.2 billion people do not have access to electricity. Second biggest challenge in energy sector, they said that 3.2 billion people across the world do not have access to clean fuel to cook food. So mothers cook food using cow dung cake, using wood, and they inhale all the poisonous gases while cooking food for us. And they do not suffer alone. Their child of 1 day to 10 years has no place to go. He also suffers. The World Bank says that I don't know the figure exactly, but the figure is very huge actually. And every year, these number of people have to die actually because of this problem. Third is, if in India, the per capita power consumption is 500 units to 1500 units, then in North America and European Union, the per capita power consumption is 15,000 to 30,000 per person per annum. You see the gap, 500 to 1500. Dr. Dilipji, if I can have 5 minutes, I would like to explain this very, very important issue.
Yeah, please go ahead. Please go ahead.
So these are the 3 challenges, Dr. Dilipji, which was identified by the professors from across the world actually. And they said, "Aap ye sochte ho energy sector ki problem hai, ye sab nahi hai, ye problem hai actually." And with the problem, it is also a big opportunity. So we said, as a law firm, as Trans India Law Associate, what can we contribute? Let us be part of the solution, not the problem. Problem sabko pata ho gayi. So we said that jis tarah se in India we say roti, kapda, makan is the basic necessity of life. But this definition is incorrect. It is partially correct. So if somebody goes to island, akele chhod diya jaye, in case of we see in Discovery and National Geographic Channel, if some person is alone, first thing what he will search is food. That is correct, roti. But the second thing which he will search, Vinakshi ji, he will not search for kapde or makan. He will search for fire, energy. So effectively, basic necessity of life is fourfold: roti, urja, kapda, makan. So we said, as law firm, what we can do is, let us highlight it. Let us work to make right to energy a fundamental right in all the constitutions of the world. Let us get it included in the Universal Declaration of Human Rights as a basic human rights. As of now, it is not there across the world. So we started campaign to make right to energy a fundamental right in all the constitutions of the world. And why I am discussing this with all of you, because all of you are from legal background, and most of the revolutions, even independence of India, has been initiated to a greater extent by lawyers actually, and even law students. So then we started various initiatives. One initiative was TILA, International Moot Court Competition on Energy and International Law. And first time when we held that competition in Banasthali Vidyapeeth, the largest residential women university in India, the students, lady students from across the world, they drafted the Right to Energy Declaration. And this is the first declaration which has been signed in India about right to energy across the world. So agar Bill of Rights UK में आया है, या Magna Carta UK में आया है, और Bill of Rights USA में आया है, तो right to energy has originated from India. So let us work in that direction. I invite all if they want more information, they can, maybe contact me or maybe write a mail or, call me. I will be glad to provide more information and look forward for the support of all of you in this endeavor. And let me thank MIT University for this wonderful initiative of, academic industry partnership to make, students knowledge ready. And second question across the world, which I am asked actually, and it's very surprising. Even in Singapore, students ask me, what is the best way to learn law? And even if I'm visiting, recently I was there in Nirma University, same question. And students ने teacher पूछते सबसे अच्छा way है impart, अगर future ready बनाना है students को, what is the way to impart education? And surprisingly, the answer lies within us actually. India is the world's oldest knowledge transfer system. भारतवर्ष दुनिया का सबसे पुराना knowledge transfer system. So if you start from the beginning, if I can have 7 points of transferring knowledge, how to learn law for the lawyers also, for the students also, and for the professors, especially professors and lecturers actually. So India has been the world's oldest knowledge transfer system. Sabse pehle we talk about smritis and shrutis. Smriti is what? Smriti is which is remembered and transferred across the generation. Shrutis हम बोल के ट्रांसफर करते, तो प्रोफेसर यूज्ड टू सिट एंड टेल एवरीबॉडी नेक्स्ट जनरेशन कि ये नॉलेज है अपनी मेमोरी से और व्हाटएवर ही हैज लर्नड फ्रॉम हिज प्रोफेसर एक्चुअली. And that is how for one, maybe thousands of years, we don't know how much time, knowledge was transferred. So first step I tell the students is knowledge transfer ka listen. Whatever is being said in the conferences, whatever is being said, in the law firm, whatever is being said by the professors, listen. You may agree, you may disagree. The Indian system does not say you to agree. He's only asking आप सुन लो और analyze कर लो. ठीक है? First step of learning law is this. Second step of learning law is when Shrutis और Smriti जब 100 साल हो गए, 1000 साल हो गया, तो it was difficult to understand क्योंकि कुछ एक कहावत होती है ना, कान में किसी को बोलो तो knowledge is distorted. So there was distortion of knowledge in 1000 years. So our ancestors, what they did in the knowledge transfer system, they articulated and documented whatever was there in Shrutis and Smritis. And that documentation is called Vedas. So 4 Vedas and 2 Upavedas were written. So second step of learning law is right. Whatever concept you have heard from your professor or the concept you have heard from the lecture, first listen, second write. Third, after 1000 years, I'm just, सिर्फ समझाने के लिए बोल रहा हूँ 1000 years, sir, ऐसा कोई 1000 year नहीं है. It is different for different books. After 1000 years, the Vedas also become, Shrutis तो हमें distorted हो गई थी. वेदास हमें समझ में आना बंद होगी क्योंकि लैंग्वेज जो है ना वो क्लिष्ट होती जाती, कॉम्प्लेक्स होती जाती. सो उन्होंने एक रास्ता, हमारे पूर्वजों ने एक रास्ता निकाला, थर्ड स्टेप. और उन्होंने थर्ड स्टेप ये निकाला, इफ वी डिस्कस द कॉन्सेप्ट ऑफ लॉ वी विल अंडरस्टैंड लॉ. And what they did is they did not discuss it. They wrote that discussion in the form of minute, which is called Upanishad. So 108 Upanishad, when you read, you will see discussions of professors and teachers and students. It is like minutes. जो board meeting के minutes हम देखते हैं, जो लिखते हैं as lawyers, it is minutes. It is very surprising. They will take one concept and then they will minutize it. The third step is discuss. First step was listen. Second step was write. Third step was discuss. Fourth step फिर क्या हुआ, ये भी difficult हो गया समझना. तो फिर हमने एक काम करा, एक रास्ता निकाला, इंसाइक्लोपीडिया बना दी. जो भी हमने पुराना श्रुति स्मृति में जो भी था, वेद में और उपवेद में क्या था और वेदांत में क्या था, उसकी हमने इंसाइक्लोपीडिया बना दी. उसको इंसाइक्लोपीडिया को हमने कहा कि 18 ब्राह्मण, 18 पुराण बोलते हैं. These are encyclopedias. And उस encyclopedia में everything is described. It is a reference book, it is guide. So refer AIR, refer judgments, refer whatever has happened in past. You will understand it better actually. So कई बार हम इसको बोलते हैं describe. आपने पहले write कर लिया, उसके बाद उसको describe कर लिया, पैसे इस साल में ये हुआ था, इस साल में ये हुआ था, पुराण से लिखे encyclopedia से. फिर उसके बाद वो भी समझ में आना बंद हो गए, because with time and place the language becomes difficult and clished बोलते हैं उसको. 1000 साल हो जाते हैं तो whatever Hindi we were speaking in 1947, we are not speaking that kind of Hindi, nor we are speaking that kind of English. It has changed. तो next step एक रास्ता निकाला हमारे ancestors ने in the knowledge transfer system, Indian knowledge transfer system I am talking about. ये निकाला, if you tell anything in the form of stories, it is easier to understand. Same language, same concept. So our ancestors wrote two stories in the knowledge transfer system. So if we read stories, हमारी stories क्या है? हमारी stories है judgment. अगर गोलकनाथ केस अच्छे से पढ़ लिया है, केशवनंद भारती केस पढ़ लिया और आपको पता है कि गोलकनाथ was farmer in Punjab and he appealed and this, you will understand the entire concept of right to property. अगर आपने कहानी सुना दी students को या students ने उस कहानी को सुन लिया तो next है fifth step is stories. अब फिर स्टोरीज भी समझ में आने बंद हो गई क्योंकि लैंग्वेज डिफिकल्ट हो गई. तो उसके बाद रामानंद सागर ने रामायण का सीरियल बनाया और B.R. चोपड़ा ने महाभारत का सीरियल बनाया. अब वॉच करके हम देख सकते हैं कि क्या कॉन्सेप्ट है. सो नेक्स्ट स्टेप ऑफ लर्निंग इज वॉच. आज यूट्यूब वीडियो सारे अवेलेबल हैं, खोलो यूट्यूब वीडियो, आप बहुत सारी चीजें यूट्यूब वीडियो मैंने देखा कि स्टूडेंट्स देखते हैं. अब ये काम की चीज भी देख लो जरा, आपके करियर बन जाएगा, आपका इच्छा रहेगा तो एनकरेज देम टू सी ऑल द वीडियोस अवेलेबल. And the last step of knowledge transfer system is that is the future. and it is called animation. So now education system, if you can use more animation, you will learn things better. So this is my, I end my dialogue with this. There are 7-8 steps for learning for students and for professors also. And it is ingrained in our largest knowledge transfer, oldest knowledge transfer in India itself. First is listen, which we learn from Smritis and Shrutis. Second is write, which we learn from Vedas. Third is discuss, which we learn from Upanishad. Fourth is describe, which we learn from Puranas. And sixth is stories, which we learn from epics. And next is watch, which we learn from serials, Mahabharata and Ramayana. And next is animation, which we will learn from the next generation, actually. So thank you so much, Sumitra ji, and thank you so much, Dilip ji, for giving time to me. And Tila is glad to be part of this endeavor. Best of luck to all of you. Yeah.
Thank you, sir.
Back to you, Dr. Smith.
Thank you.
Thank you so much, sir. Thank you so much, Raj Singh, sir. You have always been a part of Amity family, and very beautifully, in a subtle way, you have talked about the sector-specific unrivaled intelligence that talks about skill analysis and the changing paradigms of the society. Thank you so much for the beautiful address. Well, ladies and gentlemen, we now move towards the third MOU. And the third MOU today, Amity Law School Noida signs with SS Rana and Company, which is a leading law firm. SS Rana and Company was established in the year 1989, and it is a top IP and corporate law firm in India. The firm has been recognized as one of the best IP law firms in India by several research platforms like the Legal 500, Managing IP, Mundak. It's a leading law service firm with specialized practices in intellectual property laws and corporate laws, with its corporate offices in New Delhi, regional offices in Noida, Chandigarh, Mumbai, Bangalore, Chennai, Kolkata, and associate offices in the Indian subcontinent region. The firm represents several Fortune 500 companies and national and international clients in India and worldwide. And today we have with us none other than Mr. Vikrant Rana, our dear friend, managing partner at SS Rana and Company, IPO law firm. So I would request my colleague, Mr. Rupendra Singh Sir, to present this MOU between Amity Law School Noida and SS Rana and Company. Amity University, as we all know, is a research and innovation-driven university, and SS Rana and Company, with its office at New Delhi, with its managing partner, Mr. Vikrant Rana, we signed this MOU today in terms of providing industry-designed curriculum to our students in terms of summer internship, on-the-job training curriculum, as well as other internship platforms wherein, of course, students would specialize in IP and other related areas. The roles and responsibilities of both AUUP, that is Amity University, Uttar Pradesh, Noida Amity Law School, and SS Rana and Company would be to together assess the students and put the design of the on-job training curriculum for internships for the students, which will totally depend upon the mutually agreed duration of internships. Further moving on, we also talk about the responsibilities of both the parties. Amity University would create the framework for the joint assessment of the students which are undergoing the internship programs, and would nominate a faculty guide. Like I'm a faculty, I'm also a guide to more than 50 students every year, every semester. And we would conduct the final assessment jointly with the second party, that is SS Rana and Company. And together we are going to, the faculty, of course, at Amity Law School Noida is going to upload the marks on the intranet portal that we have. SS Rana and Company would again share the job description, the number of vacancies, the stipend, and the duration of the internships that they are going to provide. They would also conduct a selection process and would nominate a guide from their law firm to get the internships done for the students. They are also going to continuously skill test the students. And also on the basis of the performance of the students, they are going to present the marks to Amity University, Amity Law School Noida. Moving on together, the assessment, of course, would be done both by the industry guide and the faculty guide. Today, on 18th of February, 2022, at the 3rd Annual International Conference on Comparative Law, together, Amity Law School Noida signs this MOU with SS Rana and Company, IPO law firm, in the presence of Mr. Vikrant Rana, Managing Partner at SS Rana and Company, together with Dr. B.L. Arya, Registrar, Amity University, in the presence of Professor Dr. D.K. Bandyopadhyay, Chairman, Amity Law Schools Noida, under the stamp and the seal of both the parties. Congratulations Amity Law School Noida and SS Rana and Company. Let's have a round of applause for this partnership, this academia-industry linkage. Congratulations, both the parties. I would now request Mr. Vikrant Rana, Managing Partner, SS Rana and Company, to present his address.
Well, thank you so much, Dr. Singh. Dr. Bandyopadhyay, it's again a distinct pleasure to share the screen with you, Professor Tomar, and rest of the dignitaries, Dr. Arya, Dr. Prashar. So thank you so much. I think it's, I would say we are formalizing a relationship we always had. And it has been a pleasure to, be working with Amity on different facets, right from, having students intern with us. We're very proud that many of the interns were absorbed and placed with our firm, and they're doing pretty well with us, and we are very proud of them. And I think this is a very forward-looking move by Amity to look at the gap between the industry and the academic output from the colleges. So because that is, like you said, they have to be industry ready. Unless they're industry ready, the absorption rate would be much lesser. So we have to work together, the academia and the profession, to work together to make them understand what to expect when they join the profession. And likewise, it is, I think, our duty as the profession to help students understand the nuances when they would be joining a law firm, lawyer, or any setup which requires a legal service. So that interaction is very crucial, I believe, and this is a wonderful move to formalize a structure which was already there. So kudos to you, kudos to the whole Amity team. And we have had a very long relationship with Amity, like I said, about the internships and the placements, and also about we have had essay competitions, we have had moot courts with Amity. I've been also had the pleasure to be a guest faculty at the Amity School of Design for IP laws. So that was also part of the Amity group. So we were very happy to be part of that. And I'm sure this would be a landmark thing for Amity, for students of Amity, that they would be this practical side, which we feel at many times law students miss out, will be captured and dealt with, so that it enhances the absorption rate, enhances the skill set which they would be expected to have when they join any legal legal service provider. So my congratulations to Amity, my congratulations to the whole setup here, and we certainly look forward to working together and as per the terms, and beyond the terms also as per the MOU signed. And I would also like to congratulate Raj Singh ji and Meenakshi. And I think Raj Singh ji, that was a wonderful sharing of knowledge regarding the knowledge transfer. So thank you so much. It's good to hear so much in detail, and kudos for the the energy book and the moot and the charter you're coming out with and you've been working on. So kudos to that also. And likewise, Meenakshi, wonderful steps, and we'll be happy to collaborate and see how we can work together in the times to come. And thank you so much, everyone. Thank you. Really grateful for this honor.
Thank you very much.
Yeah, thank you so much, Mr. Vikrant Rana. Well, this shows total diffusion of knowledge through the interaction of peers today. We are very happy at Amity Law School, Noida, to have formally signed the MOU with Trans India Law Associates, SS Rana and Company, and Indian National Bar Association. Thank you, everybody, for being here. Well, ladies and gentlemen, this was the highlighting point of today's conference, and the day has ended, but not the spirit of the Amitians. But a formal vote of thanks is definitely required to end this session. And without any further ado, I would request the convener of this conference.
Yeah, Sumitra, before that, I'd like to mention to
Yes,
all three partners, now I would say the partner, academic, industry partners, academia, industry partnership. So, and especially to Raj Singh ji, I mean, your erudition in terms of, remembering, hearing, writing, analyzing, storytelling, and watching. This is the way how the evolutions of learning process has come up. But do you know that this is our old concept? But this concept has been stolen by Bloom. Bloom says, he's also talking about the six taxonomies. he says that, it should be remembering, understanding, applying, analyzing, evaluating, and then creating. So you can see the simile, which is to be our earlier days. Now, how those gentlemen, they have read our, Vedas and Puranas, and how they have actually captured it, and they have articulated it in a different way. I mean, I thought that I must tell, because lots of students are hearing, so they must also know that this concept, what we're talking about, what I was talking about at the very beginning of my deliberations, that we want our students should be in a position to come prepared before they enter into class. So we give the content. So that means that the first 2 years that, remembering and understanding, is complete. Then we like to bring back to the classroom so that they can, the teachers can discuss about the other 4 layers so that the classroom becomes much more light. Now, in addition to that, we are also thinking about that watching now has been converted to how do you learn while working, while doing. So there we find that our 3 partners are going to be great help to us. And we look forward for such a very, very strengthening and cementing relationship with the Amity Law School, Noida. So this is all possible due to our encouragement, as I already mentioned. And I like to take, I will request all of you to take home that this is the philosophy of Amity. This is the philosophy of Amity. So when others are not thinking, we are already ahead of. This is the philosophy, and this is all due to our Chancellor and also to our contribution. So thank you very much. I intuited, but I could not stop myself, because I thought that here is a gentleman, and Raj Singh ji, who is talking about our ancient way of learning, and also coming back to the modern way of learning, that the path that has been traversed, and this has been stolen by somebody else, and we all the time we remember, but we have forgotten that. Thank you very much.
सर, आपको एक बेस्ट सेलर बताता हूँ सर. पूरे वर्ल्ड की जो बेस्ट सेलर है ना, वो पंचतंत्र है. All the kings of the world used to keep a copy of Panchtantra. It is very surprising, actually. So I think if somebody wants to become one of the good lawyers, he should read Panchatantra very well.
Thank you very much.
Very well said, Chairman sir, and Raj Singh sir at Amity also. Modernity blends with tradition, and as rightly put forward by Chairman sir, our Chancellor totally believes in academia industry linkage, and with the advent and enhancement of technology, Amity Law School Noida is making a great path for all the students enrolled here. So marking an end to this session, I would request the convener of the conference, Dr. Jane Iyer ma'am, to present her address. A formal vote of thanks.
Yeah. Good evening, one and all present. I deem it my privilege to propose the vote of thanks at this memorable occasion today. First and foremost, I would like to thank our industry partners, namely Ms. Meenakshi Kadan, Mr. Raj Singh Niranjan, and Mr. Vikrant Rana. Though this collaboration with all 3 industry partners has been there for quite a long years, but then this is to a new beginning that we are starting today. So this collaboration with Amity Law School is going to go forward in the years to come, which is also going to be beneficial for our students. So we look forward to this new collaboration that we have signed today. Thank you so much for being our partners from today, though not from today, we are partners for quite a long period of time, but then for a new beginning.
But
thank you so much.
Jane, we have formalized it. We have structured it.
Yes, we have formalized it. Next, I would like to thank our chairman, sir, Professor Dr. Bandhopadhyay, sir, without whose constant blessing, support, encouragement, I believe this conference would never have been possible. Neither would the MOU signing be possible. So I extend my heartfelt gratitude to you, sir. Along with Chairman, sir, I would also like to extend our heartfelt gratitude to our registrar, B.L. Arya, sir, who has been a constant support in this endeavor of ours. I would extend my heartfelt...
Jane, you must mention that it is a B.L. Arya Saab we are not after him. He was after us. He was telling that what happened? What happened to your MU? What happened? What happened to your, internship MUs? So, I mean, look at the proactive way our register works. I mean, we must, acknowledge his contribution.
Yes, sir.
Ariya
So
sahab,
we do
are you
acknowledge
listening?
and
Yeah.
I believe sir is there. So we do acknowledge his wholehearted support for this MOU signing. I would also extend my heartfelt thanks to our additional deans, Dr. Aditya Tomar sir and Dr. Shefali Raizada, for always being a backbone for us and always guiding us in the right path. This conference would not have been possible without the support of the participants. I extend a heartfelt gratitude to all the participants. And I also extend gratitude to all the faculty colleagues and the IT team who has supported us in this endeavor. Thank you so much and have a great day.
And you must mention our three partners, profusely acknowledging their presence in this platform.
Sir, here I want to add on one quick thing. I don't know what is the target we've kept in the universities. However, I already have a suggestion here. We should also open online internship. I've really seen my student section. I work with Pan India student section across the globe as well. And they've been really struggling on internships. So students from outside Delhi, at times it's very difficult for them to come and stay here. They cannot bear the expenses and other things. Also, the best of the law firms are here. So we can, if possible, I mean, I don't want to enter your area of work. However, when it comes to my student sections, I really want, to have some time for, like, I don't know if you're already offering online internship even after the things open up. So if we can look at that area as well, I'm sure students across India will benefit. So, otherwise, Delhi NCR students have lots of opportunities all the time.
Thank you, Meenakshi ji. Don't say that I am entering into area. It is now your. It is not
yes, definitely.
It is all
then
we.
I'm really insisting on SS Rana
now we,
and
because you have become our partner.
Both. Please do. So maybe time we can limit, but they'll be really, students even from the NLUs die to come here and work because all the law firms are not in the smaller places. So why not benefit the students across the globe? When I go to the tribal areas, I'm working on certain things with the tribals. So when I go for legal awareness camps, I see the law students have very limited knowledge on the things which are very easily available everywhere. So just a short note, I just wanted to just pen it down for all of you. Thank you so much. I don't want to take so much of time. Students have been on since morning and it's a lot more struggle for the panelists.
They are also disappearing.
Yes, sir. Thank you so much.
Thank you, Meenakshi ma'am and Chairman sir. So we finally end today's session. And as we end the day one of the third annual International Conference on Comparative Law, I remember Thomas Hobbes who once said that law is but the public conscience. However, it needs to be comprehended as to live honestly and to hurt no man willfully and to render every man his due carefully, as quotes Aristotle. So with that, we formally end day one of this conference. Tomorrow, the keynote session begins in the morning sharp at 9 o'clock Indian Standard Time. And we have keynote sessions from the dignitaries from United States of America and other countries. And tomorrow would also be the valedictory session, which begins at 4 p.m. and that would be graced by honorable legal luminaries of the global legal fraternity. So all are welcome to join tomorrow's session. Thank you so much. With the permission of Honorable Chairman and Additional Director, Dr. Tomar sir, we would like to end the session.
Now I must thank Vikrant Ranaji because his lecture was in the context relevant and it was so much pertinent. I must acknowledge that. Thank you, sir.
Thank you so much, sir.
Thank you, Chairman, sir. Thank you, Rashad, sir.
Shall I close the session?
Yeah.
And thank you.
Yes,
thank you, everyone.
Thank you,
bye,
sir.
everybody. Goodbye.
Thank
and
you.
God bless. On
Thank you,
behalf of
sir.
Honorable Founder President,
Thank
Dr.
you.
Ashok Teja.
Bye,
Goodbye,
bye.
everybody. Take care.